point, contract issued after tender, contract cancelled on the ground that first page of a document uploaded in the tender didn't have my signature. I had signatures in all other pages.
Okay.
And hard copy also given. I'll show only one clause, one page, nothing else.
So tender is issued, then what remains?
Contract is issued.
So what remains?
Exactly. I have given the contract. I have started the work. Then says no, your contract is cancelled because one of
Cancelled.
Yes, terminated the contract on the ground. One page did not have a signature while uploading the tender. Tender finalized, contract awarded. So I'll only show one page, one clause, nothing else. But
Which department?
DVC. But kindly, the urgency is they will retender. But kindly ignores the urgency ground. It is drafted by somebody else. Kindly ignores that. I'm mentioning upon notice.
25 को दे। आज क्या तारीख है? 20 है ना? 24th. 24th.
The application for correction in the order.
Whatever the mentioning list, give the mentioning list with assigning the reason. I will see to that. If I will go
for
here,
correction in the order.
I will hear all the advocates. Then I think it will the total evening. It will be mentioning whatever the mentioning. Give the reasoning to my court officer. I will see to it.
Correction. I have annexed the order also.
Correct. You mentioned that.
But non-prosecution, my lord.
May I?
Whatever. Give.
Non-prosecution.
Non-prosecution. It is listed in the list. Not. If the non-prosecution is there, it is in the list.
No.
So you give the list. You give whatever the mentioning list. Only I will take the unlisted motion. If there is any unlisted motion, I will not
Mentioning for withdrawal.
I will take. I will not hear any mentioning. Give the mentioning list with the reason. I will consider that.
Your Lordship, non-prosecution.
Dada,
You give all this. But I am telling none of the SIR matter will be listed because already there are several matters. None of the SIR matter will be entertained.
भाई আমাকে একটু বলতে দে
The petitioner
Can we convert for the SIR?
and BSc nursing honors, but due to his deletion from the name, he is not being issued.
You mention that.
I have
Okay.
handed-
Mention. Okay.
Counseling is going to start from the next week, my lord.
Okay.
Kindly.
Give mentioning. I will not hear. Give the mentioning list. Giving the mentioning the urgency. I will take that.
Lordship, may
my lord one thing
Lordship,
my lord
one
kindly,
matter.
I may be permitted my lord I being a
Lordship, may I be permitted?
old man my lord I may be permitted my lord
Lordship, this.
So you are not able to write.
yes that I can.
Write it and give it.
No this matter was two
I'm
times
being
heard
dragged
by
into
your
insolvency,
lordship my lord. This is item number 200 of the combined list. Kindly consider my lord I am a kidney patient my lord, so let it be considered my lord and let it be listed in the supplementary list.
Give.
এটা দিয়ে দিন তো
Give now, whatever you give, whatever the cancer patient, kidney patient, whoever the patient, kindly give all these things.
Patient, my lord, the election is going to be held on, my lord, 28th of August, my lord.
Give.
My lord, it is, my lord,
Give the mentioning list. I will not
election is going to be held on 28th in derivation of all the applicable rules in, my lord, rifle
give
factor.
the mentioning list.
My lord, as well,
Lordship, may I be permitted to mention?
I will take the lieu
And
matter.
this
Yes, what is the lieu matter?
My lord, may I be permitted to mention one matter, my lord?
No. Only I will take the lieu matter. Yes.
The urgency is that, my lord, we have purchased a flat, my lord. There, my lord, the non-demarcation of parking, poor water supply, like several issues were there. We approached the data. Complaint referred in the data, my lord, has taken on 14/11/2024. Since the last 2 years, there is no progress with regard to the complaint we have referred, my lord. There are several petitioners.
So 2024, not to what is the urgency in 26 August?
I tell you, Lord, in the meantime, my lord, we have approached several times, my lord, to commence the hearing upon notice. We have mentioned the matter over there, but the authorities over there are not paying any heed to that effect. My lord, several petitioners are there.
So what is your urgency?
That's what poor water supply lines, and my lord, non-demarcation of parking, and my lord, several issues connected there.
No, nothing.
lordship release lordship
You file it, then we'll see.
lordship for release
Come before
lordship for release
at the time of rising, you mention it. At the time of rising, you mention if it is not taken.
lordship for release
Which matter? Item number?
item number
Item number?
Unlisted. Two matters not be listed. One is listed.
My lord, under compelling circumstances.
Yes, call the
I'm
list.
mentioning, my lord.
My lord,
My lord.
my lord, item 56.
May I address your lordship virtually, my lord?
My lord, may kindly consider.
For the petitioner.
My lord, I am for the respondent.
Who is for the petitioner?
May I be allowed to
Lord, I am
mention
for
one
the-
matter, your lordship?
Writ petition is dismissed.
Bank fees, your lordship.
Writ petition is dismissed.
Obliged, my lord.
Lord, may I get back my book, my lord?
Oh, book दे देना शाम को. You take the book from uni. Yes.
Lordship, I appear on behalf of the petitioner, Lordship. The matter was mentioned on Monday, Lordship, and this court has been pleased to dismiss the matter as withdrawn, Lordship. This is the order of the court, Lordship.
Yes.
The matter was mentioned on Monday, Lordship. Thereafter, this court has been pleased to dismiss it as withdrawn.
By which order?
Yes, Lordship. I just
ये order
read it
क्यों
over.
फाइल में क्यों नहीं डलता? अभी वो भी हम भी डालेगा. So why to be mentioned? To be mentioned में क्यों आया? एक मिनट.
Mention for
17th August, the court has dismissed. You have
Yes, Lordship.
withdrawn.
Yes,
And 20th on 17th August, you mentioned the matter also.
Lordship. Yes, Lordship. I mentioned
Then-
the matter and then the
Both way you are taking the chance.
Lordship, I mentioned and you had passed the order, Lordship. Much obliged. Thank you.
हटा दो लिस्ट हटा दो. उसको डिस्पोज ऑफ में लेके जाओ. वो डिस्पोज ऑफ है वो. नेक्स्ट 3.
I'm for the performance respondent, Lordship. I'm for the performance respondent.
My 3 minute. Interim order is expiring today, my lord.
You are for the petition.
I am for the petitioner.
Actually,
It was supposed to file a report.
হ্যাঁ রিপোর্ট এসে গেছে
Copy দেবেন।
মাঠটাই দিয়ে দেবো আপনি একটু জয়েন্টলি শেয়ার করুন এই তোমাদের কাছে
Yes.
কপি আছে
Who is for the respondents?
My lord.
Have you filed the report?
Yes, your lordship. My lord, in compliance with the solemn direction dated 7th January 2026, my lord, this is my report, my lord. I beg
Let me
to
file an
submit.
exception to the report, my lord.
My lord, my lord, I submit very concisely and briefly. My
No.
lord,
He wanted to file reply.
my lord, you exchange, thereafter I will give you the report. দুটো কপি আছে I'm giving you, you exchange, you see.
What exchange? I want
No,
to
no,
file
you,
an
you,
exception. What
you want to,
happened?
you want to file an exception.
Yes.
Achha, my lord, only one prayer is this, my lord. They took some time saying that whatever the shortcomings and discrepancies are there, we will fix in the meantime. My lord, they fix it and they communicate us. We will again inspect the matter. And if permission is necessary, we will grant them permission.
No, but
Very simple issue.
Kindly, then I have to say about the writ petition. Writ petition is regarding a fire bank license. And these all are relating to the building license. There is nothing relating to the fire bank. Because his senior had shared a copy of this over WhatsApp yesterday. Junior nahi tomorrow, sorry. The junior supplied a copy over WhatsApp.
Yes.
Because all these are all related to.
My lord, may I submit the thing? very
Let them give a
concisely?
copy. I will file a report.
Give the copy.
I will
Kindly fix a date. Your lordship may kindly fix a date for hearing, your lordship. They are delaying this matter. There are flagrant violations of fire safety.
No violation.
So this is 6 February 2026 report. You are filing August.
Yes.
Who is delaying? See the report.
He appears for the private respondent.
Maybe. So 6th August, you are telling that they are delaying. 6 February 2026 and this court has taken the matter
Right.
7 January 1st.
No, on earlier occasion, thrice
Thereafter
time was taken.
27th February.
Absolutely, your lordship.
7th February. Then thereafter on 3rd July, 21st July, this report has not come. Now today the report is coming on record. Yes, but how soon you will file reply? Exception?
No, why I am telling you, within 2 weeks I will complete every work. I will file a comprehensive report saying that I have completed every work.
Then what is the necessity
No.
to file an
So
exception?
I am disposing of.
No, but kindly do not
Yes,
dispose
they-
kindly do not dispose of it.
That is
I want to
mere
bring this
pending-
into
What interim order are you enjoying? What interim
My
order
lord,
you are
I
enjoying?
scrutinize the entire.
Not to?
Let I
To take any positive steps.
no, my lord, I scrutinized. Why? Where is that?
This is the
All
order.
the concerned persons, including the private response, shall remain present at the time of
No,
inspection for granting the fire.
3-7 order, my lord.
Huh?
3-7.
3-7. Yes.
Paragraph 4.
Mean respondent authority restrained from taking any coercive action against the petitioner till the next date of hearing. But Mr. See, this is the report submitted by you on signed by you on 10th of February
Yes, your
or
lord.
6th of February, whatever it
Yes,
may be. Correct. But you have a 3rd July order. 3rd July, on 27th February, Land Council for the State prays for time for report. The Land Council for the Petition submit that the officer in charge, Guardian Fire Station, has issued the notice on 1st July 2020. What had happened thereafter?
My lord, actually, my lord, on
He
earlier
again
office-
went on 18th.
So
This
there,
month.
so 1st July 2026. So then how this report will
no, my lord,
serve the purpose?
my lord, this is in compliance with the solemn direction passed by your lordship dated 7th January 2020.
Correct.
Comprehensive report.
No, subsequently there are again there is an order. There is an order.
But I found my lord through website, my lord, on several occasions the earlier state advocates
Correct,
took
correct,
some
but-
time for
But
filing
if
the
the
report.
inspection is carried out on 27th of February, the 1st of July, so what has happened after that?
Perhaps, my lord, that the divisional fire officer, South Kolkata division, he did not carry out the inspection.
Officer in charge, Garia fire station.
uh,
So what has happened after the
I have to
inspection?
take instruction. What was the outcome of that inspection?
The respondent authorities have filed, the divisional fire officer has filed report after serving the copy to London Council for the petitioner. Council for the petitioner prays for 3 weeks time to take exception and to compliance if any, and to take appropriate steps to
Nine eight 30 633 854.
to meet the premises complete all the shortcoming in the premises. Full stop. Accordingly, let the report become be kept in the record. Full stop. The petition is directed to file exception to the report within 2 weeks after serving copy and counsel for the respondents. Let the matter appear on 10th September.
Kindly extend the
Interim order is extended till 12th of September. Till 14th September or until further order, whichever is earlier. Next.
Obliged, my lord.
Most obliged, your lordship.
Hmm?
Your Lordship,
Yes.
I'm for the petitioner, your lordship. We have received information that another writ is pending before this honorable court on the self same ground. Therefore, we proceed to non-prosecution, your lordship.
Another writ application is pending.
We have received information on
Who
the self
received?
same ground. My client has given me information that another writ on the self same ground is pending. So
What is the writ number? What is the case number?
that we don't know, your
So
lordship.
both will be tagged together. Land counsel for the petitioner. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Where is the instruction? Because the petitioner is in jail. Where is the instruction?
Your lordship, written instruction is required.
So the petitioner is in custody. How this court can allow?
Another writ petition is pending, your lordship.
So either give the number
Kindly,
and how you see the band.
I apologize, your lordship.
Yes. Where is the other writ petition? I will see. Or you come with the written instruction because the petition is in custody. I will not allow you. Unless and until the written instructions.
I will come with the written instruction, Your Lordship.
Though the matter is listed as to be mentioned in the period made by the counsel for the petitioner, but the learned counsel for the petitioner prays for time to bring written instruction from the petitioner for withdrawal of the present application. According case is adjourned. Next.
My lord, I am for the respondent bank, my lord.
Yes.
My lord, it has come in the instance of the petitioner. my lord.
Yes.
Lord, yes.
Who is for the petitioner? Not today. Not today. Next.
Since, my lord, I am for the petitioner, the interim order expires, my lord, today, 21st of July 26. It was extended, my lord, by your lordship for a limited period further. Twice directions for affidavits have been given, twice they have expired.
Yes.
Lordship, I'm for the respondent. There's an injunction on selling the subject property, which is why we have preferred an appeal. It is running on the list and will be taken up any day now.
So what is your submission?
The interim order be extended for a short while. In case we are unlucky in the appeal, in 3-4 days we'll file and we'll ensure that for us, it will not be delayed.
In opposition in the
No, then they will
then
they will say we've accepted the order.
We will not take that point. We'll fight you on merits. Don't.
No.
Twice we are initially direction given. Then
the appeal is already there. It's item 12 in today's list.
The learned counsel for the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for extension of interim order. And counsel for the petition submitted, the respondents have not filed affidavit in opposition. The counsel appearing for the respondents submitted the petitioner and the respondents have preferred an appeal being agreed with and dissatisfied with the order dated 23rd of June 2026 and it is pending before the appellate court. In view of the above, the interim order is extended till 24th of September 2026 or until further order, whichever is earlier.
Great.
Next.
On behalf of the petitioner, Your Lordship, the correction is that in the order sheet, it is written that the passport of the petitioner has expired. But
yes,
Your Lordship, in the order sheet, it is written that the passport of the petitioner is expired, but the visa of the petitioner has expired, Your Lordship.
I could not understand what is you
Your
are
Lordship,
telling.
in the order sheet, it is written that the passport of the petitioner has expired, but the visa of the petitioner has expired, actually. That is the correction.
There is one more correction.
Yes.
The second paragraph, Your Lordship, it is written that the passport has expired in the month of September, but it would be the visa of the petitioner expired in the month of July.
No, you submitted that the petition is working in Saudi Arabia and his passport is going to be expired in the month of September 2026.
But in the item number 148, the same was copied. I prayed for the visa, but the same order is copied here. Because this was a similar matter as per item number 1.
One more.
What correction?
One more correction is I'll just remember the advocate for appearing for the state. It's came up in Dipendra Pratap Singh. It should be Shobita Roy and Arani Das. And it's inadvertent that has been mistaken.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for correction in the order dated 7th of August 2026. Counsel for the petitioner submit that in the order dated 7th of August 2026 is paragraph 2, line number 2. It is recorded that the passport instead of it should be as a visa, and in the month of instead of in the month of and in third line of the said paragraph, the month is to be read as July instead of September. In view of the above, in paragraph 2 of the order dated in paragraph 2, line number 2 and 3 of order dated 7th August 2026, in line number 2, the word passport shall be replaced the word visa, and in line number 3, word September, the month September be replaced as month July. This order be read along with the order dated 7th August 2026. Learned counsel for the state submit that in the order dated 7th August 2026, the name of the learned advocate appearing for the State is wrongly recorded as Nirpendra Pratap Singh instead of
Aroni Das, Shobita Das, Shobita Roy and Aroni Das.
in the order dated 7th August 2026. The name of the advocate for state be read as instead of Nipendra Pratap Singh. This order be treated, be read along with the order dated 7th August. Yes.
No, my lord, the short point is, my lord, whether the SGO has the authority to cancel the ST certificate which was issued 20 years back. Now, my lord is well aware that law laid down by the Supreme Court, the person there to statute was amended. Kindly, my lord, takes up, my lord, section
Yes.
Can you come to the section 8? The state government may by order constitute a vigilance cell for such each district. And vigilance cells is there. And kindly come to 9.
You are referring section 8?
I am referring section 8, 9(1) and 9(2). Following Madhuri Patil's judgment, my lord, the amendment was made, the screening committee was constituted. Section 8A, the state government may by order constitute a committee to be called to the state scrutiny committee. This committee has been constituted. The duty of the person, my lord, who has any doubt about the certificate, not to refer the matter to the scrutiny committee. Kindly come to section 9.
If the certificate issuing authority satisfies the certificate has been obtained by the person furnishing a false information or yes.
2. Notwithstanding anything, subsection 1, if the committee is satisfied that a certificate issued under this act has been obtained by any person by furnishing any false information or by misrepresentation, any fact or by suppressing any material information, so and so, so as the committee will be the scrutiny and do it. Here, unfortunately, in our case, the SDO himself has recalled the certificate which was issued 20 years back by the certificate issuing authority. The order sheet I have annexed.
It's 75.
Kindly come to the relevant portion at page 82. That he should have referred the matter to the screening committee. Well, that's the only point I am now urging before your lordship. Your question of law.
How many petitions sold?
Yes, 7. It's of same family. They're all well placed. Some is a doctor, some is a lecturer in the college and others.
7 petitioners?
7.
Of same family or other?
Same family. Kindly come to page 82, paragraph 2, 7 siblings.
Parental lineage of the family is rooted exclusively in the Desabadiya committee which recognizes other. Yes.
Lord. Principle of natural justice has been followed, my lord, by the respondent. Principle of natural justice has been followed by the respondent.
But have you follow the act?
Yes, Lord.
Where is the committee?
Lord, may I, Lord, give the rules? Lord, as per the rules. Lord, as per the rules, notice that we issued.
No, I am not
because so-called.
Correct. You issued, but how the subdivisional officer sole can reject cancel? If he made an inquiry, then it has to be sent to the committee. Then the committee will consider it and pass or not. The act says, the law says. How your subdivisional officer so more to act as a adjudicating authority?
It is not considered by the committee itself. Yeah. Kindly, yes. Kindly, my lord.
Kindly come to section. Read section 8A. Read section 8A and 9.
No, that is, Lord, they may place the order, Lord.
If you say the committee, then I have to see whether it has been done by the committee. Where is the committee recommendation?
नहीं कमिट करेनी इंस्ट्रक्शन नाउ ठीक है तो सब एसडीओ
The cancellation has to be done by the issuing authority.
Correct.
The issuing
But
authority.
where is the inquiry committee and the committee's recommendation? Committee might have, the issuing authority might be the subdivision, but there will be a recommendation from the committee.
Screening committee. I think that probably he is not properly instructed.
No. Yes, today, my lord, it is brief is received. Can you take up tomorrow, my lord?
About tomorrow. Like very short affidavit.
No.
Every
No
day
affidavit. Can be disposed of, lord, upon.
Then let it done here and now.
No. Can you take up tomorrow or day after tomorrow, my lord? Let me take the instructions.
After tomorrow you'll come, then I will.
No, on Monday, my lord.
See,
I followed my lord.
If they are not complied with the provision and the Supreme Court, your High Court judgments are there. Division bench judgment, Justice Bakshi's judgment is also there.
Following the Supreme Court.
Following the Supreme Court.
Can you give 1 day accommodation, my lord?
Come tomorrow? Which area?
Give it Monday, my lord.
Monday? Come on Monday. And counsel for the respondents praised for time to take instruction. According cases adjourned, let the matter appear on 24th August under the same heading within 5 matters.
My lord. I'm grateful to lord.
Deep your play.
Next.
Please, my lord.
Lord, this was that account freezing matter, my lord.
Yes.
If you may just request your lordship to come to page 114, my lord.
The bank.
My lord, the HDFC bank, my lord, now they are appearing today, my lord. See, my lord, my account was frozen, my lord. My debit card was blocked by them, and I just show, my lord, 2 documents before my learned friend starts. My lord, kindly see page 114.
114,
my lord. Annexure P15.
Has been blocked.
I'm obliged.
Under due diligence.
And also the credit card, the third one, the second one and third one, you also will have the HDFC credit card such and such, due on such and such, then the third blocked. This happened on 10th of August 2026 when Supreme Court has granted me permission to travel abroad for medical reason. The same day.
So first is the account.
I'm obliged, my lord.
And second is the HDFC bank credit.
Credit card, my lord.
And second is 2 credit card. There are 2 credit cards.
2 credit cards, my lord. 2 credit cards, my lord. Which is why, my lord, 2 SMSs.
Yes.
Then, my lord, one more page, my lord, kindly comes to 116. Towards the bottom. So this was the intimation, my lord. We have received, my lord, towards the bottom, your lordship will see the HDFC bank, dear customer. My lord has got it, my lord. I'm obliged, my lord. In line with our central monitoring procedure, we have initiated additional due diligence for your account, which has resulted in a temporary suspension. We kindly request you to visit our nearest HDFC bank with your original KYC documents to facilitate the necessary action. Your prompt action in this matter is greatly appreciated, such and such. My lord, we wrote them back just the previous page, my lord, 115, that under which provision you do this. My lord, I'm sorry, my lord. Page 115.
Yes.
That how do you do this? Because I have been using this account, my lord, since 2017. There is no question ever, my lord. And my due diligence, my lord, my KYC is due in December 2026.
Yes.
Well, one more page, 117. See, my lord, their reply. That we have registered your case and you get reply by 1st of September 2026. Yes. Well, the matter was taken up by your lordship when bank took time yesterday. Then, my lord, just give me this document. This was mail. This mail we have received yesterday, my lord, at 1:40 p.m.
Yes.
Now, my lord, my QIC is due in December 2016. They want to do some additional check, my lord, they are most welcome. But my point before your lordship is that how do you block it without notifying me?
Your bank is not on the eKYC and all these things.
No, my lord. My lord.
And your bank is very keen to see the persons to come in person with
No,
the
my lord,
bank officer.
My lord, first.
And a photograph will suffice. I will tell the person
lord,
send me
we
the
have
photograph.
My lord, we have already indicated that.
Now, I am asking you.
Yes.
If your bank is interested to see the face of the client, then I will tell. If you have kind one, the photograph will suffice, because nowadays even the government officials are doing all the things by the online. So,
my lord, my first submission.
as per your letter, it finds that you are very much interested to see the face of the person.
My lord, it has been blocked by the central team, my lord. That we have already indicated, my lord. My lord, now the difficulty is on
the language of the letter. You have
lord,
seen?
this is an apologetical language, my lord. What I am submitting, my lord. My lord, first of all, this is whether the repetition.
This is the way the bank is.
No, my lord,
doing the
this is not
business with the customers.
No, my lord, but the issue is that, my lord, what I have been instructed in, particularly in this case, my lord, particularly this petitioner's phone
Tell
number.
me when you resolve this. That's all. I don't want. What are the documents you want?
Kindly
Just a minute. Whatever the document you want, immediately within 15 days, inform, take the bank. We will give to you and come tomorrow.
15 minutes.
No.
Whatever the document, please inform to the learned advocate. Then he will
My
submit
lord,
that.
kindly consider one aspect, my lord. My lord, first of
KYC is only the document.
Yes, my lord.
That's all.
My lord, we are already on the process of resolving the issue.
That's why I am telling you might be process.
My lord,
It is the
whether the limit
KYC.
is at
I
all maintainable,
totally agree with your bank. Tell your manager I am fixing at 12 noon or 1 p.m. Tell your manager what are the documents. Please give to you, not to the and you communicate him. He will give all the documents.
Absolutely.
Matters all.
My lord, kindly consider one aspect, my lord. I was instructed not to disclose, my lord, but for your lordship's consumption, my lord, may I hand over, my lord. This is a third party information, my lord. My lord, we cannot. This is bank internal procedural procedure. My lord, only the issue is that whether the REIT is at all maintainable in respect of a HDFC bank. My lord, that question is also required to be answered, my lord. My lord, the first of all, my lord, my lord, this information I cannot disclose, my lord. Your lordship, kindly
Please,
consider.
this information.
This is an
relates to
internal.
me.
My lord, yes, definitely, my lord. My lord, the issue is that. My lord, particularly for this petitioner's name and mobile number and PAN is linked with the other cases which are already been initiated by the ED authorities. So, my lord, it's a system verification. It got blocked, my lord. So, my lord,
But that is not the case you made out.
Exactly, my lord. That is
a new case.
That is not the case you made out by two communications.
My lord, that is what. My lord,
If you could have been taken the very first day. This is the reason.
My lord,
then the matter would have been different.
That is why, my lord, we need an additional KYC, my lord. That is, my lord, I am answering
Madam,
question, my lord.
please understand. If you come to me,
yes, my
sir,
lord,
this is this. And I will tell madam, yes, it cannot be done. You do this. Correct? This is the first. Then you went. Subsequently, you went the other. Can I change my stand? No. This is not that. This is the thing. Tell me. If you say yes, you can change the stand, then
My lord, we
the court
have
is nothing.
changed, my lord. Kindly consider, my lord, the very.
Because what you are relying upon, which
Yes.
is your secret document, that is totally complete to the communication with
Well,
made
that
with the
communication
petitioner.
we are yet to confirm and yet to receive, my lord.
If we are not sure, how could they block my account?
Without the confirmation,
My lord,
how
that
you
is
block the
system block,
account?
my lord. My lord, that is why we were requiring an additional KYC, my lord. That is one humble.
That's why additional KYC. You tell
My
your
lord.
bank what are the
My
documents
lord,
required, he will provide.
we are also in a process of, my lord, we can assign a person or an officer to visit the petitioner's place and do the KYC treatment. My lord, that can
Not
also
required. Your service is not required. You what are the document you take through online from the bank and you communicate to the petitioner, and the petitioner will submit the document to you.
My lord, in respect of certain KYC, my lord, what I have been told, my lord, of photograph is also be required to be system is to be taken, my lord. That is why a person has to either has to meet the petitioner or the petitioner.
Where is
My
that?
lord, that is not indicated in the email, my lord. My lord, then my lord, I will come back.
Tell your bank manager to appear in person.
My lord, kindly consider, my lord.
Tell your manager to appear in person. I will take his photo first.
No, my lord, I will indicate, my lord, what are the documents required, my lord.
You cannot change the stand, madam.
I'm not changing, my lord. Kindly consider, my lord. Kindly consider, my lord. My lord,
First of all, you have taken yesterday the time.
Yes,
and now you have changed the all stand.
My lord, my lord, the only thing is that, my lord, we are also trying to facilitate.
Please remember, I will not grant any time to you in any matter.
My lord, kindly
Whether you will
consider.
submit the report or not. If like this, you will continue to changing
any
your
stand, my
stand.
lord. Kindly, my lord, that KYC was required, my lord. That was indicated in the very first
That
day, my
I'm
lord.
telling KYC. What is the KYC, madam?
My lord,
What is the KYC?
my lord,
Tell me. What is the KYC?
identification documents, PAN card, and
What are
other
the
documents.
KYC?
Yes, my lord. My lord, I will indicate, my lord.
What are the documents? KYC document. What are the KYC
My lord,
documents?
particularly in this case, my lord, what are the KYC required, my lord? I will come back. Within 12, my lord, I am coming back with the details, my lord. What are the KYC for particular?
1
Yes,
PM.
Most obliged.
Number 10.
But till today, we have not been served a copy of any. Thrice, state has been served thrice.
Yes, who is appearing for the state?
My lord, I shall represent because I've yet not received a copy, but I shall take instead.
Thrice we have served to the state, Your Lordship.
Kindly come to the order dated 22nd July.
Well, I've yet not received a copy. I shall.
Sir, you persons are not the poster before this court.
Well, actually, a copy due to maybe.
All state advocates are appearing before as a poster. Only one submission, not a copy. Kindly see the who is the Partha Chakravarti.
He appeared. We served the state thrice.
Who is the Partha Chakravarti? He had appeared. Who is the Tapas Kumar Dey? He had appeared for the state.
I'm sorry, my.
You made this court as a playground.
I'm sorry, they should appear, my. I'm sorry, man. I'm sitting here.
Who should appear?
My lord.
The court will go and trace it out the advocates.
No, but I shall go there. Man. I shall go there. After the case, man, I shall go. I shall go to GP Landed.
None appears on behalf of the state. Let the matter appear. on Tuesday under the same heading.
My lord, may
It is made clear that on the date fixed, if none appears on behalf of the state, the matter will be taken up for hearing in the absence of the state.
retain the same position, my lord. Deferred.
Under 10 matters. Yes.
10.
My lord. In all three matters, my lord, I appear on behalf of the petitioner.
Yes.
Just take your lordship, my lord. My lord, in 2017, SEBI issued a notice to all the stock exchanges saying that, my lord, there is a list of suspected shell companies. 331 suspected shell companies. So, my lord, all the exchanges are requested, my lord, to verify the details and particulars of the company and undertake the process of an audit and examine their books of accounts, and thereafter, my lord, come to a conclusion whether they are involved in suspected shell company activities or not. My lord, out of the 331, 85 came within the zone of Calcutta Stock Exchange, because the companies which are listed only with Calcutta Stock Exchange and not with BSE and NSE, Calcutta Stock Exchange. So, my lord, the petitioner company was listed with Calcutta Stock Exchange. So, Calcutta Stock Exchange was directed. Calcutta Stock Exchange put me on notice that give all furnished documents. We gave all documents. COVID came thereafter 21, all documents done. Then based on the documents and the SEBI requirements, my lord, a forensic auditor was appointed. So a forensic auditor audited the books of accounts, and thereafter, my lord, now kindly come to page 160. My lord, after examining the forensic audit report, this is the mail, my lord. Kindly have a look at the mail.
For removal of the name of your company from the suspected. So you are moved before the MCA?
No, my lord. Now we go to MCA based on this, that I have been cleared. Kindly, because your name is then the suspected shell company, I cannot do anything practically. Now MCA is sitting over this request of mine and has been doing nothing. So this is the short compass of the matter, my lord. In long and short, my lord, this is what it is. Now MCA has to take decision and remove me from the list of suspected shell company. Now, my lord, on the last occasion, my lord, SEBI said that stock exchange, somebody had appeared on behalf of the stock exchange.
My lord,
The Ministry of Corporate Affairs, I stand corrected.
MCA, who is appearing for MCA?
I'm appearing
Not
for
from SEBI, from Ministry of Corporate
Who
Affairs.
is appearing for MCA? You are appearing?
For in 12 and 13, my lord.
MCA.
MC.
Yes, what is your instruction?
One of the instruction is, my lord, it was my lord's observation to
File a report.
my lord. My lord, we have received, my lord, may I hand it up to lordship? Lordship, may kindly take page 6 of it.
Page
6 of the report.
Actual report down.
Yes.
We have received, my lord, the correspondent 1 and 2, my lord, received a notice, my lord, from the SFIO, which is the inception of this proceeding, my lord. I would like to refer to the meeting held on so and so at conference of secretary. The list of 331, paragraph 2, my lord. Listed shell companies provided to file database of listed shell companies. That is the file name in the enclosed CD. The attention is drawn to column number 8. That is the source of the data. The description of the source is as below. Then, my lord, the descriptions have been given of the defaults made by these companies. Of the defaults made, by the number of companies 124, the description list contains the companies which were received from the income tax department.
Correct.
Now, my lord, that is the list is annexed. And then, my lord,
who has prepared this list?
My lord, the SFIO has forwarded this.
Who has prepared this list?
My lord, the list has been, SFIO is part of
SFIO. Then
special fraud. And now thereafter, my lord, this has been forwarded
Where is the name of the petitioner?
The petitioner's name
In this list?
is
This is the original 331 list.
331 list, my lord.
So thereafter, what has happened?
Thereafter, my lord, it has been forwarded to, the minister has forwarded to the SEBI, my lord.
Correct.
SEBI has forwarded to take appropriate action. My lord, the ministry has also taken initiated the actions as mandated under the law, my lord. My lord, may kindly take, my lord, volume 2, my lord.
Volume 2.
In 23, my lord, the adjudication order has been passed.
Page,
my lord, 219.
Yes.
Followed by, my lord, the order in appeal, which is, my lord, is at page 226.
Yes.
No.
It is also to be mentioned.
Volume 2
As a lordship got it. As a lordship got it. Now, it has also been followed by a notice issued by the Reserve Bank of India on the issue, which is at, my lord, page 255. 255A, my lord, it is mentioned as.
My learned friend is referring to the second writ petition, not the first.
Yes, secondary they may appeal.
255 page, peep 18.
The date is March 12, 2000.
No, that is the Ministry of Corporate Affairs website.
No, my lord, it is Reserve Bank of India.
Which writ petition you are referring?
My lord, I am
WP
referring to,
number?
item number 12, my lord.
Well, I addressed your lordship in item number 11 right now.
Yes. The issues are similar in. I'm not appearing in 11, my lord. I've been instructed to appear in 12 and 13. My learned friend, senior friend is appearing in 9.
Who is appearing for 11? MCA. MCA.
1 and 2. Yes.
Yes, first address 11. Because I have some on. Who is appearing in 11? Yes, what is your instruction?
একটা রিপোর্টের কপি দেবে নিয়ে নাও জজ দেখছে বলে নিয়ে নাও
नहीं ये क्या हुआ?
I think he gave your lordship the wrong report. He wants your lordship to take the one handed over subsequently. এটা আমার দিয়ে exit.
Yes, what is the instruction?
Point number 4.
Point number?
সেই 2017 তে আশেপাশে আছে লাস্ট পেজ 2017
The statement and constitutional made in paragraph 5, 6 and 7. They submitted that the petitioner number 1 was carrying on business of NBFC activities and registered as a non-deposit accepting non-banking financial company dealing with shares, stocks and debentures, and to invest and deal with monies of the company in which certain irregularities under Companies Act 2013 have been found. The shares of the company are listed with Calcutta Stock Exchange. The office of the Director General of Corporate Affairs, Ministry of Corporate Affairs, has received a communication, letter number SCDP, dated 23rd May 2017, from the office of the Serious Fraud Investigation Office, SFIU, forwarding list of the 331 listed cell companies marked as Annexer 1, Annexer A. On receipt of the said list of 331 cell company, DGCA, Ministry of Corporate Affairs, MCA, letter number dated 9 June 2017, has forwarded the said list of 331 cell company to the Exchange Board of India, Mumbai, for initiating necessary action and there, and as per heavy laws and regulations marked as Annexer B. with reference to the point number 5. With reference to the statement and or contention made in paragraph 8, 9, and 10 of the said petition, it is submitted that the petitioners has contended that the company was listed in Calcutta Stock Exchange and its engagement in business operation is relates to the matter of records. With reference to the statement and or contention made in the paragraph 11 of the said petition, these are matters of record. The said paragraph relates to the annual financial statement of the company as per MCA database. The company has filed its annual return and balance sheet for the financial year 2024 and 2025.
Then
paragraph 7. With reference to the
sir, after this recommendation, what has happened? What has happened to the forensic report?
Oh, जाने नहीं। May I just, I'll tell your lordship, it's a complete non-application of mine. I'll tell your lordship, if your lordship will see my paragraph 22 and 20, he has dealt with my affidavit of my writ petition. Para 22 and 23 of my writ petition, at page, the bottom of page 7, I deal with the forensic audit and the recommendation made by the Calcutta Stock Exchange for removal of my name. So I make specifically, I disclose the document and make the pleading at para 22, 23. Now your lordship will kindly see the report which has been filed before your lordship by the MCA, how they deal with para 22 and 23 at their paragraph 9.
Point number 9, with reference to the statement.
So there is an unequivocal admission of this fact.
Contention made in paragraph 23 and 22 and 23 of the said petition.
No need to offer any comment. So if you say that, then para 22 and 23, the recommendation which has been made at page 160, based on the forensic report, has resolved that request to approach the MCA because there is no adverse finding in the forensic audit report. That's all that I'm asking for.
The personal hearing allegedly conducted by respondent number 4. The correspondence exchanged between respondent
Come to page 160 of your of the writ petition. 160 of the writ petition. Read.
Yes, sir. This has reference to the forensic audit conducted by Messrs. C. Ghosh and Company, chartered accountant of your above mentioned company. We would like to inform you that forensic audit report of your company has been placed before the meeting of Regulatory Oversight Committee of the Exchange held in 23rd May 2023. Please note that members of the said committee, after detailed deliberations, resolved that you would be requested to approve MCA for removal of the name of your company from the list of the suspected and sale company. Copy of the forensic audit is attached for your records.
Then what has happened? What is that? What is your submission on this? That is the paragraph 21, 22. So you are not given any comments on that.
No, here it is said that.
You have stated that no need comment offer any comments.
As it is the communication between the respondent 4 and petitioner 1,
So
there is no need to offer.
So if the forensic audit was conducted and there is no involvement of the petitioner and requested to make a request to the MCA for removal of the name as a cell company. So what remains further? That is the only question on the last occasion also. So what instruction you have taken?
There is no instruction.
No instruction.
And my lord, para 24 is my lord, directed against MCA.
Correct.
Because my request to MCA thereafter has been from page 169 onwards, 193 onwards. Kindly see
190?
193. So based on the forensic audit report and the
This is your request.
my request to
No,
whom?
where is the forensic report? Where is
My
the
lord, forensic audit report is at page 161.
161?
Now, who appoints the forensic auditor? Stock exchange based on SEBI. It is not my auditor. I can give you, Lordship, the document also by which the forensic auditor was appointed. Page 149, your Lordship will find there is a letter by which the forensic auditor was appointed in 2022. That's at page 149.
Who has appointed?
My lord, kindly see surveillance and securities appointed by Calcutta Stock Exchange. You are hereby requested to contact C. Ghosh and Company Chartered Accountants and allow them to conduct forensic audit of your body corporate, details of which are mentioned attached in the forensic audit for suspected shell companies. Further, you are requested to update status of the audit within 7 days. So this is exactly what I do. They ask for documents. I keep giving them documents. Forensic audit done. Then they, based on the audit report, no adverse finding, removed. Then I write to them since 2023.
Where is the finding in the audit report?
My lord, if your lordship will kindly take the audit report once, it starts at page 161. And my lord, if your lordship kindly takes page 181.
Yes.
The detailed observation.
Exim Finance Limited was established so and so, so and so. SEBI is widely quoted so and so, so.
And thereafter, your lordship, on shell company, the finding is at page 187. And my lord, if your lordship will say at page 188, towards the middle of page 188, there is a finding of the forensic auditors. From the above observation, it may be opined.
Yes.
181 page.
Huh?
Page number 181. There is stated that.
May I just show on page 188, if your lordship see just the middle of page 188, where from the above observation, then my lord, kindly see FG.
Yes, FGH.
Yes, FG and the last, absolutely the last sentence at the bottom. Clears everything.
Yes. This type of instruction will not do before the court. Either you come to.
My lord, may I submit the page number 181. SEBI had widely quoted in the.
Our reading.
Suggested that.
Kindly come to 188.
What's happening?
Yes, my lord.
Read from the above observation.
Conclusion and
From the, huh?
the term shell company has
Hey,
not been defined anywhere, but the shell
188.
188 দেখে দাও না মাঝখানে 188 এর মাঝখানে
from the above observation, it may be opined that
it has been included in the list of
included in the list of the suspected shell company for the above mentioned reasons. But as per submission by the company dated 20th December 2022 and documents submitted to us, we hereby report that it does not have a major public holding interest. The company B, the companies of the CSE, Calcutta Stock Exchange, and RBI has been gone through.
Read FGH.
At the end.
Serial F.
If we did not get any evidence of circulation of money for the purpose of laundering money. G, we did not get any evidence of tax evasion, money laundering, obscuring, ownership.
If I will get this type of the determination, I will be very happy.
Did not get any evidence of the company.
really don't know where we
any intention of allowed firm for favorable tax
কি বলবে
treatment.
very
and
sad very sad.
additionally facilitated
Okay, in which case you are appearing?
12. May I submit the
Well, so far as 11 is concerned, my lord, kindly direct MCA. Well, kindly direct MCA. Kindly give a representations, repeated representation made. They are all pending to dispose it of within a specified period and take a decision with reasoned order.
Yes,
that's all.
Kindly allow me for liberty for giving opposition.
Reading opposition. What is there in the opposition?
এটাই তো দিয়েছে এটাই kindly treat that as the opposition.
This is opposition.
This opposition is dealt with each paragraph of the read.
You dealt with all paragraphs. So you take a decision. He has made a representation. Correct. They have been listed as a cell company. Subsequently, matter was sent. Then the forensic report, forensic audit was held. Forensic audit, they did not find anything against them. Now they wanted to, their name should be deleted. Then the name, who will delete? MCA delete. Then you have to take a decision.
As we need a specific direction from the department.
What specific? You have given the details.
This is unexpected. You are before the High Court.
See, you have
what kind of
narrated the thing which was before the SEBI. Subsequently, forensic report, what has happened, you have no knowledge. You have not read your authority has no knowledge about the writ petition.
No, my appearing in this.
Who?
RN Bach, senior appearing in this matter. As per his instruction, kindly give us a short date so that we can came with the instruction.
In that case, I will not you. Half an hour you wasted. Now your RN bag is coming.
Now, I was not here.
He has not stated that signal. He is telling that he is appearing and he started arguing. He has argued the matter half an hour.
Extremely sorry, on behalf of him.
Pay the cost. Pay the cost.
Sorry.
MCA is having so much money.
Kindly make it pass over. I am intimating my senior.
Sure.
He is in supervision. That's what.
Pass over.
All 11.
Then all three
Yes,
kindly pass.
together I will take together. Next.
I am preparing for the petitioner.
This is my application. If your lordship remembers, my lord.
Who is appearing? Siddhartha Bhattacharya.
Here last day, my lord, I had moved an application. Lordship, just give the small time, my lord. 164 2B of the Companies Act, my lord. A notice was given by which I was discontinued by DIN, my lord, DIN.
I had showed my lord there was nothing under 164.2b. They came and said it was 164.2a, but it was showing 164.2b. Your lordship questioned them, when did you upload this? But I had shown that I had come to know in December 2025. Even after the matter was moved, they have never taken any steps to say that it was wrong. So, my lord, I had sought for quashing of that, my lord, my suspension of the dean, my lord, because I have also shown for the dean, my lord, you need to give me a notice to hear me out for cancellation. That has also not been given. So he took time to take instructions.
We have shown Your Lordship.
We have also shown two judgments. I have handed it over to him.
Your Lordship. Firstly, they refer to a judgment passed by the coordinated bench.
No, whether notice is 164.2 or 2A or 2B?
2A.
2A. How you say?
Your Lordship, it's admitted
fact
that they
page
have
73.
failed to file.
73, page 73.
Page 73, Your Lordship.
Instruction.
Page 73, my lord. Page 73 is an isolated document, Your Lordship. Isolated. The other pages are not here. I am instructed accordingly because no date is here, Your Lordship. We cannot accept this document as admissible because the date is not here, Your Lordship. The date is not here.
MCA portal. No. This is a MCA portal. Sorry.
If there is a date.
So you are denying this is not up from the
on
year
page 74, Your Lordship.
No,
kindly see the page 74.
So
that's first
page 74.
1st November to
2024.
No. This is there's different thing. 18 2006. What is 2006?
2006, no.
Yes, what is that? Your Lordship. So this is an isolated document. I'm not relying on this document.
No. You might not be relying upon the document. Then you have to give the statement before.
Your Lordship,
I'm
giving the statement.
So this is not the document of your MCA.
No, I'm not saying that, Your Lordship, because you cannot identify when it was taken out from the court. We cannot identify the date.
Okay.
That's my first point. Second point is, Your Lordship, that it's the admitted fact that consecutively, they have failed to file the annual report and the balance sheet for 3 consecutive years. That is admitted fact. And after they failed, that is in March 2024, 31st March 2024 was the financial year. So the last date was to file, that was November, 30th November 2025. Till that nothing was filed. The system is automatic. After that, they were disqualified, and the FCA, I have the.
There is a reason. Show me the reason.
Your Lordship, I have the interdepartment communication, Your Lordship. Copy. No, they didn't copy. Your Lordship, this interdepartment communication, I will give them a copy.
George accept
the change request form is on the 3rd page, Your Lordship.
Change request form
change request form যেটা মানে ডিঅ্যাক্টিভেটেড হয়ে গেল সেটা রিকোয়েস্ট করে এমসিএ কে
কোন সেকশন বলেন
160 no that's the section of our legal.
Yes, page.
That is the CRF is on the 3rd page, Your Lordship. The heading is there, CRF. Yes, Your Lordship. That's the date of the CRF. That's when the request was made to deactivate.
Then তাহলে সেই দিন যদি হয় তাহলে একদিন ধরে তো 164.2b চালাচ্ছে
চেঞ্জ করার কথা বলছি
না বলছি ওটা হচ্ছে চেঞ্জ অফ স্ট্যাটাস
What is the name of the company? Petitioner's name?
Saffron. Saffron Trading Private.
The petitioner is one of the individual. The director of several companies is one of the companies. No.
So you have not received this? CRF 17 December 2024?
No.
You the copy. You're not having the copy.
No, Your Lordship, Your Lordship, kindly give me a leave. I will just give them a copy.
Well, I can have a look and answer if your lordship wants me to, my lord.
And secondly, your lordship, their first letter, first communication is July, in 3rd July.
I don't know, my lord. My lord, even if that is the case, let me take it up from there, my lord. My lord, your lordship. Sorry, my lord.
Am I complete?
No, my lord, he wants to come. Let him come.
Yes.
Secondly, your lordship, my submission was that since it's a matter of operation of law, the question of alteram partem doesn't arise in this case. They referred to a judgment of coordinate bench of this honorable court, passed by my lord Sabyasachi Bhattacharya. কোথায় গেল? না এটা না পাতলাটা। ও আচ্ছা, kindly come. It is with your lordship's record. The judgment. Honorable Justice Sabyasachi Bhattacharya.
Yes.
Kindly come to the para 5, my lord. Para 5, paragraph 5 of that page 233.
Yes.
The disqualification of the company in question took place in the year 2014. That is prior to the 2018 amendment of the Companies Act 2013. Here the advocate said that, and as such, the provisions of the 2018 amendment would not be applicable thereto. On this basis, it was held that notice should be given. But our case is after the amendment 2018. So after the amendment, your lordship, may I once again refer to the section 167(1). One second. What happened after the amendment? At the amendment. 167.
আবার তো বের কর।
167, section 1A. The office of a director shall have become vacant in case he incurs any of the disqualification specified in section 164. Then, your lordship, it was inserted in 2018, provided that when he incurs disqualification under subsection 2 of section 164, the office of the director shall become vacant in all the companies other than the company which is a default under that subsection.
Yes.
That is all, your lordship.
Will you?
Yes.
Let me.
So I am under section 164 to
1A.
2A, your lordship.
167 1A.
No, 164 2A.
164 2A. That is the disqualifying section.
No, my lord, may I? Oh, sorry.
Yes.
My lord, may I? My lord,
that's all.
Once the other judgment that is also prior to the amendment,
which
the
judgment?
issues that raised prior to the amendment of 2000.
Which judgment?
18, that is passed in the matter of Jai Shankar Adhari 2020-222, company case 429, Allahabad.
and I'll give another copy. না দেওয়া হয়েছিল আমি দিচ্ছি আর কি। My lord.
Yes. Paragraph?
Paragraph 72 and 73, your lordship. paragraph 72 and 73 are on the basis of the issues that was raised before the amendment, Your Lordship. So they, on behalf of the petitioner, these paragraphs were referred to.
Yes.
But these are not applicable in our case, Your Lordship.
Yes.
This is my submission, Your Lordship.
Well, let me. But first things first, Malad. Today, MCA portal shows 164.2b. Malad, that might be there, whatever they had instructions given. Malad, I am not aware of that. There is also no reason why 164.2a has been changed to 164.2b. That is my first submission. That's an easier route, Malad. The next point is, Malad, I had shown before Your Lordship, and if Your Lordship once again repeat that. Malad, there is no provision. That's the first point I had taken. Under 164, for disqualification of the DIN, deactivation of the DIN, Malad, kindly takes 164. Malad. That was the point decided in this these two judgments, Malad. I'll just point that out. It is irrespective of any Malad, any amendments. Malad, kindly takes 164 once, Malad.
Yes.
Yes. No person who, Malad, I'm just reading from 2 straight on, Malad.
Yes.
No person who is or has been a director of a company which has not filed financial statements and annual returns for any continuous period of 3 financial years, or has failed to repay the deposits accepted by it. Malad, that's to be. Now, please, shall be eligible to be reappointed as a director. No disqualification or deactivation of DIN. Or appointed in another company for a period of 5 years from the date on which the said company fails to do so. So therefore, it is the appointment or reappointment. Then
no disqualification.
No, Malad, I am coming to that. Proviso.
Only in case of appointment.
Yes. Provided that where a person is appointed as a director. Now that's the proviso which has come in, Malad. Kindly see, Malad. 60, Malad, Your Lordship will find. Malad, that's the proviso he is talking about.
2018.
2018.
2018.
No, 2018.
The proviso is provided that where a person is appointed as a director of a company which is in default of clause A or B, he shall not incur the disqualification of a period of 6 months from the date of his appointment. It's not even applicable here. It's only in respect of appointment if done of a company which has already failed in A or B, then that disqualification will not apply for 6 months. That is the proviso. But there is nothing here which says that deactivation, well, deactivation has been specified in the rules. I've shown that rules to Your Lordship, Malad, kindly.
Heading to the disqualifications for appointment of
Yes,
director.
Malad, I'm corrected by my learned junior, Malad. Also the heading of 164.
It is only in case of appointment.
It is a disqualification for appointment as a director.
Correct.
We are continuing.
We are continuing. It's not a.
There is no reappointment here.
No. See,
Malad.
But 2012, December 2024, you have been disqualified.
No, that is the period they are saying, Malad.
Only this letter you have not deposited.
But with humility, I think the letter is dated in 25, has to be.
17 December 24.
Malad, whatever it is. Malad, that is neither here nor there. For my matter, I'll point out why, Malad. Yes, if they're saying it's 2024, I never came to know about it.
No, if you have been disqualified as a director in 2024, so how you can continue in 25?
Well, that is what I'm on. If they have disqualified me, well, this is not a document which disqualifies me. It's the MCA portal. Today, the MCA portal says it's 164.2b. And that is...
In view of the above, kindly disqualified to above DIN.
Yes, Malad. Disqualification of a DIN. Malad, that is what I'm on, Malad. This is not about disqualification of a DIN. This is disqualification from appointment. And there is only one provision for disqualification of a DIN. That is provided.
Rule 11.
Rule 11, Malad, kindly see Rule 11. I've shown on the last occasion, I'll show again, Malad.
Cancellation or surrender or deactivation of DIN.
Malad, this is what they are trying to do, Malad. Kindly see, Malad. I'm just handing over the book, Malad.
Yes, it is there.
Oh, it is with Malad. Malad, kindly see the company's appointment of director rules 2014.
Yes.
Now kindly see is Rule 11.
Yes.
Rule 11 only is the provision for cancellation or surrender or deactivation of a DIN.
Correct.
First, my lord, I do not fall under any of these. First. Second, my lord, even if I fall under this, my lord, I need a notice.
So if you're under Rule 11, the cancellation or surrender, the deactivation of the DIN.
That's the only way.
provision. It is the only provision. If suppose you have been disqualified under 164(2)(a), so what about the DIN? If you're not the director, then what about the?
Well, that is why I refer to the judgment, my lord. It disqualifies, my lord, it disqualifies. But the point was that can my DIN be suspended or deactivated? My lord, may I just first take your lordship kindly sees? My lord, that 2018 amendment has nothing to do with this. I've shown your lordship. Now kindly sees.
Para 16 of the
Paragraph.
Which one?
16. My lord, the single bench first, and then I'll take your lordship. The division bench isn't relied upon by the single bench. The single bench is our High Court. Therefore, my lord, I'm showing that first.
Para 16.
My lord, kindly straight away comes to para 16, the consideration.
16.
116 is on the right hand side, my lord. The paragraph number, my lord. Upon considering the arguments of both sides and the legal provisions, it is evident that in the opinion of the division bench of the Allahabad High Court as well as the learned single judge of this court, in the fourth judgment cited by the petitioner, disqualification of DIN of a director for the default of a particular company of which he is a director cannot disqualify said director from acting in the said capacity in the other companies which did not allegedly commit default. As such, in event, now sees the disqualification of the DIN of the petitioner could not operate in respect of other companies of the defaulting company.
Correct.
In the event, the DIN of a director is to be deactivated and not merely the name of the company struck out from the register of companies. So this is not the case.
No.
The company remains here.
Correct.
The said person has to be given notice individually and heard and given an opportunity to establish they are not liable for the alleged default committed by the company.
Not done.
This has not been done. So, my lord, this is the next structure which is there, my lord, whether I am responsible or not. Then kindly cease, my lord. My lord, the Allahabad bench cited the result of a similar opinion. The opportunity of hearing had to be given to the petitioners prior to the deactivation of their DINs. Even in respect of the defaulting company. My lord, cease that. Has your lordship found?
Yes, yes.
Which has not been given in the present case. Then kindly cease, my lord.
In the absence of lawyer.
Yes.
Now kindly cease, my lord. Kindly cease, my lord. 18, the last sentence onwards. Rather, my lord, I read from 18. Division bench of the Allahabad High Court went one step further by holding that the register of companies cannot deactivate the DIN only on the ground that the director has incurred disqualification under section 164(2)(a) or his office has become vacant under 167(1)(a). Since such DIN is allocated under section 154 of the 2013 Act, my lord, kindly notes this, kindly, my lord. There is no provision in the Act for the deactivation of the DIN of a director only on the ground of such disqualification under sections 162(a) or 167(1)(a).
Yes.
The action in the present case, in deactivating the DIN of the petition on the ground of such violation, in a particular cannot confer a right on the register of companies to deactivate such DIN.
Yes.
Then, in the absence of any such provision of deactivation of DIN in the 2013 Act, one has shown that there is no provision. The mere disqualification under section 164(2)(a) of a company cannot give rise to the consequence of deactivating the DIN for which there is no provision in the statute.
Yes.
There is in case of contravention, there is a punishment which is provided under section 159. However, there is no scope of.
Okay, but yeah.
Yes,
okay, I'll go by your submission and the judgment, and you're relying upon page 160, page 73. But now they have come with another document.
But this is about 164(2)(a), not 2(b).
No, that's why. But you're not challenged this. So what would the effect?
Which I have not.
This now they have given this CRF.
Internal. This is internal.
No, internal. It has been online.
Online.
No,
I don't think
internal.
so.
Internal. The communication internal. No, what is available in the MC
You're not served the copy.
I'll serve you.
You can serve it.
I'll
Okay.
Purely. And one more thing,
document, my lord.
73 is the official.
73 is the official document.
Yes.
I have not got that. But I'm not taking the point whether it is there or not. I'm not going into that. This is the official document. Now, my lord, even if I take that has been served, my lord, my whole point is my 164 without notice of hearing cannot be used for deactivating. This is what I'm saying.
May
And
I
it's
add,
not been served, my lord. I'm also saying this, my lord.
may I add single thing? The paragraph 16 of the judgment, what they relied on.
No,
Oh, acha.
Judgment.
No, Your Lordship, this is based on the prior act before the amendment. And the issue was whether all the companies.
No, all that.
That was the issue. That time amendment was not there.
Amendment was not there. Amendment is only kindly come to the proviso.
Your Lordship.
Come to that.
Your Lordship.
165 proviso, second proviso.
That time all the companies were not covered. So they were entitled to a notice.
No,
all the
see, 164 2A, B has not been amended.
No,
Change.
Your Lordship. But
kindly come, please come.
Yes, Lord.
Then proviso. Kindly come the proviso. First proviso that was changed.
Your Lordship.
That is 60, 2018. Kindly come.
Your Lordship.
Then, so 1, 2 has not changed.
No. Your
A, B is not changed.
Your Lordship.
Proviso has changed. They are not claiming under the proviso.
No, Your
Correct. Now it is with regard to the disqualification of the directors.
Disqualification
of the appointment of the disqualification appointment of directors. Okay. Now here the question is DIN. Cancellation of the DIN, deactivation of the DIN. DIN is under 11, rule 11. So what action you have taken under the DIN? For deactivation of the DIN?
No, my submission was that, Your Lordship, once a person.
So yeah, as per your submission, what the court understand, as per your submission, once the directors have been disqualified, so automatically the deactivation of the DIN.
Your Lordship. The FCI is Your Lordship.
So no necessity of
after amendment, Your Lordship.
After amendment.
Okay.
It's not there in the amendment. They have not.
Yes, no, but it is not there in the amendment. That's what I'm trying to say, my lord. We are trying to get that.
The petitioner has filed the presented application. So you will file affidavit.
Your Lordship.
Can I dispose of quashing that?
We'll file affidavit, Your Lordship.
Then stays the operation, my lord, kindly, my lord.
No, cannot be.
I would prefer, my lord, he has already made his submissions, my lord.
Because you cannot further, what you will improve?
Exactly.
Your Lordship may kindly pass the order, Your Lordship.
Grateful, I'm very grateful for him being so, my lord.
The petitioner has filed the presented application praying for a direction, praying for mandamus by directing the respondents to quash and rescind the disqualification under 164 within bracket 2 within bracket small a slash 164 within bracket 2 within bracket small b with effect from 1st November 2024, published in the website of the respondent number, published by the respondent number 2 on the website of the respondent number 1, being Annex 9 of the presented application. Full stop. Counsel for the petitioner submits that the petitioner submit that in the website of the Ministry of Corporate Affairs, the name of the company, the DIN status of the company, is shown as disqualified under section 164 within bracket 2 within bracket B of the Companies Act. He further submits that the respondent authorities have published the said disqualification in the website without giving any opportunity of hearing to the petitioner. without giving any opportunity to the petitioner. He has relied upon section 164 within bracket 2B, which reads as follows. 164 2B has failed to repay the deposit accepted by it or pay interest thereon or to redeem any debentures on the due date or pay interest due thereon or pay any dividend declared, and as such failure to pay the redeem continuous for 1 year. By referring this section 164, Mr. Race, senior advocate appearing for the petition, submit that 164 of the Companies Act only with regard to the disqualification for appointment of directors and not for deactivation of DIN. But in the present case, the respondent authority, by taking into reports of 164(2)(b, has deactivated the DIN of the company. He further submits that with regard to the deactivation of the DIN of the companies, cancellation or surrender or deactivation of DIN, is provided under Rule 11 of the Companies within bracket appointment of directors bracket close Rule 2014. He submit that the respondent authorities by deactivate the DIN of the company has not taken the recourse of Rule 11 of the said rule. The petitioner has relied upon the judgment in the case of Imraj Ali Molla versus Union of India and others, reported in 2021 bracket में फिर 224 company cases 231 Calcutta and submit that the coordinate bench of this court, by considering the judgment of the division bench of the Allahabad High Court, has held that in any event the disqualification of the DIN of the petitioner could not be operated in respect of the other companies than the defaulting company. In the event DIN of the director is to be deactivated and not merely in the name of the company struck out from the register of companies, said person has to be given notice individually and heard and given an opportunity to establish that he was not liable for the alleged default committed by the company. By referring this judgment, the petitioner submits that in the present case, the respondent authorities have deactivated the DIN by taking into consideration of section 164(2)(b of the Companies Act, and admittedly no opportunity of hearing was given to the petitioner. The petitioner has further relied upon the judgment in the case of Jayashankar Agrahari versus Union of India and others, another. And in this said case, the reported in 2020 bracket में 222 company cases 429 within bracket Allahabad, and submit that the division bench of the Hon'ble Allahabad High Court has considered section 164(2) of the Act of 2013 and held that the condition of disqualification actually exists, and for this purpose, bare minimum requirement of notice to such direction would be necessary to verify whether such conditions exist or not. By referring this judgment, and counsel for the petitioner submit that in the present case, no opportunity of hearing was provided to the petitioner. The press for setting aside the impugned website notice wherein the dean status has been shown as disqualified under section 164 within bracket 2 within bracket B of the Companies Act. Per contra, an advocate appearing for the respondent authorities submit that the dean status the dean status has been disqualified not under 164(2) within bracket B, it is only 164(2)(a). And as such, there is no necessity for issuance of any notice in terms of the amended Act of 2018. He submits that as per the proviso, the director of company which is in default of clause A and B, he shall not incur the disqualification for the period of 6 months from the date of his appointment. And as such, as per the amended provisions, there is no necessity for issuance of the notice. He has handed over the documents and submit that on 17/12/2024, the registrar of company has issued the CRF wherein it is mentioned that the company a instruction has been received from the DGCOA in the month of August 2024, and in terms of section 164(2)(a) read with the proviso of 167(1) of the Act, the directors have been made disqualified for the companies except the company Messrs. Saffron Trading Private Limited for non-filing of the annual returns and balance sheets of the company for the consecutive period of 3 years, that is from 2021, 2022, 2022, 2023 and 2023, 2024. He relied upon section 164(2)(a) and submits that that if the director of the company has not filed financial statement or annual returns for any continuous period of 3 financial years, the directors can be disqualified, and taking into consideration 164(2)(a), the directors of the companies have been disqualified. He further submits that once the directors have been disqualified, accordingly, the company's status of the dean has been disqualified under section 164(2)(a). In reply to the judgment relied by the petitioner, and counsel for the petitioner's respondent submit that the said judgments have been considered by the coordinating bench of this court as well as the division bench of this court prior to the amendment of the Companies Act. But the said judgments is not applicable in the present case, as in the present case, the authorities have taken action in terms of the amended Act. Heard the learned counsel for the respective parties peruse the materials on record and the judgments relied by the parties. The only question in the present application whether the status of the dean of the company has been shown as disqualified under section 164 within bracket 2B or 164(2)(a), and whether the petitioner is entitled to get any opportunity of hearing before the status of the company has been status of the dean is disqualified. Section 164(2)(a) provides that if the financial statements or annual returns of any continuous period of 3 financial years is not submitted, directors will be disqualified. Section 2B provides that if the directors fail to repay the deposit accepts by it or pay interest thereon or deemed any debenture on the dues due date or pay interest due thereon or pay any divided, declared, and such failure to pay or redeem continuous for 1 year or more shall be eligible to be reappointed as director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. Fails to do. The case of the respondents that the case of the respondents that the case of the petitioner is coming under this 2A as the petitioner, the directors have not filed the annual returns from 2021, 22, 22, 23, and 23, 24. But this could find that the document which the respondents relied upon, that is the CRF of dated 17 December 2024, is the internal correspondence between the authorities. Neither the same was forwarded to the petitioner, nor it was uploaded in the website of the respondent author, Ministry of Corporate Affairs. And as such, the petitioners are denied with regard to the existence of the said document, as the said document has not been supplied to the petitioners. The counsel for the respondents has also not shown any document that the CRF dated 17 December 2024 was supplied to the petitioner or was uploaded in the website of the MCA. Section 164 provides the disqualification for appointment of directors. In the said provision, there is in the said provision, the status of the DIN status of the company cannot be disqualified. Deactivation of the company, surrender or deactivation of DIN, not company, DIN is provided under Rule 11. The respondent of the 11, Rule 11 reads as follows. Rule 11 of companies within bracket appointment of directors, Rule 2024 reads as follows. It is a specific case that the respondent authorities have not followed the Rule 11 by deactivation of the DIN. The respondent authorities have also not placed any materials on record before this court, though the respondent has submitted several documents to say that the respondent authorities have complied with the Rule 11 by deactivation of the DIN of the company. It is a specific case of the respondents that the deactivation of the DIN of the company has been done in terms of Section 164 2A. But this court finds that Section 164 is provided only for disqualification and appointment of the directors, not with regard to the deactivation of the DIN. The judgment in the case of Imraj Ali Mullah and Jaishankar Mullah Supra and Jaishankar Agrahari provides for opportunity of hearing to the petitioner. But in the present case, admittedly, no opportunity has been provided. And it is the specific case of the respondents, the opportunity is not required, an opportunity of hearing is not required, as the respondent authorities have invoked the provision of 164 2A. But this court 2A. Considering the above, this court find that the impugned website notice wherein the DIN status of the company has been declared as shown as disqualified under 164 2B, but the said disqualification of the status of DIN of the company has been issued without giving any opportunity of hearing to the petitioner. And as such, the impugned website notice wherein the status of the DIN of the company is shown as disqualified under Section 164 2B is set aside and quashed. Is set aside and quashed. However, the respondent company is that respondent authorities are free to take appropriate steps in accordance with law if the petitioner violates any terms and conditions of the act.
The disqualification of the dean has been set aside.
Dean has been set aside. If the respondents found in any violation, they can take appropriate
Yes,
steps.
Malad, that they are always entitled to. So that I can at least use for
That's
the
set
dean for
aside.
that.
They have not filed the affidavit.
That is set aside.
Malad, they were not required to file an affidavit, your lordship.
Hardly server copy, my lord.
Okay. This and the writ petition. Yes. What you say?
No, Malad, only Malad, if the consequential release can be, Malad, consequential steps be taken expeditedly. Because or else, Malad, I'm on, Malad. 31st of August is the last.
So now it's set aside. You
no, Malad. Grateful. Very grateful, Malad.
किसका? इसमें रन कर रहा है, भेजे ही नहीं होंगे। कब निकला ऑर्डर? 14 तारीख का है। फिर आज है तो तुम लोग फाइल बताए। और एक फाइल मेरा चैम्बर में पड़ा, आज का डेटा आपको खबर ही नहीं है कहाँ आया। तुम लोग क्या डायरी में क्या नोट करता है डेट देने समय? यस, नेक्स्ट।
I beg to appear for the petition. These are all that LOC matters, my lord. Mr. Banerjee was submitting with your lordship. We have concluded our argument. My senior friend was to start with his argument.
Before I start my submission, Milord, your lordship, kindly have a look at this order. Coordinate bench.
12170.
12170. Milord, let this retribution be tagged with this retribution also. Why I am saying so? Milord, why I am saying as because Milord, this is Milord regular. This your lordship is having Milord regular determination. Now Milord, so far as Milord the order passed,
I made it regular.
Now Milord, kindly see Milord the last order. Kindly see Milord last order Milord which was passed on 23rd of July 2026.
L. 23rd July.
23rd of July 2026.
Yes.
Now may I just place this order? Well, can number 1 of 2026 is moved, praying for clarification and or correction and clerical error which has been occurred in the order dated such and such. In the course of hearing, London Council such and such has placed an instruction dated 29th of June 2026, which is at page 21 of the application being can number of 1 of 2026 in the matter of such and such, wherein it appears that at paragraph E that the Register of Companies Kolkata 1 has submitted as follows. It is submitted that pursuant to the report and recommendations of the IO, the Central Government Ministry of Corporate Affairs, via order dated 23rd of April 2026, has ordered that the investigation of say group of companies by the SFIO as alleged misappropriation of the public fund and the criminal breach of trust under section 212(1)(c) of the Companies Act 2013. No. Mr. Mojumdar submits that the order dated 23rd of April 2026 was never communicated to the petitioners and has still not been communicated to the petitioners. It has come to their knowledge only because of the inside instruction dated July 29, 2026 was filed in the another writ applications. Admittedly, the writ petitions are pending before the regular bench. It is submitted before that as the said order or instruction was not in the knowledge of the petitioners. Same was not placed before the court on 29th of May 2026. As such, the appropriate relief was not prayed for. London Council for the respondents has raised strong objection to the prayer of the petitioner submitting that the matter should be placed before the regular bench for consideration. Considering submission made by such and such, London Council appearing for the respondent numbers 1 to 4. This court makes clear that this order was passed in view of the order dated 30th of June 2026 passed by the regular bench. Accordingly, on hearing the London Council for the parties and on perusal of the materials on record, the paragraph 5 be deleted in the order dated 29th of May 2026 and following paragraph be incorporated. Considering the said facts, it is directed
that the respondent authority shall give an opportunity of hearing to the petitioners on the basis of their representation dated 5th of March 2026. The order dated 29th of May 2026 stands modified accordingly and department to incorporate the said correction in the original order. It is further submitted by the petitioners that after this court had passed an order on 29th of May 2026, it has come to the knowledge of the petitioners that the respondents had already passed an order on 23rd of April 2026, which has caused serious prejudice to the petitioners. And in view of the fact the same has not been within their knowledge when the writ application was moved on 29/5/2026, as such necessary relief could not be paid for in respect of an order which, though prior to the court's order dated 29th of May 2026, accordingly till the said order dated 23rd of April 2026 has not been communicated to the petitioners. Next, paragraph 10. This court, by its order dated 29th of May 2026, had directed in paragraph 6 of the said order, no coercive action should be taken against the petitioner till 30th of June 2026 or until further order whichever is earlier. While referring to an order dated 8th of May 2026, passed in WBA number 22767 of 2025, and now it appears that the order of the respondent authorities dated 23rd of April 2026 was passed even prior to the order dated 8/5/2026. Accordingly, as the matters are pending before the regular bench for consideration, the order dated 23rd of April 2026 be also not acted upon by the respondents in the present case till 10th of September 2026 or until further order which was earlier. The interim order dated such and such, which was subsequently extended, is hereby extended till 10th of September 2026 or until further order which was earlier. Now, in my experience for the last 26 years, I have not seen in a modification application any learned judge having no determination passes such kind of order. What I am praying before your lordship today, kindly, tag this WPA 12170 up to 2026 with this writ petitions because this is a clear
What is the 12170?
12170, this is the matter, my lord. They filed a writ petition challenging that MCA is taking certain steps. We are not going abroad and all these things. LOC
at the instance of Ministry of
Ministry.
Here also
LOC.
They have tracked all the same petition.
So where this writ petition is pending?
Before your lordships. Your lordship, kindly have a look at the order passed.
What is the prayer in 1210? 1217?
No. It was done in a cryptic manner. Kindly have a look.
Dear friend is agreed by the order. He can file an appeal.
30th June. Can you see the order passed by your lordship?
The order was passed after hearing them.
30th June.
Today, simply the order has gone against them. They cannot.
No. What I am praying, let this matter be also tagged with these matters. Can you see 30th June order? You passed by your lordships.
And this is interim order of
10
September.
Thanks, my lord. This matter is listed as to be mentioned on the prayer made by the learned counsel for the petitioner for extension of interim order. Learned counsel of the petitioner submits that the paragraph 5 and 7 of the order dated 29th of May 2026 are contradictory. He will mention the matter before the appropriate bench for clarification of the order dated 29th May 2026. He submits that the interim order is still today and prays for extension of the interim order. In view of the order, the interim order dated 29th May 2026 is extended till July 23rd 2026 or until further order with liberty to the prisoner to mention before the appropriate bench for clarification of the order dated May 29, 2026. Now, in the guise of clarification, the subsequent order comes on 23rd of July 2026. So, what I am praying, all these matters are relating to LOC. So let this matter be also tagged, fix any date, we will make argument. And we are taking necessary steps for filing an appeal challenging this order.
So
it is in the process.
It makes no sense for tagging this matter if they are filing an appeal against this order.
This writ petition should be heard along with this writ petition.
Appeal is filed, the writ petition cannot be heard, my lord. They cannot have button on both sides.
Challenging this order. What is happening, my lord? Due to this order. Well, what happens, my lord? Due to this order,
respondents are represented.
Kindly consider, my lord, what is the conduct of the litigant? My lord, when your lordship had taken up this matter on 23rd, I have supplied the communication which I have received from the MCA. Now, my lord, that communication was produced before another single judge by one applications for a modification of the order. And in the guise of modification, this order was passed.
But with deepest of respect, my lord, your lordship, my lord, kindly tag this matter with these matters. Let it be heard out. Let us see, my lord, the conduct of the litigant has to be, my lord, placed before your lordships. Person is claiming, my lord, equitable relief and doing all these mischiefs.
I have strong reservation against the usage of expressions, my lord. My learned friend should be conscious about the usage of expressions.
Yes, I am conscious, 100% conscious.
The issue is today, my lord, we have argued before your lordship, so far the LOC is concerned. My lord, we have two branches of argument. So far, one branch is concerned, my lord, there is no subsequent proceeding. So far, another branch, my lord, there is subsequent proceeding, which your lordship has, indicated to us. Now, my lord, today we have prayed for, my lord, quashment of those LOCs, my lord, because we have traveled a lot in the meantime. Number two, my lord, there is no renewal of LOC. My lord, till date, there is no answer from the other side that there is a renewal of LOC. But LOCs are to be renewed, my lord, on yearly basis.
Not required. Renewal is not required.
No, my lord, that's according to their, my lord. Let them argue on that, my lord. Now, thereafter, my lord, there was another writ, my lord, which was released by your lordship for a clarification. My lord, I was not there. If your lordship sees the order, my lord, what I find from the order, my lord, I just argue that before I place that only before your lordship. Let us not get behind the order, my lord. So the order, it was your lordship's desire that we should that order should be placed before the honorable judge who had passed that order. But that was placed. Whatever order was passed, my lord, the order may not be palatable to me, may not be palatable to my dear friend, my lord. The order was passed after hearing the respondents. Now today, my lord,
okay, whatever it is, I am not going into that. So now the another writ petition also by the same party.
Yes, yes.
But the issue
what
is
you
complete.
prayed for? What you have prayed in that writ application?
Well, I have to take instruction because I have never appeared in that writ, but there is nothing to do with the LOC.
Yes, yes.
And my lord, going by the submission of my dear friend, they are now in the process of filing an appeal.
If it is not with regard to the LOC, then why you have referred them the order before the honorable judge, and you got the order of the interim order. If it is not with regard to the LOC, so then how the interim order?
I'm beseeched by so many, wise men around me.
So let that writ petition be. Let the writ petition not. I am not tagging. Let the writ petition be.
Yes.
No, but only. But I don't mind. Your lordship's determination, whichever order, writ petition your lordship likes to hear, your lordship can do. Only difficult.
No, because why I am telling. So now as per the honorable judge, that order has also been stayed till this 10th September. Correct. And if today this court disposed of the matter, that order will remain in the file.
Yes.
So what would be the effect of that order or that communication?
With your lordship's permission, may I just read out with your lordship's permission, my lord, paragraph 8, my lord. If my lord's pleasure will be 8, my lord, page 3, para 8.
Yes.
It is further submitted, my lord has got.
Yes,
I'm
yes.
obliged. It is further submitted by the petitioners that after this court had passed the order dated 29th May 2026, it has now come to the knowledge of the petitioners that the respondents has already passed an order on 23rd of April 2026, which has caused serious prejudice to the petitioners in view of the fact that the same was not within their knowledge when the writ petition was moved on 29th of May 2026, and as such necessary relief could be prayed for in respect of an order which, though is in prior to the court's order dated such and such. Admittedly, till date, the said order dated 23rd of April 2026 has not been communicated to the petitioners. Then, my lord, this court, vide its order dated 29th of May 2026, had directed in paragraph 6 of the order that, court, no coercive action shall be taken against the petitioners till 30th June 2026 or until further order, whichever is earlier. While referring to an order dated 8th of May 2026 passed in WPA 22767 of 2025, and now it appears that the order of the respondent authorities dated 23rd April 2026 was passed even prior to the order dated 8th of May 2026. Accordingly, as the matters are pending before the regular bench for consideration, the order dated 23rd of April 2026 also be acted upon by the respondent, also not to be acted upon by the respondents authorities in the present case till such and such or until further order, interim order such and such.
What is the order? What is the 23rd April?
My lord, that order, my lord.
What is the 23rd April?
My lord, that order they have never placed, my lord, which was placed before your lordship, by virtue of which, my lord, they have ignited their jurisdiction.
That's why if that is the communication you place before the learned judge and learned judge, if today I pass or dispose of the writ application, this order will remain on record.
We have a look at your lordship's order on 22nd of July. Kindly, in these proceedings, kindly take your lordship's order on 22nd of July. Can you see the conduct? Well, I'm just pressing it. Can you see, my lord, the repetition number is that is 22767. The last one. Sunil Kanoria versus Union of India.
Yes, yes.
Yes. Now, my lord, can you see? Next order. London Counsel for the petitioner has concluded his argument in respect of WPA number such and such, such and such, such and such. As regards hearing remaining 2 writ petitions, the London Counsel for the petitioner pays for time to take instruction with respect to the report submitted by the SFIO dated July 14, 2026. The report submitted by the SFIO be kept with the record. My lord, I produced the report before your lordships, given a copy to my London friend's client, to my London friend. Now, my lord, on the next day, my lord, the application was moved and order was obtained.
But the order was not part of that report, my lord.
Yes, order was supplied to you.
No.
Yes, don't make incorrect submission. Order was supplied to Mr. Banerjee. I supplied the copy of the.
No, it's only the instructions, sir.
Yes. At my instruction, my lord, on the very day, my lord, I supplied the instruction.
What is the stage of the WPA 1217026?
But it's pending for consideration, my lord. That's the last order which was before your lordship, my lord. It seems well, we were protected till 10th of September or something. The order is, my lord. The interim order is operative till 10th of September 2026. Now they are in the process of. I'm sorry.
Considering the writ application is disposed of.
This can one is disposed of. Let the writ petition be tagged with these writ petitions, my lord. All are similar, my lord. Let it be harder along with this.
Let him show, my lord. The prayers are similar, my lord.
You are there, you saw it.
So if you are not sure, how do you make a prayer before the honorable judge?
Well, can you see the can past file in connection with that writ petition? Can you see the annexure of the can?
Substance of the writ petition was, my lord, that our representation was on board. That was not considered. When an order was passed, my lord, it was never disclosed to this honorable court, my lord, that that order had already been passed. Now, my lord, today the scope and ambit of this batch of writ petition, my lord, is completely different, my lord.
Okay, I am not tagging. Let the writ petition come.
That your lordship can definitely because we have to seek for extension there also.
Why I am worrying, why this court is taking into consideration, kindly come to this which you obtained the order, order dated 23rd of July.
Please,
23rd of July, paragraph 11.
Paragraph, my lord?
Paragraph 11, please. The interim order passed by the court. The interim order passed by the court, the order dated 23rd April 2026 is also not acted upon. If that order is affecting in this writ petition, then what would be, if today I will dispose of or tomorrow I will dispose of, then it will be difficult. So let the writ petition come.
In the can you see, these instructions I had handed over on 22nd.
This is saying, my lord, the can
instruction I handed over to the lordship with a copy to Mr. Banerjee. Now, these instructions, my lord, they have utilized that and filed independent can application and obtain this order.
All the orders are clear.
What is the order dated 23rd April?
Exactly, my lord. That they have never produced.
So if you not produced, how you got the interim order from the coordinate bench?
How
without going through the interim order, the coordinate bench passed an order?
Yes. Without even having the jurisdiction.
Let you produce the order about 23rd of April.
That they have not produced.
You have mentioned.
You have obtained order.
Yeah. You have mentioned before the Hon'ble court and you got the order. Where is the order? If there is no order existing, how this order exists?
Page 3, your lordship has placed. Your lordship has indicated to me, para 11. Sees para 9, page 3, para 9.
Correct.
It's recorded admittedly till date that said order dated such and such has not been communicated to the petitioner.
Correct. If it is not communicated to you, it is not on record. And today also you are not producing the record. You
don't have, my lord.
So what is the purpose of this interim order? If suppose tomorrow this order will affect this present writ application while disposing, so what would be the effect of the order passed if this court will pass the order on?
But there will be fresh LOC, my lord.
Yes.
There will be fresh LOC, my lord.
My lord has this bunch of orders. But can we take the first order in that bunch? First order is dated 29th of May, right? My lord, can we come to paragraph 6 in the second page? Kindly see. In view of order dated 8/5/2023 passed in WPA 22767. There is interim order. Number 22767 is today on board before your lordship. They are saying 22767 and this petition, this 12170 are different.
But they are getting interim order in 12170 in view of order passed by your lordship in 22767. Then how they can say these two are different and cannot be
Because
hard
my lord, the
together?
prayers are
Kindly
different.
see,
My lord, I just
they
indicate
are,
to your lordship,
they
my
are
lord.
taking this order from this honorable court, using that in that petition.
Exactly, because
which
there is a
also
connection.
before your honor.
But the
There
scope
is
and ambit
connection.
are different.
There is connection connected, so let them be checked. What my learned senior friend was.
So that, my lord, matter is not hard, my lord. What I will say, my lord, if your lordship intends to see the record,
Fix any date, my lord, I will hear, I will make argument.
my lord, it is your lordship's discretion. I cannot stand in the way. Only the request I have, my lord, don't tag it, my lord, because now they.
I am not tagging it. Let them.
Please, my lord, give us a short date because, my lord, they will
one
linger,
after
my lord.
another. I will say.
I don't want this batch to linger, my lord, on the ground that they will file an appeal against that.
That cannot be done. This court will not allow
Please,
for
please.
lingering the matter.
And my lord, kindly direct them to produce that order, my lord, which has not been
obtained order, you produce it.
The matter
In
is
his
fixed.
case, his order I will produce.
The matter is fixed today for. Especially fixed today for hearing at 12. Learned counsel appearing for the SFIU, SIFO. Submit that. Submit that. The petitioners have obtained an interim order from the coordinate bench of this court in WPA number 12170 of 2026, dated 23rd of July 2026, wherein the coordinate bench of the court, this court has passed the following order. 11 then. Accordingly, as matters are pending before the regular bench for consideration, the order dated 23rd April 2026 be also not acted upon by the respondent authorities in the present case till 10th September 2026 or further order, whichever or until further, whichever is earlier. Learned counsel for the respondent by referring the said order submit that the WPA number 12170 of 2026 is pending before this honorable court, and this said petition also be brought on list along with this application one after another. Considering the above, this court find that writ petition number 12170 of 2026 is required to be placed before this court along with one after another of the present writ application. Accordingly, the department is there. Accordingly, WPA number 12170 of 2026 within bracket Hemant Kinoria and another versus Ministry of Corporate Affairs and others be listed after WPA 414575 2025 and another matters on give the date on 8th September at 12 noon.
Please, my lord. And my lord, if my lord's pleasure will be to direct them to produce that order, my lord.
Which one?
The 23rd April. My lord.
But you have obtained the
on the basis of the information, my lord.
You have right the interim order.
My lord,
Can it be on 9th? Yesterday also I mentioned the same thing.
I don't. Then when come over? Come up with.
My lord, interim order was passed in my favor because there was no disclosure.
Where is
Mr. Let them produce that order. My lord.
The respondents are directed to produce the order dated order number order dated 23rd May 2026 on the next dates. 28th September at 12 noon.
Deeply obliged.
Yes, next. Obliged. No interim order, no? Interim order is there.
No interim. No interim.
Yes, next.
I appear for the petition. I appear for the petitioner. But I have filed my affidavit of service on the previous day. You know, this is a case where a tender was published initially. 6 qualified persons were declared. I am one of them, the writ petitioner. Kindly come to Annexure P2, page 42.
42?
Page 42.
Yes.
there is a list of 6 names. The last.
You are Sabir.
Sabir Construction. I am the technical evaluation will be done shortly. They are the valid bidders. At this stage, my lord, suddenly the tender was cancelled. Kindly come to page 46. And it's
46.
Page 46.
Yes.
This is the notice. The first call of the above tender is treated as cancelled as per direction of the competent authority in the interest of award by reference 4. Reference 4 is SUDA something not disclosed. Now, my lord, one thing is admitted that in the tender paper there was a clause that is at page 24 that the authority reserves the right to cancel the tender.
At any stage.
That is in case of unavoidable circumstances. Here no unavoidable circumstances are disclosed. And thereafter, my lord, in respect of the same work, a fresh tender has been again issued. It starts from page 47. Only the difference is the different works are now clubbed together. And therefore, the credential, the earnest money, everything has been increased, no technical change, nothing. And thereby, some persons, including me, we are now prevented from participation because of the increase of the credential. Against that, I am before your lordship, my lord. No reason is found, no reason is disclosed. And in view of some recent judgments of the Honorable Supreme Court, it has been specifically held that putting of arbitrary condition or imposition of arbitrary bar something which results in prohibition of participation, open participation in tender, that is not permissible. And that is exactly what is being done without disclosing any reason. Against the subsequent issuance, cancellation order and the subsequent issuance, I am before your lordship.
I have been short. Now, this night has been voted by the municipal engineering directorate for certain works on both. But guiding up to page 17 parts. This was the first in 1926. But there are 3 page 17. There are 3 works, name of the work 1, 2, 3. And when the amount tender, the 3 amounts have been mentioned. Number then on 7th May 2026, this tender was and the page as referred as at page 44. We found
6 bidders, sir.
6 bidders. But up to this point, but there was no further neither technical nor financial at this. Only when we opened the offer and we found 6 bidders. Then under the competent authority issued a plea to amalgamate to cancel this tender and refresh. And by amalgamating 3 work orders, as I have told you about at page 17, now the third notice has been appears at page 47. There is clause number 3. This is the work order. Earlier I have shown from page 17, I refer page 17. 3 work order now clause into amalgamating. This is the work order, which is what which has been amalgamated. And if you write the right hand side, along the amount to tender 4.12 lakhs and all, you will kindly add page 17 amount, same figure will come. Now there is no such change. And the exception, few changes were there, why it has been amalgamated by the competent authority. Now, this was made on the phrase tender was installed.
No, this page 17. Page 17, one is yes. 3 works order. Correct. But that is total change. Construction of proposed 10 TPD municipal solid waste management, and here the balance work of the SW solid waste management, and amount has changed 2 crore 45 lakhs.
Earnest money, credential, everything has been increased,
Not increased.
2,45,000.
And that is why we are now barred. Our credential doesn't permit.
What is the credential?
To participate.
The value of the contract, particular 1 plus 3, page 17, is equivalent to 4 plus 12 lakh as would be evident from page 7, what, sir?
No, that is the total one.
Total value of the
Or each work.
keyword.
No, that's why I'm telling 47. The first work, name of the work, put to tender amount 2 crore 45 lakhs or 2 lakh 45. Don't. Correct. Last one 4 crore 12 lakhs. So this is the third work.
This is the what the petitioner is challenging. He has page 17 is it has been segregated. Page 17 is segregated.
Acha, the total. You are telling that 1, 2, 3 as combined in 3. So you are telling that the 1, 2, 3 of the 17 is equal to
4 point or 1 to 4.
Okay.
Equal. So 5, 6, there is no difference. Now, sir, given the competent authority directed the local zone, and sir, our position, the data is operational, number 3 is the features of the higher authority to cancel and issue fresh. And it has also been published in the web portal of the along with this cancellation notice. But should they also annex at page 46?
At page 40.
Yeah, that is there.
Yes. So that was the decision of the indirect authority to issue, cancel, and issue a fresh by amalgamating. So that was now the petitioner chose not to participate
in page 70.
Over, but in L1 was yet to be declared since the matter is solved.
So you are not participated.
No, because in page 17, my lord, 3 works were there. I participated in 3. Rupees 2,72,000, 2 crore 72,049.
You participate separately.
Separately, in one, not in all. And because of this clubbing, my lord,
so you will not be able to.
I am not being able. That is the difficulty.
Your bad luck. Anything further?
This time, my lord, the amount has been increased by
come with a good case.
Does not permit, and that is why.
Sorry. The petitioner has filed the present date application challenging the impugned communication dated 15th May 2026, wherein the superintending engineer, West Circuit Municipal Engineering Directorate, Government of West Bengal, has cancelled the tender, cancelled the notice inviting tender number notice inviting e-tender dated 26th of February 2026. And counsel for the petitioner submit that on 26th of February 2026, the superintending engineer the respondent authorities have issued the notice inviting e-tender with respect of 3 separate works, with respect of 3 works. 3 works. And as per the said tender notice, the petitioner has participated in 1 work being serial number 3. After submitting the document, the respondent authorities found that along with the petitioner, there are altogether 6 firms are eligible to participate in the said tender and have issued the notice notifying that 6 valid bidders have found eligible to participate in the bid process. But instead of proceeding the bid process further by an order dated by a communication dated 15th May 2026, the said tender is cancelled. And after the cancellation of the said tender, the respondent authorities have issued other e-tender notice dated 12th of June 2026 by incorporating some other works. As the respondent authorities have incorporated some other works in the second tender notice, due to which the petitioner will not be in a position to participate in the said tender. Counsel for the petitioner submit that the respondent authorities have cancelled the first tender in spite of having knowledge that 6 personship firms have participated in the said tender process. 6 firms are eligible to participate in this tender process, but the said cancellation order is without any reason. Any reason. He prays for setting aside the impugn order dated 15th June 2026, 15 May 2026, and subsequent tender notice dated 12th of June 2026, and to direct the petitioner respondents to complete the tender process with regard tender notice dated 26th of February 2026. Per contra, an advocate appearing for the respondent authorities submits that though the respondent authorities have published the tender on 26th of February 2026 and 6 bidders have found eligible to participate in the said tender, but subsequently the authorities have found that further works is to be put on tender, and accordingly the authorities have taken a decision for cancellation of the earlier tender notice dated 26th of February 2026 and incorporates other works and to issue a fresh tender notice, and accordingly on 12th of June 2026 a fresh tender notice has been issued. He further submit that the works which are appearing in the tender notice dated 26th of February 2026 is also in the second tender notice at serial number 3. But serial number. He further submitted after issuance of the second tender notice dated 12th of June 2026, the tender process is over, but work order has not been issued due to the pendency of the presented application. Had the learned counsel for the respective parties peruse the materials on record and the materials on record. This could find that though the respondent authorities have issued the tender notice on 26 February 2026 with respect of 3 works, but subsequently the authorities found that some other works are also to be executed and taken a decision for cancellation of the earlier tender notice and to publish another tender notice by including subsequent other works including the earlier tender works which was published on 26th of February 2026. After publication of the said tender notice, the respondent authorities have proceeded the said second tender notice and the tender process is over, only the work order is required to be issued. Considering the above, this could find that the petitioner has not made out any case to interfere in the decision taken by the authority by cancelling the earlier tender and issuance of the first tender notice. Accordingly, writ petition is dismissed. Next.
Your Lordship, I'm led by my senior Mr. Shaming Chatterjee in this matter. I'm praying for a short passover on his ground, Your Lordship. Your Lordship, a very short passover on his ground.
I am praying for a short passover, my lord. We have Mr. Chatterjee, my lord. He is on his leg from court number 237, my lord.
So now, whether you applied for the have you applied for
PwC authority to tell me regarding the procedure to adoption? I have filed.
But what is your age?
But
what is the age of both the petitioners? Here both are the petitioner. Husband and wife both are the petitioners.
What are the petitioner number? What is petition?
What is the age of both?
40. Petitioner number 1 is, my lord, one is date of birth is 1974 and another one 1975, my lord.
What is the total age? 75 means 25, 25, 50. Now
50
second
and 51, my lord.
51.
But for last 3 years, the child is with us, my lord.
But procedure is to be adopted. So what the child welfare committee? But taking the child by the child welfare committee, what step they have taken further?
But I have already.
Yes. What step they have taken?
No, my lord.
So you take what step they have
But I have
taken?
asked them to tell me the procedure.
Tell them that you have to. You are the advocate. You know. You read the Kara. What is the procedure? That is. You read the Kara.
But may I play for short passover, my lord? He's only just.
Not today.
Great.
Yes, call the passo.
11 to 13 was passed to.
But that first was the bank matter though. बैंक एक था ना 9 yes what your instruction? So when you will visit? Where is the petitioner?
I am for the petitioner.
Yes.
I am led by Mr. Oyun Bhattacharya.
So okay, you do one thing. You have a copy. So you provide that document and you inform when he will come. Go and do that. So I am keeping on Monday. Yes.
Good. Milord, can it be fixed tomorrow, Milord, subject to your lordship's convenience, Milord?
Whether it cannot be done. You supply all the document and they will come for the photograph to see your face. Last one. Why is the presence of the petition not required? Our executive will visit. We need customer sign, so he will take that.
Document submit.
So you want suggest something solution?
Definitely. Definitely. The KYC mentioned above. KYC form.
My matter is over, all things over. I am not keeping anything in mind.
Your Lordship, I am suggesting that, as it was stated by my learned senior over here, that they can send someone and the KYC can be done at home.
See, what I propose, this document you can collect and submit today evening. Where is the bank? Here only. Mr. Bhattacharya, go through this 4 document, you supply that. And they will come, they will inform the date, time, they will come and photograph.
They can come to me today itself, my lord. Your lordship may record my statement and I'll keep everything ready
I'm
to.
telling. So I am keeping on Monday. If it is done, then matter can be disposed of. When you are leaving?
I'm leaving, my lord, next week, my lord.
So Monday I am keeping it.
My lord, we'll come back on Monday. Wait. We will come back on Monday. Your lordship may record my statement that I am available today. They can come, and I am keeping everything ready.
You do one thing. You along with document, you write to the bank today
Please,
itself, and then you will do. Very. I am recording here. The bank has submitted the document and submitted a communication wherein the petitioner is required to file the KYC document. KYC document. That is photo, address proof. There's
only
Aadhaar /
I'm sorry, man. Only one thing. You'll also can see, my lord, these 4 documents. For these, my lord, they have suspended my account, my lord.
That is not.
And my lord, I'm requesting for cost, my lord, because my lord, according to the regulation, my lord, this is
Bhattacharya, no.
My lord,
let the work be done, then we'll see.
My lord, may I just suggest, my lord, if we write again letter to them, my lord, there will be
I am recording here.
So they
I am
may come to me today itself. It can be shorted.
I am recording your submission. KYC form. क्या बोला? And the bank has to submit KYC form, comma photo, comma address proof dash Aadhaar slash voter ID slash passport slash driving license and PAN card. It is further mentioned that the KYC is not permitted by online due to the blockage of the account of the petitioner. Full stop. It is further mentioned that the petition is not required to appear before the bank in person. The executive of the bank will visit the house of the petitioner, residence of the petitioner for taking signature in the presence of for taking signature of the petitioner in all document in the presence of all bank officials. Let the clarification be kept with the record. Considering the above, the petitioner is directed to immediately submit all the documents to the bank in course of the day and course of the Learned Bhattacharya, Mr. Learned Counsel appearing for the petition, submit that the petition is available today in his residence, and the bank can visit to take the signature of all the documents. In view of the above, the bank is directed to intimate the time to visit of the bank officers either for taking signature of the petitioner in all the documents, and the petitioner shall remain present in the house when the bank officers will visit for taking signature of the petition. Did the matter appear on Monday, 24th at the top? Come on Monday.
Perfect. My lord, your lordship's pleasure will be to record my submission.
I have recorded. Because I recorded that you will submit this document, and you submitted that your petition will be available today in the residence, and the bank will inform the time.
For my lord, high-handed action of the bank, my lord. But this should not have happened.
That is a procedure.
First, you complete that.
So, my lord, will come back on Monday.
They are saying download from the website.
And
They should come.
Yeah, we will be providing that.
Not
perfect,
website.
Not
But they are now indicating that KYC form, why they need to download it from website. My lord, we will provide
You
that.
do.
Because according to your circular, I cannot download it when
That's why, because of blockage.
And blockage was by them. And one of their regulation is with before blockage, my lord, or before my lord KYC, they need to notify me, my lord.
And how long will my credit facilities be?
Because it is a long procedure.
Do
Do that. I have directed you to immediately
I'll do that, my lord. Your
submit the document.
At the moment it is done, my lord, my credit facility to be opened, my lord.
That's why you kept on Monday. What they're doing.
So that I can also come back with the details, my lord. My lord, I cannot.
What more reason?
That's why I kept on Monday. One day 24 hours has given to them if it has been done today.
Very most of.
Next. क्या है पासवर्ड बता কি আছে পাসওয়ার্ড
11, 12, 13.
Yes.
The suspected list of shell companies. MCA was required to indicate, my lord.
Whatever direction would be given by your lordship.
No direction. My only question is that
Earlier applicant directed us to submit a report.
But the report which has been submitted, that is not with regard to kindly come to the page 160. 160.
160. 10th July 2023.
Yes.
So, as per the audit report, the petitioner's company is not involved in anything. Cell companies also, they have requested the petitioner to approach the MCA for removal of the name. And now he has approached. The MCA is not taking. Now, kindly come to the 188. 188. 188 clause F down portion. We did not get any evidence to a circulation of money for the purpose of laundering money. We did not get any evidence of tax evasion, money laundering, of obscuring ownership, Benami properties. We did not get any evidence. So this is the forensic report.
Yes.
So
Then my representation is at 193.
not 193 is the representation. Correct.
The first.
So you have submitted this reply. In the reply, kindly come to your reply.
मैटर हो रहा है ऑफिस में स्कैन हो
2 मिनट में तुम इधर उधर कर देता है. Yes, yes, yes. In the reply, please you come to the reply. Paragraph 9.
Yes.
So you, because the document which I have shown to you, that has been referred by the petitioner in paragraph 22 and 23. Kindly come to paragraph 9 of your reply or report, whatever it is. You have stated that respondent number, there is no need to comment any offer. So please see to that. Please see to that. Take the instruction only. What I propose to do, but subject to what the instruction. Once the audit report has come on record and petitioner is requesting, the MC has to consider. But you first when you will come after 1 week.
Very.
And counsel appearing for the respondents, though have filed the report, but this court find that the report has not satisfactory. Accordingly, and counsel for the respondents prays for a week time to take instruction. According cases adjourned, let the matter appear on 2nd September.
Very well.
2nd September within 10 matters.
2nd September.
Come on that day. You also consider all these things.
Well, second, I mean Supreme Court.
Okay, come on that day.
My lord, could it be on the first, my lord?
First September. First September.
Deeply obliged. My lord, all three matters, 11, 12, and 13. Very good.
Yes, next. One zero two disposed of 161.
61, your lordship.
None appears. No recommendation is sought for dismissed. Next.
33.
Madam, 162, Madam, it is exceptional, Madam. Name of the petitioner deleted.
Which one?
162, Madam. Madam, son of the petitioner selected for MBBS.
Urgent matter.
MBBS court at Rajshahi Medical College and Bangladesh, Madam. And Bangladesh. Selected for MBBS. And Madam, he applied for passport. Passport authority did not issue passport as his mother petitioner name was deleted.
Mother petitioner.
Mother.
Because both has to be mapped. Whoever is born.
So who is the petitioner? Petitioner, who is the mother? Not the candidate.
The candidate.
162 record. The son of the petitioner is selected for getting admission in the MBBS course at Bangladesh, but due to the deletion of the name of the petitioner from the voter list, the authorities are not giving the passport, not providing the passport to the son of the petitioner to go to Bangladesh to pursue her higher study. Higher studies. Counsel for the petitioner submitted the being agreed with the deletion of the name of the petitioner from the voter list, the petitioner has already prepared an appeal before the appellate authority, and he prays for a direction upon the appellate tribunal for disposal of the appeal preferred by the petitioner as early as possible, so that the son of the petitioner may get the passport to go to Bangladesh to pursue her MBBS study. Considering the submission made by the counsel for the petitioner for this materials on record, the appellate tribunal is requested to dispose of the appeal filed by the petitioner as early as possible, preferably within a period of 2 weeks from the date of receipt.
हाँ 2 weeks
मतलब डायरेक्टली रेस्पॉन्डेंट नंबर 3
हाँ
Page 34.
Disposed of.
page
Huh? Disposed of.
copy
165. 33. Page 33.
Disposed of.
20
Disposed of.
32
Disposed of.
68
2 persons are there. Who are they? Who is in 168? None appears. No accommodation dismissed. Next.
169 exceptional. Actually, next week my passport expired. I am residing Saudi now. I am a driver, my lord. Kindly short direct.
renewal for passport.
Page 28.
The
He has to appear
who
before
is petitioner in Saudi?
Yes,
Or is in India?
he is now in Saudi, my lord.
His passport is going to expire. When? Counsel for the petitioner submitted. The petitioner is working in Saudi Arabia as driver, and his passport is going to be expired in the month of September 2026. The petitioner is intending to renew his passport wait for action. क्या बोला? Petitioner intending to pray for extension of the passport, but the passport authorities are not accepting the application of the petitioner as the name of the petitioner from the voter list has been deleted. He submitted the petitioner has prepared an appeal before the appellate tribunal and prayed for expeditious disposal. In view of the above, the tribunal is requested to dispose of the appeal as early as possible, preferably within a period of 2 weeks from the date of receipt. Disposed of. Yes, next.
Well, page 28.
Disposed of.
Well, similarly, like on 79, 71, his passport expired on 12 October, my lord. He is also residing there.
Same करो as 169.
So the date
169. Yes, on लेकिन ये अक्टूबर कर दें.
On 69 to 170.
Yes, next. Disposed of.
173.
others
Page 50.
others
How many persons are there?
Others, 3 জন আছে. Yes.
One.
The petitioner is
4 persons.
4 person. Same family.
Huh?
Same family, 4 person. 4 person are there.
Yes, they are not the relatives.
They are relative, my lord.
How relative? Who is petition number 1 and what is the relation with the petition number 2? Yes, not the mother, father, son, brother.
Son, brother.
Then
Their cousin.
the 4 petitioners have filed the present writ application. According, writ petition is dismissed. However, dismissal of the writ petition will not prevent the petitioners to take appropriate steps in accordance with law. File separate application.
Lordship, item number 168. Kindly, my lordship. I am on leg my another court. 168.
Yes.
Two brothers.
was also dismissed.
This is 44. Kindly, my lord. 2 brothers are there.
2 brother.
Passport has been expired.
What is the page number?
Page number 14, my lord.
এখানে স্ক্যান কপিটা পাঠাবো
168, my lord.
Disposed of. 168 disposed of. Yes, next.
47
Page number 47. I am for the petitioner.
Disposed of.
175.
Page number 90. Disposed of.
176. Page number 36, my lord.
Disposed of.
177. Page number 29.
Disposed of.
178. 31. Page number.
Disposed of.
179.
Disposed of.
180.
নতুন নতুন লোক আসছে
Disposed of.
81. 181. 181, lordship. Page number 17.
Disposed of.
182.
দেবে দাদা
হ্যাঁ আমি পাঠাবো।
Disposed disposed of,
183. Page number 28.
disposed of,
31. 31.
31 page.
बोले हाँ पर बोले जाओ
184,
31.
disposed of,
185. Page number 26.
disposed of,
186. Page number 30.
disposed of,
187.
31. 31.
disposed of,
188.
Domicile certificate has been kept with it.
why?
Because her mother's appellate kindly comes to page number 35.
एट जोड़ने की अच्छा
Her first appeal is pending. Although the petitioner's police verification and everything is clear. Kindly comes to page number 24. It has been sent to the block development officer by the Hasnabad PS, but last night, but nothing adverse could be found against her till. But in the year 2024, her domicile certificate was issued by the same BD. That is in page number 22.
How is it related to SIR?
It is not the SIR.
No.
Her domicile certificate has been.
এটা কাজ করুন কালকে
It is not there today.
within 5 minutes कर लो कल ये मेन मैटर है ये SIR नहीं है कल रख दो उसको
কালকে থাকবে কালকে
come to ma
I don't know why.
and mother SIR it is not the mother's application.
This petition is a daughter.
Yes, next.
189.
189.
Yes,
90. 190.
disposed of,
Scanned copy the bill.
191.
191.
disposed of,
It's a offline. Arey Baba, epic number has to be given. XHS
191.
191, Your Lordship. Howrah district. The epic number would be. পেপারে লিখে দাও ওই পেপার নিয়ে লিখে দিয়ে দাও কোর্ট অফিসারকে and ওর পরে নেক্সটটা নিয়ে নাও
The petitioner has filed an appeal before the appellate tribunal physically being epic number
XHS
capital X
14
capital H capital S 149350 on when you file where is the seal on 6th April 2026. Counsel for the petition submitted. Since then, the another is already there. What is the page 54? Online is also there. It is in. Disposed of.
sorry madam
Disposed of.
regular
Next.
192.
And for the petitioner, page number 27.
Disposed of.
193.
On self-family matter, father and son and daughters.
Father, son, and daughter 4. Then where is the 5?
Fine, daughter, 3 sons and 1 daughter.
Disposed of. Next.
scanned copy दियो दादा
94.
And the petitioner, page number 33.
Disposed of.
20
Disposed of.
23
196.
Disposed of.
27
197.
Disposed of.
28.
29
Disposed of.
29.
27
Disposed of.
100. 27 madam.
Disposed of.
101.
34 madam.
Disposed of.
102.
29
Disposed of.
103.
39 page number 39
Disposed of.
scanned copy
Disposed of.
105.
22.
Disposed of.
106.
Disposed of.
107.
last one district Malda
Being agreed with the deletion of the name of the petitioner from the voter list, the petitioner has preferred an appeal before the district election officer Hooghly, Hooghly, on, what is the date? Hooghly, full stop. On receipt of the appeal filed by the petitioner, the district election officer has conducted the hearing, but till date no order has been passed. Non-counsel for the petitioner prayed for a direction upon the district election officer Hooghly to dispose of the appeal preferred by the petitioner as early as possible. Consider the submission made by the counsel for the petitioner peruse the record, this court find that the petitioner has preferred an appeal before the district election commissioner being agreed with the deletion of the name of the petitioner from the voter list, and the district election officer also conducted the hearing, but no order has been passed. In view of the above, the district election officer, Hooghly, is directed to dispose of the appeal preferred by the petitioner dated 13th May 2026 as early as possible, preferably within a period of 3 weeks from the date of receipt of it. Next. So what do you want? Disposal to? Disposed of. Next.
33. 33.
Disposed of.
Oh. Urgent matter.
Lordship, this is the same matter which I seek leave yesterday. The matter is, I have already mentioned that NIT UG aspirant domicile certificate has not been issued. He got selected in Bachelor of Dental Surgery. However, it's my prayer before your Lordship to kindly just direct the SDU to at least grant a provisional domicile certificate so that the petitioner can proceed with the admission procedures.
Who has prepared the appeal before the appellate authority?
Petitioner itself. His name only got deleted.
So he cleared the NIT and he got the seat in the dental.
Surely, sir. You can just see the page. Surely, your Lordship, you can see the page number 34. The undertaking. He is just taking the undertaking.
No. Which seat he got?
BDS.
BDS.
Bachelor of Dental Surgery.
Which college?
So,
okay, record an order.
Institute.
The being agreed and dissatisfied with the deletion of the name of the petitioner from the voter list, the petitioner has preferred an appeal before the appellate tribunal and the same is pending. In the meantime,
my prayer is as well to dispose of the matter appeal.
In the meantime, the petitioner has also appeared in the NIT UG examination, and after clear the NIT UG examination, the petitioner is selected for getting admission in the BDS course. Due to the deletion of the name of the petitioner from the voter list, the concerned authority is not providing the domicile certificate, due to which the verification of the document has not been conducted by the authority for getting admission in the BDS course. Counsel for the petitioner prayed for a direction upon the respondent authority, that is SDO.
Yes, Your Lordship.
The respondent, the subdivisional officer, Chanchal subdivision, for grant of domicile certificate on temporary basis till the disposal of the appeal filed by the petitioner. If she further undertake that after disposal of the applicant, if the petitioner succeed in this, after the disposal of the appeal by the appellate tribunal, the same will be informed by the petitioner to the concerned authority. Consider the submission made by the counsel for the petitioner. This court find that the petitioner has been selected for getting admission in the BDS course, but due to non-grant of domicile certificate, the petitioner is not getting the admission in the college in BDS course. Accordingly, the subdivisional officer is directed to provide temporary domicile certificate for a period of domicile certificate till the disposal of the appeal filed by the appellate pending before the appellate tribunal. The petitioner is directed to submit an undertaking before the subdivisional officer that in case the petitioner failed to succeed before the appellate tribunal, she will surrender. He or she will surrender. He will surrender the domicile certificate granted to the petitioner. Full stop. The appellate tribunal is requested to dispose of the appeal as early as possible, preferably within a period of 2 weeks from the date of receipt of this.
Grateful.
Yes.
I wanted to mention, my lord, item number 56 of your lordship's list. My lord, it's a matter where, my lord, my demat account has been frozen.
You mentioned earlier, I think
Yes,
so.
my lord, but it has
No, it
appeared
was
as item
taken,
56.
not taken.
Not taken up yet, my lord.
56.
56. Any day convenient to your lordship, my lord. Save and accept, my lord, Monday, my lord.
Okay, we'll see to that.
Item number 56.
Yes.
I'm so grateful to you.
have fixed matter, item number 153, 154.
But it seems Malad has to refix the matters again, Malad, because in terms of Malad's last order dated 10th of August, Malad, there are similar writ petitions, Malad, which were to be listed together so that they can be heard and decided. Now, Malad, that writ petition has not been, it's WPA 20642 of 2026, so that has not been listed, Malad.
Yes.
Para 2, Malad, of Malad's last order, dated 10/8/2026.
2026.
I think my learned friend will be ad item with me, Malad, at least in this regard,
I was
Malad.
telling him in whispering that you are saying my statement, so my client will not take it.
But how you are free today?
Free, fine. Every day I'm free. When the matter is in your lordship's court, I'm yeah. My lord, your lordship will recall challenging that rate. We have filed a substantive rate petition. That was subject for coming to this.
This one?
Will not come.
The petitioner.
Achha, this is the same.
Same. Supplementary affidavit is directed to file by the division bench. It has come back.
Okay, okay.
But a substantive writ petition has been filed. My lord has recorded in your lordship's order.
Yes.
Somehow it has probably missed.
So that matter is that fixing rate of the.
Yes.
That we have challenged substantively.
So.
I have filed an application for intervention, can 1. In the current expedition, that WP A18829.
2-1.
That is in the list.
18829.
That can I say?
That is in the list.
Okay.
In fact, I have existing supply of SSK. But the petitioner, according to his pleading, he supplied last in 2018. But we have been supplying at the rate fixed in 2018 because subsequently no rate revision.
Now it is renounced. Now it is renounced. The existing has been given effective by the division bench.
Yes.
So he is happy now.
Kindly.
So what can be done?
Fixed another day so that
Yes.
rate can be hard.
Babu, kota আছে? Rate petition 20642. 20642 of note करन 20642 of 2026.
But in terms of lordship's order, we have again sub, but because that rate is not here.
20
is not here.
कौन सा डेट है कोई डेट है
terms and conditions.
শুধু bid document এটাতে bid document and both.
Whatever is published and whenever it is published, my learned friends will challenge.
Oh,
I think. No.
One day I told the bar, only the advocates require one white paper and black ink. The writ petition is ready.
I don't have first-hand experience of that.
That's what. Without the experience, how I can say this?
What can you see I will place on the other day the orders of your lordship's court where he appeared for this, my client.
Hey, Kobe.
Now it has changed the side.
Kobe.
Now the honorable judges after changing side said something.
Kobe, in this matter.
Oh,
I done it is it is attributable to me, my lord. I briefed my learned friend, my lord, in one of those matters. Mr. Ajit Paja, my learned friend, and my lord, myself, Mr. Vishwarup Bhattacharya and myself. So there was a question before the honorable division bench. It was possibly before Justice Shirpurkar, my lord. That why have you come up? Why have you filed these petitions, these frivolous petitions? So my learned friend said, am I a criminal? I am a citizen of India. As long as I am a citizen, I'll keep on filing petitions. And that saga continues, my lord.
No, that is the judgment of the apex court. You can you have a right to do anything if it is not prohibited by law.
So I am not tell anything. That's the same thing you are following.
I have to follow because I am this side. My lord may have liberty to forget this part, which is blessings for us that my lord had not forget.
Yes. कब होगा? उससे पहले कोई नहीं है. अगस्त में
मीटर घुड़ेगा. बस ठीक है. ইন্টারভিউ তো আছে.
তো আছে ওই 2022 এর রিট পিটিশন. ও এটাই did not finalize the thing.
ये पता है सेनापति
সেনাপতি কোথাও গেছে কি অন্য কোনো কোর্টে মামলা
8 अगस्त खाली है कितना बजे पक्का क्या 2 ना हो जाए 2 बजे खाली है 28 अगस्त
28 8 মানে ফ্রাইডে না
Friday is there
ফ্রাইডে হ্যাঁ
28 August, Friday.
तो then September देखो September क्या डेट है फर्स्ट डेट
at 2 o'clock
To change coach.
not change Mr. Basu is not available on Friday
I will. No, I cannot say in court. Many things is coming. Is it available? They could get.
that is the difficulty before this court
All courts.
7 September
very well
what
very
time
well
2 p.m
Great.
Fine.
let it be I will take all this along with by an order dated 10th August 2026 this court directed to place WPA number 20642 of 2026 along with the present date applications but inadvertently the said petition has not been placed. Accordingly, the department is directed to place the said application along with the said document on 7th 7 September at 2 p.m.
Great, extremely great.
Matter on 7 September at 2 p.m. as specially fixed matter. Next.
My
Yes.
position. The tender matter, if you remember, tender, I'm sorry, Eastern Cold tender.
Lord, before my learned senior friend begins, my lord.
16. 17.
Tender matter floated by Eastern Coalfield.
Yes.
The Coalfield was not finalizing the tender, although the stipulated period of 135 days had lapsed. Lordship, they said they will take instructions and come, and there was some policy decision they were saying. Ultimately, they were to take instructions and come. What when they will.
Yes, Mr. Ghosh, you are appearing.
Milord, I am appearing, Milord, for Eastern
India.
Coalfield. Milord, for Milord, Eastern Coalfields, Milord,
Eastern.
R5, respond number 5.
Yes.
Milord, this is a tender, Milord. My learned friend has participated in the tender. That's the only stage. There is no finalization.
That's why
of
he
the
is
techno-
only asking for whether
Yes,
to
Milord,
finalize.
Milord, kindly, Milord, he is asking for in his prayers, if your Lordship takes. So not a question, Milord, of what I intend to do. If your Lordship takes the prayer in question, Milord, his prayer is, Milord, that, Milord, I should not abandon the tender process. That's the interim order he is asking for.
Not interim order, I will dispose of directing you to conclude the.
Milord, I have taken instruction. Milord, we do not want to proceed with the tender.
To take decision and communicate that.
Yes, I'm taking, Lordship will record that.
But I'll deal with it now, my lord, whether he can do.
I do not.
Let him file it on tape. Let him.
That's
file
why.
an
What is the
affidavit.
question? I'm saying so. I do not want to go with the tender. Today, Milord, his bid is not selected. He is in the techno-commercial bid. Milord, I have received a complaint. There are technical problems. Milord, that complaint, Milord, I have with me. Milord, today, Milord, a tenderer cannot say I will not cancel the tender. I do not have to furnish reason of that. I am saying so. I'm saying so.
Let me deal with it here and now.
Yes, let us hear it out.
Let us hear it out.
Yes,
Whether
yes.
he can cancel it.
Yes, absolutely. It's within my right.
Reading an affidavit, whether he can cancel.
Yes,
Can we have the
absolutely.
tender once, please.
Absolutely.
My prayer is not what Mr. Ghosh read out. Kindly have prayer C. What my prayer C is exactly what fell from your lordship. This is what I had submitted on the last occasion. My prayer is commanding R5 and its men, servants and aid to expeditiously conclude the technical evaluation and thereafter proceed with the tender process strictly in accordance with law, the tender conditions and applicable decisions, clarifications issued. This is a simple prayer. Mr. Ghosh, I understand, does not wish to use an affidavit because I don't want to waste.
He's telling that it's.
I'll not. I don't want to. I said so that I don't want to proceed with the tender.
Now kindly have the tender bid once, please. Kindly have P1 at page 23.
Yes.
Validity of the bid has to be, bid offer must be kept valid for 120 days. It presupposes that the tender will be decided in 120 days. Now kindly turn to clause 13 at page 38. Clause 13, Your Lordship, sir. The provisions of CIL's purchase manual and its subsequent amendments prevailing on the date of opening of tender shall also be applicable if not specified otherwise. I'm just showing Your Lordship this. I'll take Your Lordship through the manual also, what the manual says. Now kindly have, my Lord, CIL's clarification on the tender process, because this is what Mr. Ghosh is saying, what his instructions are is exactly what they do every time, and that is why they've come up with a circular saying this cannot be done because external forces come into play after a tender is floated. Kindly see his Vigilance Officer Circular, page 70. This is Coal India Limited Vigilance Division. Exactly what the subsidiary wants to do, the parent says you cannot do. And because they are loath to doing this every time. Kindly see the circular vigilance. The delay in tender process was discussed in the meeting taken by Chairman Coal India on such and such date, followed by CMD's meeting. It was informed that some of the tenders are taking unduly long time to get finalized. In some tenders, even after recommendation of tender committee, acceptance of the tender gets unduly. And kindly see next. It was also pointed out that many tenders get cancelled without any justifiable reason, even after identification of L1. Accordingly, it was decided to fix upper time for completion of various processes in the tender and monitor the same. Now, the timelines are given. We are at stage 5 and 6. The tender receipt has happened. Now, 5 is not being done, techno-commercial is not being done, and thereafter acceptance of tender. So, after receipt of tenders, that is after closing date, within 45 days, the tender has to be completed at the highest. Now, let's see serial 4. In that
Tender receipt, open tender 21.
Tender receipt, global tender, 21 days or 30 days, whatever, we close that. So, after receipt of tender, now comes serial 5, my lord.
Yes, tender committee deliberate.
Tender committee deliberations, including technical, commercial scrutiny and price justification, we have 60 days.
Yes.
And then acceptance of tender committee recommendation, 30 days. If tender requires acceptance by vote, 45 days. Let us give them the highest, my lord, 60 plus 45. Within 105 days of receipt of tender, you must finalize. Now, can you see? This upper time ceiling may be monitored closely and cases of delay may be brought to the notice of the chairman and managing director of company for his attention. Then kindly see, if it was also decided that if the tender committee recommends cancellation of tender or the competent authority has taken tentative decision to cancel any tender above 5 crores, opinion of advisor, PNV, that is Purchase and Vigilance, Coal India Limited, may be taken as to whether cancellation is absolutely necessary. All cannot be at the whims and fancies of the subsidiaries. All cancelled tender above 1 crores will be placed in the meeting of functional directors for review. This is without prejudice to examination of any cancelled tenders by the chief vigilance officer. So it's not that I don't feel like doing it and I will cancel it. Now kindly come back to the tender once, please, my lord, page 23.
23.
The tender in question, my lord. I'm just giving your lordship the timeline now because your lordship saw there 105 days. So kindly come back to the bid opening date is 7th March 2026. Bid end time 7th March 2026. So 105 days from there, they ought to have completed this process. And that is why they say now, my lord, validity has to be 120 days. So my bid has to remain valid for 120 for them to accept within 105 days. And cancellation follows a procedure. It has to be with reasons. The final vigilance has to be informed. Functional directors review has to be there. And it may be further reviewed. Now kindly to the Coal India guidelines, which are applicable to this. The tender is bound by provisions of Coal India purchase manuals. Yes. 1.2.1, it applies to the subsidiaries also. 1.2.1, your lordship will see 8 wholly owned subsidiaries.
Subsidiary company Coal India.
So I am concerned with Eastern Coalfields Limited, which is a wholly owned subsidiary of Coal India.
Then kindly 1.3.1 deals lays down how Coal India and its subsidiaries will carry out purchases. The purchase function in Coal India Limited are carried out by Materials Management Department headed by EDNM General Manager.
Where from you're reading?
Purchase functions in
No,
Coal India and
clause,
subsidiaries. 1.3 month.
Yes, purchase one.
This is for this is the purchase manual manner which is referred to in clause 30. Kindly come straight to Malad. Kindly 1.5.4 at the bottom of page 4. 1.5.4.
Yes.
The procedure laid down in this purchase manual is to be followed by all entities of CIL, entities including Malad Eastern Coal, involvement in procurement of goods. Then only exception is World Bank funded projects. Then kindly come to page 150. 10.10.1.
Yes.
Kindly come to 10.10.1. Period of validity of bid is essential. Kindly see. It's essential that tenders are finalized and contracts are awarded in a time-bound manner within original validity of the tender, that is at 120 days, without seeking any further extension. And then your lordship will find here about 5 lines or 10 lines, 6 lines from the top. A reasonable time frame, preferably not exceeding 120 days from the date of opening of bid, techno-commercial bid in case of 2 bid systems should be fixed for the bids to remain valid while issuing tender inquiries, keeping in view the complexity of the tender, etc. So this is 120 days they get from here.
Yes.
So, the Coal India guidelines, read with their own Coal India Limited circular, is binding on ECL, and this cancellation at their whims and fancies is not permissible.
Yes, that's all.
Yes, Millard.
Millard, writ Millard proceeds on the basis that I have to finalize. Now, Millard, I have not taken any decision is not before your lordship. Whether I have finalized, whether I have cancelled, or whether, Millard, I don't want to proceed. So there is no decision before you. My learned friend is a participant in a tender. Millard, today we are in the techno-commercial bid stage. It's a tender in the GEM portal. Lordship does it every day, Millard. I get 2 or 3. My learned friend may get, Millard, more. But, Millard, GEM today is not a party before your lordship. Now, Millard, GEM portal has a clause that, Millard, buyer at any point of time can cancel the tender. I don't have to give reasons, Millard. Deepest of respect. Now it has been settled by our division bench, by the Supreme Court. I don't have to give a reason if the tender has that a clause. Millard, I said, Millard, I have not taken a decision. He feels the tender is not going forward. So he comes to court and asking me to fully comply with the tender and complete it. Millard, as an employer, Millard, I can go forward with the tender. I can scrap the tender. I have to intimate him in the GEM portal only. That's the GEM portal. Now, Millard, today, courts have said even a L1 or a H1 doesn't have a vested right. So what right my learned friend today has in asking that I will not cancel the tender or I have to go forward with the tender? So far as the Coal India guidelines lordship has seen, that's a 2015 Millard he showed. Millard, what he hasn't said, Millard, kindly Millard takes Millard why I don't want to go forward. There is no decision. I have not taken any decision till now. I have not. A decision is a subject matter of challenge. Millard, lordship can ask me to take a decision. I will give a written decision to that. But there cannot be, Millard, order. Millard, there cannot be any order that, Millard, I will not cancel the tender. That's within the realm of the person who floats the tender. Millard, the claim of even an L1, if he was L1, if I had cancelled, isn't damage.
Kindly see the prayer C.
Milord, kindly look at prayer C.
Expeditiously conclude the contract.
Milord, I don't want to conclude. I want to give a go by.
Take a decision. That's why
I will take a decision, Lordship, and record it.
And thereafter proceed with the tender strictly in accordance with the law. And
why I don't want to go? Kindly, yes.
If you're not, you pass a prepared order.
I pass a reasoned
There
order.
will be a cause of action
Yes,
for that.
I'll do that. Why I don't want to go?
Yes, you give that.
I'll give that
Because
kindly. And the reasons, kindly.
As per the manual, you have to complete within 120 days.
Milord, why, Milord? There, what is not shown, Milord, kindly have a look at it. The manual is, Milord, pretty fat. Milord, kindly take, Milord. I have a right of scrapping the tender also. Kindly have a look at, Milord. Page, Milord, 185. Kindly bears with me, Milord. Milord, this sort of litigation, Milord, should be stopped in.
That's why I'm asking.
Kindly, Milord, takes, Milord, 185, Milord. Kindly have a look at it.
Yes.
Scrapping of tender and issue of fresh inquiry. Lordship has found out. Now, Milord, 13.22.1.
Yes.
Under ordinary circumstances, it is not desirable to scrap a tender and re-invite quotation. Rejection of all bids when justified when. Milord, the actual quantity quality requirements have changed. I can say, Milord, today I don't need this. So I can, or there is an unrectifiable infirmity in the bidding process. So this is given to me under the manual. I can say today, after floating the tender, I don't need it. You are going by my, there is no contract. It's a question of legitimate expectation.
Everybody is having.
Whereas if there is a material change in the basic specification after issuance of tender inquiry. So power is given to me to scrap the tender, A, B, C, D, Milord, the powers. Now, Milord, why? This is annexed to the writ petition, Milord. Kindly have a look at, Milord, the parent body is Director General of Mines and Safeties, Milord. They, Milord, issue a circular. Kindly look at the circular 29th of June, Milord, 2026. Page number, Milord, 66 of the writ petition. Normally, Milord, what are these? These are ionizer for dust separation, Milord, of coal. Now, if you, Milord, take coal, Milord, and there is, Milord, basically, Milord, crushing of coal, there will be dust. So what is required? It's something called ionizer. So ionizer is required for a person who is qualified. DGMS guidelines initially said, that's in the tender. I'll show the previous guideline. Are, Milord, 4 of them. So there are National Chemical Laboratory, Pune, Industrial Toxicology Research Center, Lucknow, Indian School of Mines, Dhanbad, Central Institute of Mining Research Fuel, Dhanbad. Lordship has seen. In addition to that, to get, Milord, better, Milord, offers, because, Milord, it's, Milord, public element involved. Milord, they now insert, which is, Milord, page 67. Lordship has found out 67. Any government laboratory, test house, institute having all testing facilities, including above mentioned institution for testing chemical additives used for dust suppression in the mines. This is added. Page number 67. 67, Milord. This is part of the writ petition.
Yes, ease of doing in accordance with the above requirement.
Any government, this is a, Milord, in addition.
Any government laboratory.
Yes. Any government test house, institute having testing facilities, including the above mentioned institution for testing chemical additives used for dust suppression in mines.
Yes.
So this is done. This is a new circular which has come into force. So I have to put that in if I at all want to go forward. Because in my tender, Milord, initially, kindly have a look at what was DGMS circular. DGMS initial.
So what benefit you are having with regard to this?
Milord, I get more, Milord, participants.
More
Initially,
participants?
Milord, who can bid in the tender.
No, what is the work of the work? What is the work?
Tender, Milord,
What is the work?
it's a, Milord, tender selection procedure. One he has to get with selection in his bid is, Milord, he has to get the certificate from these 4 authorities.
Yeah,
initially, it was only that. Now, the statutory body, which is, Milord, DGMS, which is, Milord, has issued a circular on, Milord, ordered, Milord, on, Milord, 29th of June 2026. He has added this Milord, additional clause. So, other than these 4, Milord, any government laboratory, test certificate, institute having all facilities, including the above mentioned institution including the above mentioned institution for testing chemical activities used for dust separation. So other than these four, you can go for Millard, other institutions also. Now, Millard, this was not there. Millard, if your lordship takes page 61, what was prevalent when the tender was floated? Page 61, annexure P3, 24/2/2015. This is the authority under the Act. I have to function, Millard, as per the direction. Kindly have a look at Millard, page number 62.
Correct.
This four was only there. Lordship has seen it?
Yes.
My tender, Millard, the difficulty is my tender at page 40 had, Millard, the term from government test house. Page 40. Serial number 4. This 4 lordship will find?
Yes.
So, Millard, these four, including or from government test house. Lordship has found just Central Institute of Mine, Fair Research Institute, Dhanbad, or from government test house. Lordship has found it?
Yes.
So, Millard, this was there. When, Millard, the circular was not there. So, Millard, I have to now, it's unrectifiable defect. So, Millard, I have to, Millard, come back and, Millard, follow the procedure. That is permissible in the manual itself. I have to give a decision. I have not taken a decision yet.
Correct.
Millard permits me to take a decision.
That you initially you told that you record your submission, you cancelled it.
Yes, I'm recording.
Now, this is the reason.
No, I'll give the reasons. I'll give lordship once. I'll give a detail. Though I am not, Millard, obliged to do so in view of the rulings of this court.
No, that's.
I'm not obliged. Lordship
You
says
take either one stand. If you want to give the reason and pass an order, then I will fix a date. Then you come. You say that on that day you will come. If you say no, your submission can be recorded. I will
my
record the
submission
submission
can
and
be
I
recorded.
will dispose of this.
yes, my submission can be. And why, Millard? Kindly have a look at.
Because if you are making a submission, because that is not on record, I don't know what tomorrow what will happen.
If lordship wants an instruction, I'll come back with the instruction one page. Millard, because
That on the first day, that is what was said. That
Come with the instruction.
Kindly have a look at GEM portal, Millard. So many things are said. Kindly, Millard, takes GEM portal. GEM is not a party. Kindly have a look at the GEM portal. Millard, buyer reserves their right to cancel at any point in time.
is there any time,
Nobody denying with regard to cancellation. You can cancel or whatever it is. They have a right to challenge, and the court has
They
to
let him challenge. And
that is not here. Here only there. They are going by with your document. Why you have not taken a decision? You take the decision.
I'll give Millard written instruction to court that I don't want to go with the
Come when you will come.
Tuesday. Keeps it Tuesday.
Please.
Come on.
Whole India.
Learned counsel for the parties has argued the matter at length. Solicitor counsel for the respondents prays for time to bring on record an instruction, bring the instruction on record on the next date fixed. Accordingly, case adjourned. Let the matter appear on 25th August within 10 minutes.
Whatever. Millard,
It will retain its position.
Millard makes it Millard Wednesday. Makes it Wednesday, Millard. Don't Tuesday.
26,
Millard. Tuesday I'm on legs, Millard, in court.
26. No, 26 is holiday.
Holiday.
No, we are told now.
Yes, declared.
27th will be a
27 is holiday.
27.
Okay.
26 declared.
Then keeps it 27.
No, 26 declared.
27th keeps it. Millard, Tuesday, Millard, I am in difficulty, or Monday, Millard.
26 declared holiday. 27.
27. I'm sorry, Millard. Court 16, Millard, first matter this morning.
Malad, they will not aggravate matters of
What is
repetitive
aggravate? I am
matters in
saying
the main
what I
category.
do.
Lordship is in season of.
Why should I? Have I done anything? I am
He's
saying
telling
so.
it. Now it is clear they are not going to issue the tender.
Yes,
Now what
in
is
L1.
that they
In
come?
All India case, even if he was L1, Millard, he doesn't have a right to challenge.
Yes,
my
next.
decision. Grateful.
Yes. Keep the manual with you.
Great. KT manual.
Bring on the next date.
Yes.
Next.
Your Lordship, before the petitioner, and that there is another three petitioner along with this petition, and there is note in the list, which is same in the nature, same there and same response.
What is the prayer?
There is
What is the prayer?
Those are interlinked with the same.
Correct, interlink, but what is the prayer in the read? What is the prayer? Don't know. And you are telling the same.
Well, this is surface. I am appearing on behalf of LIC Housing Finance.
Yes.
This is a surface related matter.
That's why I'm asking. That's why I'm asking him. What is the prayer? What is the matter?
Surface related, Your Honor.
So I am releasing it. This court is not having the surface determination. How this court can hear the surface matter?
The specific statute is there. They go before the tribunal.
That's why I'm asking you. What is the prayer?
The matter, my lord. They go there before the appropriate forum.
You don't know what is the matter? So, where is the representation 16.6?
The representative given the district magistrate.
No, they are asking for the prayer A. Can you come to the prayer A? Respond to each of them to agent to subordinate. Consider the representative 16.6. Where is the 16.6 representation?
Page 219.
Yes. Fraud, representation, suppression of fact by the financial institution, LIC Housing Limited. For the proceeding under proceeding 320 surface A.
May I, my lord? We have taken the position as per the DM order that to also pass by the single bench that was affirmed by the division bench. And we have taken the position, physical position, my lord. They don't have any locus.
So
I have not related or no due relations with them, my lord.
Not today, Your Honor. Only court advocate is not present. I am not aware of the
Counsel for the petition pressed for time. According to cases adjourned, let the matter appear in combined monthly list of October 2026.
Yes, my lord, may I please answer?
My lord, I am for the bank, my lord.
The petitioner with your lordship, the current account holder, my lord, of the name and style Bholanatha stores. My lord, all the business transaction is doing in the through this account. Now, in month of February, my lord, suddenly his bank account is freezed. Inquiry, my lord, there is a some unwanted money, my lord, has been credited to his account, and as per my lord, the cybercrime report, his account has been freezed. My prayer is, my lord, this is my lord, the current account. All the business transactions is doing through this account. But my prayer, my lord, the credited amount, unwanted amount of rupees 9,000 only.
Yes, madam. What is your?
My lord, this writ has become infructuous because the accounts have been already unfrozen. My lord, there was a complaint from the Delhi crime department and we had frozen the account and 2 lien was marked amounting to 9,000 and 8,000 rupees.
No, only
So that is there. Thereafter, my lord.
The lien you have unfroze the account.
Yes, my lord. On the date 29/7/2026, the account has been unfrozen because there is an existing circular dated 26/2/2026, my lord. Mark correct second.
So you have not got the information.
No, my lord.
So my lord,
after my lord,
my lord, that is the mark copy. I'm sorry, my lord. Point number 3.1 and 3.2.
After fulfilling the my lord, the advances.
So this is the circular which says that account, those 2 amounts can be marked lien, but we cannot keep the account frozen. Point number 3.1 and 3.2,
Let it
my
be
lord.
recorded and we'll dispose of the matter, madam.
So thereafter, this was.
The petitioner has filed the present date application praying for a direction upon the respondent bank to defreeze the account of the petitioner. The petitioner submits that the bank has freezed the account of the petitioner on the allegation of receipt of the complaint with regard to the alleged transaction of rupees 9,000. He submits that due to the disputed amount of rupees 9,000, the bank has freezed the account of the petitioner, has freezed the total account of the petitioner, due to which the petitioner is not in a position to run the business. Then counsel appearing for the respondent bank submits that this writ petition has become infectious, though the bank has freezed the account, but freezed the account on receipt of the complaint from the cybercrime police station with regard to two transactions of rupees 5,000 and 4,000 respectively, but subsequent to the but in terms of the circular number 6 of 2026 dated 26th of February 2026, 26th of February 2026, the bank has defreezed the account of the petitioner by keeping the disputed amount of rupees 9,000 in lien. In view of the above, this court find that the account bank has already defreezed the account of the petitioner by keeping the disputed account in lien. According, no further order is required because the petitioner is disposed of.
Great. Hello, those two, the amount will be kept as lien.
Yes, lien I recorded.
Yes. Great.
Service fine. Great.
Disposed of. अरे उसी में रखो, उसी में रखो.
Made this your lordship. My lord, on 14th of August 2026, my lord was pleased to pass an order. My lord, one of them was, my lord, to direct them to file a report.
Yes.
My lord, so far as report is concerned, my lord, I have made it ready, but it could not be affirmed. The latches is on my part, Lord. No.
When you will affirm, when you saw the copy.
What I'm saying is, I have a complete unaffirmed copy. I can give it to your lordship for the record. But lordship, if your lordship allow me 2 minutes time, the issue here is he participated in a tender, and in a mid of a tender, I said you are cancelled. I have not given any reasons for that. So lordship, they came before your lordship's court and said, see, I have complied everything. In fact, I am an existing tenderer. I am conducting this, and lordship in fact passed an order allowing them to continue. This juncture, how a state government, all on a sudden that you are not been eligible to participate. The lordship, the thing is, who can participate? A man in this tender, this is the relates to transfusion of blood, plasma, then so many complicated things. But then what I understood from the brief that someone has to have a license from government of my lord, I'm late by.
No, it has been briefed in this matter.
He wants to give a report first.
No, lordship, allow me 2 minutes time. Then lordship, maybe the report might not. I will request your lordship for 2 minutes. So what I wanted is that someone should participate. He should have a license. Without that license, it's not. So if your lordship kindly come to the pages, if your lordship kindly come to page.
No, what you want? Without the report, you want to argue the matter, or you want to file the report?
Lordship, whether the read will be maintainable or not, I want to see.
Okay, but that's why on the last occasion, your petitioner, your respondents have taken, you have taken the time to file report. So let the report be filed, then
lordship
it will be decided.
I will do everything, but for my satisfaction, 3 minutes time, freedom.
What purpose would be so? You tell me. If I will hear you also.
I'm just thinking that they might come back with a. They might not go ahead with the writ. Lordship, 3 minutes time. Lordship, page 182. As your lordship knows that this is on 18 June
182.
180.
Yes.
18 June, I said I will decrypted the document which you have submitted. I informed him. Now, Lordship, kindly turn to the next page. 183. I have been directed to inform you that the technical evaluation FFB tender will be held on 22nd June 2026 from 2 p.m. I inform Lordship, he duly appeared. Next page, 184. As per the technical evaluation such and such, I have been directed to request you through mails a attested copy of the license for manufacturing blood product approved by the license by Authority of India. Lordship has got it. Then Lordship, he says, next page, page 85. He says, here is the thing. He says that self-attested copy of the manufacturing license of blood product effective from this to this, approved by the state licensing authority and sent to central licensing authority, this. So that means even on 3rd July 2026, his central license was not there. Now, Lordship, kindly turn to page 202.
Yes.
Lordship, this is a Government of Telangana document of 22nd June 2026. I am informed that the such and such, they are such and such of Telangana. Therefore, I forward here with the approval for the renewal license of such and such in triplicate endorsed by the state for approval of the central licensing authority and request you to return the same. So, Lordship, kindly see, even on the when I opened the technical bit, he had not the license, which was the criteria of the tender. I'm not taking your Lordship to that tender criteria because this is admitted. So, since even on June 2026 he had not, then July his own admission he has not. In that case, Lordship, we cannot consider him. Lordship, now, if your Lordship, in the report, what I wanted to rely, that he participated, he has no license. These are all in the form of a report I will place you. So, Lordship, today he doesn't have that license. If he admits that I don't have a license, then Lordship, he wants to proceed. I know. Or if he says, no, I have the license, then definitely I have to come with the report. At least from the document, his own document, it shows at page 85 that 22nd June, State Government of Telangana said that it has to be endorsed. 185, it says they cannot forward the central. And Lordship, the day before, I requested that document, which central approved document. Now, Lordship, this is all I want to say before your Lordship. Now it's up to them whether they want my report to file. Otherwise, we will be taking the time of the court.
My learned friend, I don't know, Millard, probably is not well informed. Page 186, I had shown at the time of moving the application.
Yes.
I had also shown to your Lordship page 188. I can understand, Millard, my learned friend is not willing to file a report. Let him say he'll not file a report, then let me argue. He can't have best of both worlds.
Yes.
So I again request my learned friend that if he wants to file a report, let him file a report. And if he doesn't want to file a report, say we don't want to file a report and we proceed.
Yes.
But I can file the report. I have no hesitation in not filing.
That's the first thing I say.
But kindly takes page 21 of the report.
But may you have a copy of the report? Submission was made, it was unaffirmed, and I
No, one copy was with my learned friend. The signed copy was with me.
Yes.
Thank you. But kindly takes page 20
Milord, may I say this? He has now have been given a report.
No, it's their
Give me
document.
time to consider this report.
No, it's their document only. I'll just indicate one thing.
He's filed a
Bottom and
7-page affidavit with this. Let me consider this.
But only for prima facie
Very well.
satisfaction.
Let him be satisfied so that I also get the benefit of understanding.
But kindly take page 20. Malad will find this is their renewal of drug license in form 28E and it's form 26I. Malad will find, Malad, there is no endorsement by the Central License Approving Authority. It is admitted. This is dated 22/6/2026. Malad kindly turns, Malad, to page 19, Malad. These are, Malad, by other participants. These are all complete documents. Malad, kindly, Malad, may take note of the endorsement at the bottom, Malad. This is the Central License Approving Authority, Malad.
Yeah.
So here, under the drugs and cosmetic rules also, if Malad kindly takes pain.
Okay, then this is the disputed. Let the file reply.
Yes.
Because you are telling that the page 20 does not reveal that he is having the approval of the Central Licensing Authority, and he has relied upon that.
Yes.
What is in 186 and what, that's why what is 186 and what is 120 is the same.
I'll just indicate, Malad.
So let us say that it has been approved by Central Agency by an affidavit.
But kindly only, Malad, take the drug rule, form 26I.
Rule.
Drug rules.
Drug rules, Malad.
Form
26I. It's appended to Schedule A. Mine is the 2026 edition, it's page 287.
Yes, 26I.
Yes, Malad will find, Malad, it has to bear, Malad, the endorsement of the licensing authority as well as the Central License Approving Authority.
Correct.
What the court is saying.
That's why I'm telling, because what the certificate is relying in 186, the same certificate, page 20 of your report.
Yes.
Correct. I appreciate your submission because in that Central Licensing Approving Authority name is there. There is no signature, seal and signature, and the other documents, the other participants have the signature of the Central Licensing Approving Authority. Let he satisfy this court. Let he satisfy this court. Yes, he is having this because I find that the other authority which has been given, that is the online signature, digital signature.
Yes, those are other documents, Malad. But yes. Is this an online signature? Yes. But Malad, it's admitted that there is no endorsement from the Central.
Correct. Let the satisfy. Let the given affidavit. It is certified. Then the court will dispose of the writ application. If it is there, if it is not there, it is not there.
Hold it out. Document. We have shown the document to get that.
You have to satisfy this.
Of course, Milord. Of course.
Whether the central authority is approved or not.
That is it, I said. Either you file the report.
How soon you will file?
Wednesday. I have. It is my. Without instructions, I am saying I have. Milord, I am to take instructions, Milord, and he is asking my person.
From the document and
the only contentions of the respondent in the present application that the certificate under form 26-I within bracket rule 22-1 which the petitioner has relied upon, which is valid from 1st April 2026 to 31st of March 2031, which is appearing page 20 of the report submitted by the authority and page 186 of the writ application. There is no endorsement by the Central Licensing Approving Authority. Learned counsel for the petitioner submit that the petitioner is having the central licensing approving of the central licensing authority, and he prays for time to file reply to the report submitted by the exception to the report filed by the respondent. Let the report be filed by Tuesday after serving the copy to the learned counsel for the respondents. List the matter on 27th August. Under the same heading. Same heading within 10 matters for it.
Retaining a position within first 10 minutes, let it go.
बोलिए.
Hello, we could have saved so much of your lordship's time, Virat. We could have saved so much of your lordship's time. I said that I file a report, I'll come back.
Yes, 21.
21, I'm very state.
Huh?
I'm in detail by
Yes.
He's on his next way.
What is the matter?
Matter is, Malad, has heard extensively, Malad.
Yes.
My caste certificate.
Schedule caste certificate.
Yes, Malad. Yes. Malad, there was a direction about the state, Malad, to file a report, Malad. I have prepared the report. I am handing over the report to your lordship, as well as to the petitioner. I have handed over.
So you go through.
Let me go through. Malad, kindly fix this on Tuesday, Malad. Kindly.
The respondents have filed report after serving the copy to the learned counsel for the petitioner. Petitioner's liberty to take exception to the report, if any, within a week. List the matter on 2nd September.
No, within the top 10.
Within 10.
Give your list.
Kept in the record. Next.
My lord, item number 22, I am appearing for the official liquidator in this matter, my lord. My lord, I am humbly seeking an adjournment on my personal ground, my lord. I met with an accident. I could not reach court today, my lord.
I was presenting the respondent number 1.
Have you filed the reply? Ready?
Yes.
First state.
Petitioner has filed affidavit in reply to the affidavit in opposition filed by the respondent number 2. Let the same be kept with the record. Respondent number, counsel for the respondent number. Madam, you are appearing for respondent number?
My lord, I am appearing for the official liquidator, my lord.
That is the respondent number 2.
Respondent number 2. Prays for time due to her personal difficulties. According case is adjourned. Let the matter appear on 3rd September. 3rd September.
Grateful. Grateful, my lord.
Kindly, I would request the matter to be on the given some priority for hearing my lord. I am ready with the matter, madam.
Yes, next.
Already at
Deeply obliged, my lord.
And for the petitioner,
Yes, what is the matter?
The petitioner before your lordship was successful in respect of a tender which your lordship would be finding at page 20 of this petition, my lord.
20?
Yes. It was for the purpose of supply of cooked diet to the railway hospital.
Yes.
Cooked diet, my lord, to the patients in the railway hospital.
What?
Cooked diet, my lord, for inpatient food, my lord.
Food?
Yes, food. The tender, my lord, was for 2 years, the validity of the tender. Now, my lord, some differences cropped up because...
So you got the tender?
Yes, I got the tender. The tender as of today has been terminated.
The fake GST and ID.
Ideally, do not make submission which is not in terms of the orders.
Petition, your lordship.
It will be 4th round of litigation.
Okay, then what has happened?
Yes. But we approached this court on the plea that we are not being paid. The NIT says that the billings has to be made on a monthly basis. We were not being paid. But several rounds of litigations were there, my lord.
What is the prayer in the petitioner?
Yes.
What is the prayer?
Yes. Lordship kindly comes to page 44 and I shall show what is my prayer.
Credential certificate to the petitioner on the basis of their work done on from Itna to Itna.
Yes.
So if your tender has been cancelled, So how the work done certificate
And
is
I've
provided?
done my work for 10 months. I've been paid for 10 months.
Correct.
Page 44 says that everything that I will work for, there will be an experience certificate. Lordship kindly comes to page 44, my lord.
Yes.
The middle portion is the eligibility criteria of tenderer. But clause I, my lord, kindly see past experience of similar services. The bidder must have successfully executed or completed similar services over last 3 years. But I have done work for 10 months. I'm only seeking this experience certificate for 10 months.
Can't be. Can't be. You have been awarded the work. But subsequently, rightly, wrongly, respondents have terminated the tender within 10 months, though it was the 2 years.
Yes.
Correct. You are challenged or not challenged, that is different thing. Now you are asking that for the 10 months for which you have worked, that is to be given. How the authority will give that certificate once the authority find that your work was not satisfactory or you have obtained the work order by fraud or by placing
there
some
was no such
documents? How the authority will give?
There was no such observation, my lord. But kindly takes up that page, last clause, my lord.
Lordship, may I hand over one order of this court?
I will come to, yes.
But kindly takes a look to this order at 25th of August, which was passed in between same parties. There. 25th of August, July. And this is an order which was passed on 25th of July. And kindly see paragraph 2. The petitioners are performing certain work in terms of the contract issued by the railways. The petitioner, however, are not being paid allegedly because the GSTI number is not correctly mentioned in the contract form. The GST registration number of petitioners is such and such. The authority is referring to the earlier number of the petitioner's proprietorship form, which stood suspended in December 2023 because.
Which order you are referring?
There is an order of 25th of July 2025.
25th of August. It's only three paragraphs.
25th of August. The July. Paragraph 3, my lord. The contract contains a provision for settlement of dispute which mentions that it is 25th July, 29th August. Sorry. Separate. But there is a provision for settlement of dispute.
Where is the judgment?
Your lordship, my lord. বললাম দুটো করে তাহলে একটা করে দিচ্ছিস কেন রে ভাই? But কোনটা দিচ্ছিস?
Yes. The contract contains the provision of settlement of dispute which mention the dispute differences can be settled by mutual discussion. Only the discussion and negotiation fail, then the dispute shall be referred to the arbitrator. So what has happened?
And there's a representation to that effect. Let them take a decision to that.
For what?
That they will not give the experience certificate. If that
I am deciding here in now, why they will? I am telling under the law, you are not entitled. The experience certificate, how? See, in the contract, unless and until the contract is completed the work with the satisfaction of the authority, it is not, nobody will provide you certificate. If suppose you are a junior advocate, you are under the senior advocate and you are not conducting any cases and you left within 6 months, that whether the senior advocate provide the certificate?
Lordship.
If the senior advocate is not satisfied with the work,
but kindly have
simple thing.
Kindly see paragraph 6, my lord.
Yes.
From of this is an order of dated.
The database jam record be updated. Payment of contract was successfully completed.
Lordship, kindly read the above.
Successfully completed the work cannot be withheld. Then, what the court is telling?
The court said, my lord.
So,
Lordship, kindly take the paragraph number 5 of the same order. Kindly take the paragraph number 5, just above.
Previously acted a proprietorship fund, thereafter currently acting in partnership, and the tender was made.
There was no fraud on our part.
The registration of the petition with GEM and the sole GEM is not accepting many entries.
Lordship, may I submit?
Take the paragraph 7 and 8.
Lordship,
yes.
The petitioner has participated in the tender bid through a GSTN number that was fake, and he appeared as a sole proprietorship firm. Later, upon completion of work, when he submitted bill under tactfully and very tactfully, he submitted
through another GSTN number of a partnership firm, but the name was previous. That earlier sole proprietorship firm, that name has already that does not exist. Then there is an order of this High Court which said that the petitioner will get the payment. অর্ডারটা বার করো দেওয়া আছে পেজটা page Lordship, page 55. Petitioner got the remuneration what work he has done. Now he want the certificate of the work which he began upon a fake GST number, upon creating fraud by deceiving that with the sole proprietorship and partnership with the same name, your lordship. With the order of this court, he has got the remuneration.
They have not done any charity. We have worked and thereafter we were paid.
Successful
Yes.
Lordship.
The petitioner has filed the present date application praying for a direction upon the respondent authorities for providing the experience certificate to the extent that the petitioner has executed the work with the respondent authority for about 10 months. Concept of the petitioner submit that in terms of the tender notice. Of the year 2024, the petitioner has participated in the said tender and the authorities have awarded the work to the petitioner. The tenure of the work was 2 years, but in the mid of the tender, work, the authorities have terminated the tender. Fully stop. He submitted the petitioner has worked for 10 months with respect of the said tender work, and petitioner has applied for grant of the experience certificate, but the respondent authorities are not providing the experience certificate for the period which the petitioner has worked for the respondent authorities in terms of the work order issued by the authorities. The petitioner has referred the clause of the tender document wherein it is mentioned that the bidder must have successfully executed or completed similar services over the last 3 years, that is the current financial years and the last 3 financial years. By referring the said clause, the petitioner submit that if the respondent authority will provide the certificate for the period for which the petitioner has worked for the respondent authority, the said certificate will be benefited to the petitioner who participate in the future bids. Counsel for the petitioner further has relied upon the judgment, the unreported order passed by this court, passed by the coordinate bench of this court in the case of Quality Caterer and another versus Union of India and others in WPA 16314 of 2025 dated 29th of August 2025 and submits that in terms of the and submit that in the said order the Honorable Court has directed the authorities for payment of the work which has been successfully completed by the petitioner. By referring this judgment, the petitioner submit that this court has accepted that the petitioner has successfully completed the said work, and as such the respondents are liable to provide the experience certificate to the petitioner. Per contra, advocates appearing for the private respondent authorities submit that though the work order was issued in favor of the petitioner, but subsequently it was found that the petitioner has used the 2 GST number. One is for the proprietorship, another for the partnership firm, and accordingly the authorities have cancelled the tender, cancelled the terminated the work order issued to the petitioner, and the petitioner has not successfully completed the work awarded to the petitioner, and as such, it is not possible for the authorities for providing the experience certificate as prayed for by the petitioner. At the learned counsel for the respective parties, this court find that the grievance of the petitioner that the respondent authorities are not providing the completion, providing the work completion and experience certificate to the petitioner, as the petitioner has worked for 10 months with the respondent authorities. This court find that the work was awarded to the petitioner for 2 years, but in the meantime, the respondent authorities have found that the petitioner has used 2 GST numbers, and accordingly, the respondent authorities have terminated the contract awarded to the petitioner. The petitioner has only worked for 10 months. As the petitioner has not successfully completed the work awarded to the petitioner, this court is of the view the petitioner is not entitled to get any experience certificate for the respondent authority, as the petitioner has not completed the tender work, and in the mid of the tender work, the tender of the petitioner was terminated. In view of the above, WPA number 7 is dismissed.
Deeply obliged, Your Lordship.
Next.
May my lords leave to mention 195 of the monthly list.
Yes.
Lord, in this matter, the interim order is expiring today.
Today.
195.
195. Though the matter is listed as item number 195 of the today's list, but the learned counsel for the petitioner, but due to paucity of time, the matter could not be taken up for hearing. The petitioner has mentioned the matter and submitted the interim order till today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 24th of September 2026 or until further order, whichever is earlier, let the matter remain in the list.
My lord, I've got a case which I will take. I will
Watch
take.
Yes?
10 minutes I will file tomorrow.
10 means for
58, serial 50.
serial number?
Item number 50.
Okay, let us see tomorrow. See the list tomorrow.
I'll take only 10 minutes.
Have you got the certificate?
I will answer.
You have to produce the certificate of the auditor.
My lord, you have asked questions. I will answer to that.
Okay, come.
My lord, item number 63 of today's list, the interim order is expiring tomorrow. We had mentioned at 10:30.
To be mentioned.
I'm extremely grateful to
Yes.
My lord, may I mention one original side matter, my lord?
Just a minute, let the office.
No, officers has changed.
Oh, I see. Let the officer change the name. Yes.
This is item number 187. This was taken up by your lordship last on 10th of June. And my lord, it was fixed for today. Now, my lord, I shall.
187.
Yes, my lord.
8 weeks. XX.
Original side, my lord.
Yes.
Now, my lord, section 34 application, my lord.
Yes.
Parties are, my lord, on that day also, my lord, it was said, though not recorded because we did not want it to be recorded.
It's the SX matter, my lord. We are on the other side, my lord. We are opposing that
Parties
section
are trying
34.
to settle. Possibly, my lord, there is no dispute about that also. Kindly, my lord, keep it, my lord, on some other day, my lord.
But very short, my lord, not very
Vacation,
long
my lord,
time.
I would
Otherwise, my lord,
suggest. But
not a very long time, my
definitely
lord.
Parties are, my lord, trying to
settle the disputes.
I had made very substantial arguments, troubled your lordship, but that thereafter.
But it is good to settle.
Yes.
As a similar, if better
Yes,
sense,
Mr.
my lord,
Banerjee?
prevails. Yes, my lord, better sense if it prevails. But my lord, I was only praying, my lord, if it could be not a very long time, because otherwise, my lord, the settlement intention will also, my lord, will not be intensified.
Meetings, my lord. Just before the vacation, my lord, I was trying to avoid that.
No, I was requesting, Mr. Advocate General, if it could be just before the vacation so that we know there's some progress which has been made.
It's entirely on your lordship.
Government is burdened with the vacation. That's why.
My lord, only difficulty is, my lord, we are also, my lord, have an award, my lord, which is substantial. Whichever way, my lord, it goes, my lord,
So
government
instead
can
of contesting
take
it
a
by
quick
the government-
decision.
Okay, let it come on 7th October. We'll see if it is okay.
Very well.
7th October, I'm fixing as a to be mentioned.
Lordship, yes.
Item number 187. Though the matter is fixed as item number 187 at today's date, but the learned advocate general mentioned the matter and submit that the matter can be fixed. I am not recording settlement. Learned advocate general place for fixing some other date. In view of the above, let the matter appear on 7th October as to be mentioned.
7th October, very well.
Lordship. Lordship, my application is coming up on 26th, sir. So the thing is that, Lordship, the thing on 26th, there's some holiday. It was fixed at 3:45.
You also came to know 26th is holiday.
That is what you just, your good ship.
Yes. Let
So
it come on that day. Will come.
So I'll
on 26 it will come on 27. Let us see.
same position.
Let us see. Oh, come on 27.
Much.
May it please, madam. And I am for the defendant. Your lordship remembers. So decree to my lord takes volume 1, page 126.
First supplementary judges.
Oh, first supplementary judges. No, additional judges brief. Volume 1. Now, এগুলো copies though.
Yes. Volume 1.
Yes, ma'am. Volume 1, additional judges brief of documents. The spiral bound, that's it. Oh, this page 26. Yes. And I just want to get over this topic. Your lordship sees this is a photocopy of a decree passed against one drum place limited. Now, this was the document that was shown to the division bench. Your lordship recalls I got a decree in the trial court that the FD proceeds will give into all this subject about lien, etc. Everything was considered. It was decided there was no lien. You give it back the money. Then they went to the division bench and it's recorded in the order on just the penultimate day of hearing. Then they come and they showed this document and they wanted to rely on this document. Then this is a decree against Drum Place Limited. Now they have changed their stand in this suit. But just to get over that topic, that the fact is that they represented to the division bench that they had a decree in their favor. Now, my lord will see this decree. It's a one-page decree. It's got no reasons. It's what you call, my lord, a default decree. Your lordship will see no defense having been served by the defendant.
Page
126, PD 32. It's A32.
126.
Yes.
Yes.
It's an exhibit, A32.
Yes.
9th day of January, 1985. There's this decree and defendant is to pay the plaintiff such and such.
Yes.
Money. So what I want to show is that this is a ex-parte default decree.
Yes.
And it is drawn up, interestingly, at the bottom right-hand corner by their advocate on the bank's advocate on record.
Yes.
I was wondering whether this practice is here, the way your lordship will trust my advocate to write a decree and just sign it. Because it's a default decree, there's no defense, immediately it's passed. So be that as it may, my lord, this was the decree. Now,
when I taken the testamentary and I send the fiat, I also surprised that. The writing in the fiat.
Because when we used to take leave under clause 12, they used to record on the fiat, and thereafter, if it's dismissed, like we couldn't appeal because there was no suit. Then the practice was you have to take from that fiat. And if anyone knew how to do it, the division bench would automatically grant you. It's because most people didn't know
that
what to
one
do.
matter has come because the department is not giving the certified copy of that. So where then I have given. Yes.
So this is the decree. Now, I'll make 3 or 4 points why this decree cannot be enforced. Though they are in their evidence now, in the plaint they have written, we have a decree against drum place and SL liners.
Yes.
But in the evidence, they have said that they have already adjusted this money against the dues of the alleged profit and loss account of SL.
Yes.
So just to make the points, we have made a comprehensive note, my lord. I shall give you a lot, my lord. So this is, first of all, it's not a certified copy. Secondly, my lord, it's a ex-parte default decree. It would probably, even if they attempted to execute it, it would probably be hit by section 13 of the CPC. And no effort has been made, my lord, even to prove the ingredients of section 13 and I think section 44 of the CPC. The question has become hypothetical because they are not saying that they adjusted the money against this decree. All I wanted to show today was this was the decree which they showed before the division bench. And the division bench made observations. I've quoted that if they prove the authenticity of this document, well, they haven't given a certified copy. If they prove the enforceability of this document, that is that they can enforce it in India under section 13 of the CPC, etc. They have made no effort to do that. And the third thing is whether it is competent to be executed against RK agencies, the decrees of Drum Place Limited. So whether you can, and these are the main 3 things that the division bench said. And none of them have been, at least in the evidence, it's not clear. None of these have come out. There's no certified copy. There's no pleading of section 13, etc. Now, 2 other things are important. In the course of evidence, so no authenticity, no enforceability, and no competence. These are the 3 points I want to make.
Yes.
And 2 further points are that
yes,
this company, after this decree, got wound up. That has come out in the evidence. They even proceeded before the liquidator. So this decree cannot be any longer. This already been executed in England, and the company was wound up. And and the witness said, I don't know if the bank got any claim or not. So that was the additional point. So this chapter of Drum Place Limited is to be brought to an end. I have placed the plaint there. They have referred to again Drum Place decree, etc. So it becomes hypothetical. But it is important in my submission because our counterclaim is based on the deceit or the fraudulent practices of the bank has done to mislead the court. I would say deceit, of course, I'm saying, but misrepresentations. So they represented one thing.
So what is the evidentiary value of this document?
I think it's gone in as an exhibit because they had produced it in the earlier, this A series are all the documents from the earlier. The witness himself did not try to prove it or to enforce it.
And then in the prayer, whether in the prayer they
yes, in the prayer is mentioned in the
prayer, what they have asked for with regard to this decree.
Yes. No. So there's only one prayer. If your lordship sees prayer, I've broken that up before. I'll do it again.
Lien set off.
A declaration that is entitled to exercise its lien. That's one legal thing.
Different.
And to adjust and set off. That's a separate thing.
Yes.
The fixed deposit proceeds against the dues and/or claims of SL Satya Liners and Drum Place Limited, and had rightfully and validly made this adjustment. So they are also saying that we are seeking a declaration. We have the right, but we have already done it in 2006. And the fact that they had tried to do it in 2006 was known to the earlier suit, and it was specifically held that no, you return that money to the constituent, RK agencies. So Drum Place, I just wanted to make these points so that it gets out of the way. Now, what they did immediately after they got this leave, and the division bench in all fairness, my lord, stayed the execution of my decree for 6 months. And it was not that to prove that this decree is bad. It was to this money, in case they prove that RK agency is liable for this decree, then this money will be appropriated. I don't think the division bench or anyone at that stage envisaged that this point which they were arguing in that suit, that this is a lien, we have adjusted it, which has been found to be demolished already. So they really, what are my main objective to show in this whole effort is they are re-arguing the case which they made as a defense in my suit and lost. They are not doing something new, which they represented to the court that no, we have a decree. And the judge said, if you have a decree, you prove it. I'll show that quote again. You prove it in accordance with law and enforce your decree. Okay, I'm in the meantime staying the execution of this decree. This decree is not touched by the division bench.
Yes.
So now when they come up with the suit, it now appears, it has nothing to do with a new claim. They are regurgitating the same defense. So now what happens is after this, they go out to the Supreme Court. In the Supreme Court, I showed my lord the grounds from the SLP. They changed their stand and said, no, we are appropriating against the decree passed against SL Satyalainas. So two things. And then they said the SL Satyalainas account has been transferred to India. So these two misrepresentations were made. But the Supreme Court in any way, in one line, said we are not going to interfere. We are extending the stay given by another few months, you file the suit. So the stand taken there was no, not against drum place, but we are already adjusted against SL liners. Now SL liners, when they come to in this suit, they write again drum place in the prayer and in the pleadings. They say,
so what is the connection with the drum place and SL line?
Their contention, at least in their arguments, is that the Setya family runs all these companies, but they have not proved. And in the earlier suit, they took a point. My suit was bad for non-joinder of Mr. Ranjit Setya, who's our witness's father, non-joinder. And they file a suit, they don't make him a party. He hasn't been made a party only. There's no allegations against him. He was a director in one of these companies that we have disclosed, the company records, and there were other directors. It was not his private fiefdom. But be that as it may, Malad, I'll show that even SL Satyalainas has got wound up in England. So I'm on drum place. I think these are my main points on drum place. In my note, I have made
and
more
the drum place, when the drum place was wound up?
In 1985.
No, 1985, the judgment. 9
Judgment.
January 1985 is the
I'll
decree.
give my lord that. On 21st October 1985. This is, my lord, disclosed by us at page 56 of this document. Of this of that compilation. Yes. Where is it written? Yeah. My lord has page 56.
Yes.
It starts there at page 58, your lordship. So be wound up by this court under the provisions of the Act, etc. 21st October, it was wound. That's the date at page 59. Yeah, also at page 56.
Yeah.
Now they have relied on, my lord will recall that the only real document they are relying on, of course, my learned friends will make their argument, is a letter and resolution showing that these debts were written off. And then they were sent, the profit and loss account is maintained in Mumbai. Therefore, they are saying we don't need any RBI permission anymore. But interestingly, just a last point on drum place. Drum place's name is not there in the list of debtors
Companies
whose names are coming. SL Satyalainas is there. Drum place's name is not there. So that's one chapter. Now they go to the Supreme Court and say, no, it's SL Liners. Now, as far as SL Satyalainas are concerned, my lord, there is no decree. This is my main point. They have consistently, till this witness, who ultimately says, I don't know if there's a decree or not. But no decree has been exhibited. The plaint which was filed against SL, we have got the certified copies and we have executed. They had a claim, no doubt. But it is also mentioned from their documents, it will appear that SL was also wound up and a receiver was appointed. And all this, and the debt was also written off.
Yes.
This must have been done before 31st December 1986. Very difficult to get that date. We made a lot of mistakes and typographical mistakes. In 1986 December, the bank was closed in England, and all what was to be done was written off and sent back. So, my lord, as far as SL is concerned, apart from all the submissions I've already made, the main thing is there was no decree which they have claimed, and the account was never transferred, which they claimed.
Yes.
Now, if the prayer A, which my lord saw just now, this prayer, I have argued already, but I'll just sum up that this is a prayer for declaration. Well, it's not maintainable because it's vague, because is entitled to exercise its lien. I've argued, at least before my lord, a lien is a right to retain something, a movable thing that can be retained. Maybe the fixed deposit receipt could have been, but it cannot be a sum of money. So, right to exercise its lien, and in any event, it has been held that it doesn't have a lien, or to adjust and set off the deposits against the dues of or claims of against SL and drum place. So they are vague and it's without any particulars, this prayer. A declaration cannot be such a general roving declaration. There is no particulars. And the last part, and rightly and validly made such adjustment or set off. Date is not given, particulars is not given. So it's a completely vague and prayer without any particulars. So SL also, my lord, my respectful submission, my lord, is they have not been able to prove that RK agency was indebted to SL. Well, the initial thing was this money will be sent to a foreigner's account. It never said it will be sent to a foreigner's account to pay off the debt of the bank. That is written in the letter of Zaiwala. That letter is very important. I'll also rely on that one. But just to finish off with the characters, one is Drum Place Limited, second was SL, third is Ranjit Setia, who they have not even made a party, and who they are saying that just because the name Setia is there, and they kept changing the name of this foreigner. They said SL Liners sometimes, Drum Place sometimes, House Setia group of companies sometimes, which doesn't even exist. No entity like. And the fourth character in this is RK agencies. Admittedly, my lord, there is no debt that RK agencies owes to the bank. There is no debt. There is no demand also. And nothing has been sought to be proved. And in fact, it has been agreed that there is no debt. So if there is no debt, then the lien form which RK agency signed and said that, yes, I'm signing a lien form. If it had a debt, then that would have been a lien. So that was a contractual lien. But now the trial court in the earlier thing said it is meaningless, that there is no such thing as lien because there is no debt. The division bench said that even if there was a lien, it would not be valid without the RBI permission. So the contractual lien, if any, doesn't exist. The division bench relied on section 32 of the Contract Act, and it is contingent upon this money being sent. And the only other option is that why would RK agencies keep money to pay off someone else's debt if it was not a guarantor? And if the FEMA doesn't, or FERA at that time, doesn't permit Indian to guarantee the debt of another abroad. So that is very clear that section is there. So they have not claimed also, to be fair, that he's a guarantor. They said, no, it's a lien. And all this is coming out of one paragraph of a letter of Zaiwala and Company, who are the solicitors of SL liners, not of drum plates. That letter is at page 14 of volume 1. I've shown, my lord. But the argument I'm making today, my lord, I'm really building up to my counterclaim to show one by one why these stands were taken and the litigation was prolonged for so many years. And still now I haven't got my FD proceeds. Page 14, man.
Exhibit A by 7.
Exhibit A by 7.
Why you have made a counterclaim?
I'm sorry.
Why you have filed the counterclaim?
Counterclaim. This is why.
Why you have filed the counterclaim?
First is what they told the court right up to till the filing of this suit is no interest has accrued on this account because the ED had blocked. So they said the only 20 lakh 60,000, which was the on 6 months. 20 lakhs was deposited, 60 months. So they specifically gave evidence that we are not giving interest on this. No interest has accrued. There's an order from the RBI or the enforcement director. Then when they filed this suit, first, when they made an application for stay of the execution, they disclosed a document where we are saying more than 1 crore had accrued on this account. And by compound interest every 6 months. Now, this plea I had taken in the division bench. When I got only 12% simple interest, in the division bench, we said, no, it should be compound interest. And they said, again in the division bench, I'll show that quote, that their thing was that there is no interest has accrued because there's this thing. Now, it turns out that ED order never said it. All it said is, you should not close this account. We are investigating. So that interest I lose automatically. Now, in my counterclaim, I have not challenged the decree, nor has these challenged the decree. I have not claimed interest. My Lord, when I have placed the written statement, I'll show the written statement again. I have said that to measure my damages, that is why I'm using interest as a measure. So what happened is, I'll just give a very broad example, which we have calculated. Suppose I got 12% simple interest on this amount of 20 lakhs odd. Then I would have got something. But if it was compound and biannually it was done, today, I will get, I think 24 crores. 24 crores. About 21 or 22 crores instead of 1.5, which is now, I think 2 crores has happened all these
compound
days.
interest.
If it was compound, I would have got. So straight away that. But what I have asked for really is the second measure of damages, is what has the bank done with my money? They have used it. Now I've got it straight from the horse's mouth, question 222 to 225. He has disclosed their lending rates and said that usually it's 4% above the PLR, the prime lending rate. So if I do that, I'm to get in the hundreds of crores. I will run both the calculations. And my claim is in tort. So it will ultimately be up to your lordship. If I can show that each and every step, there's a misrepresentation. I'll just start with this letter. This page 14 in volume 1. Not that volume.
Yes.
The
got
other.
Got it.
This is the
Zaiwala's company.
Yes, Zaiwala and Company. Here, the important part is this one paragraph they relied on. Yes, the page 15, the last paragraph. So this is being written in July 1985.
Yes.
The previous letter, there was a letter of February.
Yes.
Where they have said that RK Agencies is arranging. Now, their advocate on record, Stocken and Lambert, wrote a letter on the 29th of May, where they have rejected this proposal of SL liners that RK Agencies will send the money.
Yes.
I will read that last paragraph once with you. With regard to the deposit of rupees 2 million with your client's Calcutta branch, our clients are simply appalled that your clients, by acknowledging receipt of the rupees 2 million from our clients, Indian solicitors, Messrs. Khanna, should plead ignorance of the fact that these monies were deposited on our client's behalf. If your clients now wish to ignore the deposits placed with them by Messrs. RK Agencies on our client's behalf, through Khanna and Company, then our clients have asked you to take instructions from your client and confirm that the bank will allow Messrs. ARC agencies to withdraw this deposit on demand. So they have obviously written a letter saying, no, we don't accept this. We have disclosed their plaint. They have not asked for any declaration that they have made such a prayer or it has been guaranteed that it will be paid. Now, this letter itself shows that the arrangement which was there with ARC agencies, if any, between third parties, not ARC agency, but between third parties, they said that they will arrange. That arrangement was not in existence after this letter, at least. And this letter, Your Lordship will see on the page 14, it's in reply to Stocken and Lambert's letter dated 29th May 1985, which letter has not been disclosed by them. This letter is disclosed by the bank.
One day after Khanna demands the money.
Stocken and Lambert has written a letter on 29th May, which we can read from the reply, that, for which this Zayawala is appalled, that they have taken back the stand. So they knew from that date that there is no such arrangement, but they have managed to successfully drag our litigation. We have succeeded in the all three stages in the earlier suit, and now we are still stuck fighting the same thing in this suit. So now I'm coming to our counterclaim, Manoj. But before that, I have prepared, Manoj, 3 appendixes. I will finally put it in my notes for arguments. The appendix, just the appendix. Give a copy to the other side. Okay. If my lord takes, I'm sorry, it's back. I will just take my lord through this, and on the next day when I finish, I'll give my notes supporting this. I want to just explain to, like I said, my lord, in a argument for a decree, all the work is done at night. There's nothing, this is being done here, but it's so many documents. Now, this looks very complicated, but it's very simple. Well, the first chart, what I've tried to do is to show the shifting stand of the bank. And it will be explained in my notes. I will give the notes also. And I will see on top.
I think this court, this case will be kept as a judgment, so other matter will not be taken.
So now, Lordship will see, for example, what is the issue? The first issue, the first column, my lord, no permission of RBI to remit to the foreigner. This is the issue. In fact, there isn't. Now, your Lordship will see that the primary record is the RBI's letter itself, which they concealed in the initial stage. Now, your Lordship will see the 6 stands of the bank. One is pre-trial. During our chapter 13A, it's written order 13 by mistake. It should be chapter 13A.
Yes.
The first one. They suppressed the fact that RBI had refused permission. Now, your Lordship, then in our trial, they said after discovery in 1990 that the RBI had denied permission, they consistently sought to put the onus. So they said, no, ARC agencies was meant to get the permission. They had failed to get the permission. Then, finally, it is admitted that no permission was given. That is one thing. Now, the second thing, the date up to which the fixed deposit subsisted or was adjusted. Now, the primary record, my lord, would have been the FD register. That has not been disclosed. I've asked the witness in the last suit and in this suit. They have said we didn't maintain a FD register. So their case at that time was because of the blocking of ED, no interest had accrued. So I lost out on that whole thing. Now, I can't go back and reopen that decree because of a fault or misrepresentation by them. Therefore, this action in cement. Then I'm not reading the all 6 particulars. It's in my note. I shall show it on the next day. Then, third is compound interest. They suppressed it.
Yes.
They didn't pay. They have denied the payment of interest altogether, right up to Supreme Court. Right up to Supreme Court. I'll show that. And now in this trial, they have admitted that, yes, we paid compound interest up to the 2006. That also at a very low rate, not as per their bank rate, as a
prevailing
savings account rate, some 4% or something they gave us. And the learned judge gave us, couldn't help it, only 12%. Simple. Then this next, my lord, if my lord will come to 5.
Authority, yes.
This is to do, that is to do with the fixed deposit. Now it's to do with whose debt was it? Whose debt was adjusted? Pre-trial, they said SL Liners and drum place. In the trial, in the written statement, they said one Ranjit Setia's debt. Then they amended the written statement. They said Setia group of companies debt. Then before the appeal court, they flashed the drum place decree. Then in the Supreme Court, they said SL Setia. And now again, SL Setia Liners and drum place. And in the trial, the evidence is given, no, we adjusted against SL Setia. This very chain, my lord, has delayed. So each one of these points has exacerbated our misery, if I may put it that way. Then, my lord, about the decree of SL Setia Liners. Repeated perjury all along, they have gone right up to the plaintiff to say that they have a decree. They haven't produced the decree. We have given the suggestion there is no such decree. Our witness has said there is, to his knowledge, there is no such decree. And he says, I have not seen any decree. The trial, your lordship will see the last. Then the misuse of the Queen's Bench judgment against drum place. My lord, I've just placed these facts before my lord. Similarly, so once your lordship, once also I figured out how this chart is being read, it covers lots and lots of pages. Then they say there's an alleged oral agreement between Zaiwala and the bank in London. And I'm relying on the letter of 29th May, which they have suppressed, which shows that that arrangement was no longer there from that date itself. Then, my lord, the fact that drum place and SL Setia Liners were liquidated or were winding up had been passed is the serial numbers 10 and 11. They did not disclose this at all, and it has come out, the SL Setia Liners has come out in that write-off letter. I'll show that letter. So finally, if my lord turns over the page, the 12th row, what was the basis of their entitlement? The first, they said in the chapter 13A, they said there's a contractual lien. Yes. Because Mr. Khanna had signed a lien document, but ultimately they couldn't show a debt for RK agency. So then they used the word set off. A set off can be done against suppose I have money in the bank, I owe the bank money, the bank can take that money. Can adjust or set off. But they can't take it in lien. It can attach that money. A lien is if they can take a lien of my car or my movable property. So the basis of their entitlement has also changed. So this is the first thing, Malad, about their different shifting stance. And because of this, I have suffered loss not only of time, but also money, Malad, and harassment. So that my counterclaim is essentially based on these misrepresentations made. Because I would have got what, for 42 years, this money I have been deprived of this money. And because of their representations made to the bank, to the court, now the next, it's a brighter piece of paper, Malad, is what they said and what they didn't say. Now, every stage, this was those 6 columns, if your lordship sees, pre-trial written statement, amended written statement, at every stage, I've analyzed, I'm not going to take my lord this today because it will take some time, but at every stage, whatever they said, we have said what they didn't say was there was no decree against SL Setia Liners. Then they continued to suppress. So my comments are there. This is what I argued on the first 2 days.
Yes.
Now, next appendix, my lord, is the list of dates. I had given my lord already a list of dates. It's a bit more in detail. The page numbers, etc., are given. And I'll come to that when if it requires. In our notes, I've referred to some of the dates in this list of dates, so that it's an appendix to my note, really. I shall rely on this one. These are the names. I have placed it. Now, up next document, Appendix B. This was my first day submission. I took my law through every paragraph of the plaint and I had made comments. So we have just summed this up. The assertion in the plaint, and this was our comments. So my lord will recall, first day I only placed the plaint. I was of course only getting these half an hour session. First day I placed the plaint. Second day I placed Justice Maharaj Sinha's order, the trial court. Next day the division bench, which is the most important one. So now if my lord comes to Appendix C. So Appendix B is my first day's argument really of the plaint. I'm not repeating it today. Then Appendix C, these are the portions of the judgment I had read out to my lord.
Yes.
So I have just tried to collate them. I think I'd given a copy of this before also, but I tried to collate them. Now, if my lord permits me, one or two things to show. I'd say that these are like the top quotes.
Yes.
If you read these, Shakespeare, whatever the quote, each quote is in my favor. So I put the ones in my favor. The rest of the judgment is, of course, there. So, for example, if my lord sees the serial number 2, it is clearly found. No. Yes, serial number 2. Most importantly, the plaintiff never owed any money to the defendant. So all these submissions I've been making before my lord, they are there. And I'd placed these before my lord. But just to highlight some of them, so we never owed money. These are all found. There's no lien. Then 540, page 3, the defendant did not realize what the expression foreigner's account meant. Then it says, to my mind, it could mean anything, and the bank did not care to know the particular account, admittedly the undisclosed foreigner, by what was meant by this expression.
Yes.
So I'm not repeating, Manoj, but these are the quotes that from the single judge. Then if my lord turns over the page, this is all single. Then the third page are the excerpts from the division bench, which are also very telling, which I, of course, made submissions today that what they showed was the, if my lord comes to serial number 38, or before that much, serial number 30, I'm sorry, 30. Mr. Mitro contended since London account has been was transferred to Bombay. Now that's incorrect. Page serial 30 of the division bench. My lord has that. The third page of these excerpts. Third or fourth page.
Yes.
It's serially numbered, the quotes. 30. Mr. Mitro contended since London account was transferred to Bombay, permission was not required. And the bank was entitled to have adjustment. Even if we accept such argument, we are unable to appreciate how, without a court proceeding, money could be adjusted, particularly when there was no clear mandate on the score, on that score in the letter of Mr. Khanna making the fixed deposit. There was no mention. It says we will send the money to a foreigner's account. It never said I'm sending it to adjust the dues of the bank. So it's specifically a wrong statement was made on instructions, I'm sure, that the account has been transferred. Then to corroborate this one, if my lord comes to 38. To sum up, we find Setia had dues in London.
Yes.
If Drum Place Limited is a company of Setia, it did suffer a decree before the Queen's Bench Division. Central Bank of India was thus entitled to enforce such decree, provided it is lawfully enforced through appropriate mechanism. Suo motu appropriation on the pretext or transfer of account from London to Bombay would have no factual or legal support. So this argument they are making today is just that it was in front of the earlier judges and they saw it and they said this is not without any adjudication. There has to be a decree. They would have asked for a declaration here that RK Agencies is the name lender of SL Setia Liners or other way around. Then,
okay, stop here.
I'll just explain the last two things. This is the excerpts. I didn't want to repeat, and also the points that are shown from the SLP. Then my lord will come to this annexure 1. I'll finish just now. Annexure 1 is the calculation if 12% was done biannually. If 12% was done biannually, if my lord will come to the last figure in that chart, then I would have got approximately 24 crores today.
Yes.
I'm getting not even the 2 crores. What's lying in the bank today in the court is about 2 crores. And my lord, the most exciting part of my submissions, the last one, if it was done at the bank rate which the bank has given, the amounts also the bank has given, the arithmetic is also the bank's, and the evidence also. It comes to a figure, I can't even say how much this figure is, 132 crores. So the central bank should go away from India also, what my learned friend is saying. Should. And my last thing of the annexure is that these are the persons who have affirmed the falsities. That is anyway, we reserve our right to take after the proceedings are no longer pending. If so advised, he will take the thing. But these are the persons who have affirmed the various, those 6 and more, and the people who have come and given evidence.
Yes.
And of course, the last is the costs that we'll be asking for. So these are my submissions really. But all these charts, my lord, I have explained in a comprehensive note. I shall give my learned friend the note on the next day. And my lord, I shall also give it. I have it today, but where is it? It's fresh off the press, my lord. So I want to correct it once. And all these are the appendixes. I think this is what I wanted to explain to my lord. And of course, the list of dates is there, all the facts now. Note. Copy. This note I'll give on the next day. I'll just correct it. It's in a bit of detail, but it's there. It really explains these. Well, the 27th, your lordship has kept it. I'll conclude on that. But my lord will give us 1 or 2 more days now. On the 27th, there won't be any days. And I've done most of the work for my learned friends, so they should not take too long to start their argument. They can argue. My lord will give us 2 or 3 close dates.
Defendant has argued the matter at length, but due to the paucity of time, hearing could not be completed. Let the matter appear on 27th at 3 p.m. Yes.
My lord has given 2 other dates.
2 other dates.
We can fix that on the 27th.
No, let us have the fix.
I think
27th,
to fix on the 27th.
my lord, the 27th, the moon might rise on 27th also. There's a
Mr. Dutt will be here on the probably will be here on the 27th.
If it is difficult.
I think it is better to.
Okay, come on 27th.
27th, 26th may be a holiday or 27th.
26th is holiday.
Is it already confirmed? Because it doesn't change. It will depend on
26th. Confirmed. Notification issued.
Someone told me that there's some doubt.
No. Today I find after research I find that notification is there.
No, but 1 week, my lord, it'll 2 months of time will go. My lord, fix 1 more date. The fix
Mr. Ghosh will take the crores from you.
Yes. I will make sure that my business in India is also.
How many banks you are having in Calcutta? How many branches you are having?
I asked him whether he has an account in central bank. September.
27th August as well as 28 and 29 September at 3 p.m. September. क्या assign matter है?
Yes. Great.
My lord, in this matter, it's a very embarrassing for me, my lord. Though, my lord, the authority gave me the instruction, but my lord, there was a direction to submit a report. Now, my lord, very unfortunate, my lord, I am taking the responsibility that the report has not been prepared. I have, my lord, I just as a last chance, my lord, kindly give me a 3 days time, my lord. Meanwhile, I will prepare the report, my lord.
My lord, may I just indicate, my lord, so that, my lord, there is no further miscommunication. I'll just indicate, my lord, what is the scope, just that limited part, so that my learned friend can take appropriate instruction. Because your lordship knows nowadays appropriate instructions are not coming. So thereafter, your lordship is, my lord, compelled to adjourn it once again for taking appropriate action. So that is why, my lord, I just wish to indicate what is the small, very insignificant issue here. My lord, kindly take this, my lord, kindly hear me for 2 minutes, my lord. There was a term loan that was given by West Bengal Industrial Development Corporation. The term loan was repaid in entirety. Thereafter, there was a loan called a sales tax loan given. But this sales tax loan was connected to a West Bengal incentive scheme of 2000. Incentive scheme. So I received from the government 2 incentives. 2 amounts. I'm not troubling your lordship with the amounts. Amount X and Y. So I received the incentives. Now the sales tax loan that was given, that was an interest-free loan. Now, when the receivables came to me through the incentives, so this amount, they said you adjust this amount and pay back the sales tax loan. So the amount I received from subsidy from the government, that was adjusted against the sales tax loan, and the balance amount we repaid. This was in 2017. 17. Oh, 11. I stand corrected. 2011.
2007 can't be.
Yes,
After the GST, there is no incentive.
Correct. I stand corrected. My lord, 2011, it was cleared in entirety. Then, for the first time, my lord, in 2017, a letter came for that same loan, sales tax loan, which has been completely cleared off based on the subsidy and the repayment made by us. Now they are saying that there is a demand on principal and interest on the sales tax loan. Thereafter, my lord, 2025, same. Now they are asking for documents from us.
And you are asking from them?
No, I am saying my title deeds. I have repaid the loan. I am saying kindly give my title deeds, because this is the factory land which was mortgaged. So this is a limited issue. And we've given the documents also that previously, based on their documents, the entire sales tax loan, after adjustment with the subsidiary, subsidies have been repaid in entirety. This is the issue that they need to take instructions on.
By next week, we will file the report, madam.
Counsel appearing for the respondent number 2 and 3. Prays for extension of time to file report. Let the report be filed by by 1st September 2026, after serving the copy to the land counsel for the petitioner. The petitioner is liberty to take exception to the report, if any, by 7th September 2026. Release the matter on 9th September.
Very well, 9th September. Well, will it retake that same time?
Then you go to October.
No.
Let it be in the list, we'll see to that.
We'll see.
My lord.
No, হবে সেপ্টেম্বরে করবো আমি করবো
Please, your lordship. Your lordship. Well, I was making my submissions. This is that SEBI matter. No, my lord. Your lordship.
Yes.
Appearing on behalf of SEBI, and I'm being led by my senior. I'm seeking not this week.
Why? Where is the report?
On grounds of personal difficulty.
How that amount has been calculated? That is the only question. Which officer? Recovery officer.
Yes. Page 24 of the proceeding.
Recovery officer. How the recovery officer has calculate that amount?
I am indicating one thing. I must indicate. My lord, a lot of submissions have been made from the bar. My lord, let my learned friend, my lord, I am told.
Not to make any sense, let our senior come.
Thank you.
Not to made.
Obliged.
Obliged, Your Lordship.
And they have done their law, I was just inquiring, she has done it from OP Jindal. I have done it from Hazra. I said OP Jindal has to make submission. And she says that she has done corporate law. So she has to make submission.
She is the best person.
Yes, she is.
Because the corporate law.
Corporate law. And this is SEBI.
That's why.
He prayed before me. I also had this stage, at some stage in my life. My senior used to, force me to do matters. I remember, Justice Dotto, when I was deviling in his chambers, those days were days, where you can't be unprepared.
When I was appearing, where is your chart? Without chart, I will not allow you to argue.
That was each and every brief. I had to be with that in those days.
And when
absolutely. That is how we got ourselves prepared. And we did not pursue law from those big law schools. In fact, I'll tell your lordship, just on a different note, Hazra Law College has today, the Department of Law has today produced the best. Whoever is wherever, they are more or less from Calcutta University. And they are all doing marvelously well. Your lordship will keep it, Monday. That is the that is the most important. 3. No, second. Anytime next week, subject to the business of the court permitting, anytime next week, same 27. Great.
I am appearing on behalf of the respondent, my lord. The question was raised with regard to the territorial jurisdiction, my lord.
Yes.
My lord, this is an application. My lord, writ petition is basically the writ petitioner is purporting to challenge the so-called notice, my lord.
Yes.
So-called notice issued by the bank, my lord,
for
declaration of fraud, which is at page 77 of the writ
declaration of fraud was why the maintainability?
My lord, maintainability means, my lord, this notice was issued from Chandigarh.
Jurisdiction,
territorial jurisdiction. And everything happened, all this account is concerned is in Chandigarh. Everything is in
Who has
Chandigarh.
issued the so-called notice?
My lord, kindly sees the averment that he has made, my lord. My lord, averment for approaching before this honorable court, my lord, at page 26, page 26, page 26, paragraph 56, page 26, paragraph 56. Petitioner is an individual person, my lord, not a company even. He said, why the communication dated 22nd October 2024 issued by the respondent number 2 in his alleged capacity as assistant general manager of the respondent number 1, purporting to be a notice, to be a notice under Master Circular dated 15 July 2024, which was received by the petitioner at his address at Kolkata, and said respondent has threatened to take measures against the petitioner who is a resident of Kolkata. As such, this honorable court has jurisdiction to entertain the present application.
Yes.
So the contention of the petitioner is that he is a resident of Kolkata, first of all, and he has received this notice sitting in Kolkata. So this honorable court may have jurisdiction. That is the contention of the petitioner. My lord, there are certain decisions where it says, even if it is a company having its operations in Calcutta, registered address in Calcutta, received the notice in Calcutta, still the jurisdiction, this honorable court will not have the jurisdiction because the consideration is the part cause of action. Under Article 226, my lord, after the amendment of Article 226, my lord, 2, my lord, the part cause of action means, which has been defined, my lord, integral part cause of action. Whether this receiving of a notice sitting in Calcutta by a person who is ordinarily a resident of Calcutta constitutes or is an integral part of cause of action or not, that is for my lord to adjudicate at this in this matter, my lord. My lord, in this regard, my lord, may I be permitted, perhaps this my lord, to place this decision, my lord. This is, I have not found this reported. That's why I am placing this in this way, my lord. Or rather, I have not found the reported copy with me. My lord, this is the Everest Coal Company Private Limited, the division bench of this honorable court, my lord, in the year 1985. No, my lord, long ago it was placed for my, but if my lord says that I do not need, my lord, I will not. I will not. But since this matter is being argued after a long time, my lord. So may I just indicate the paragraphs which I once more, my lord.
Yes.
My lord, paragraph 10. The fact that the appellant company has its registered office at Calcutta by itself cannot give rise to any part cause of action within the jurisdiction of this court in respect of the aforesaid two orders made by the governor of Bihar. Observation made by the division bench in the case of Union of India.
After this order, several changes has come.
Yes, my lord. I've tried to come up with also.
Then 13, I have taken
my lord.
Then
11 and 13, my lord. I'm not placing, my lord.
Yes.
My lord is well aware of this Suvaika's decision, but paragraph 7 and 8 of Suvaika's properties. In this, my lord knows that it was regarding a land acquisition. The land in question was in Rajasthan. Notice was issued from Rajasthan, but what happened, my lord? The land is Rajasthan. The notice was issued from Rajasthan, and here, my lord, the person or the company is in Calcutta. So, my lord, here also the bank or the account is being maintained in Chandigarh.
Manatosh, AC come karo.
Account was here also the account is being maintained in Chandigarh. Notice was issued from Chandigarh, and all the banking transaction concerning this, my lord, took place in Chandigarh.
Yes.
My lord, I'm just harping on paragraph 7 and 8, my lord. Upon these facts, we are satisfied that the cause of action neither wholly nor in part arose within the territorial limits of the Calcutta High Court, and therefore the learned single judge had no jurisdiction to issue a rule nisi on the petition filed by the respondent in Article 226 of the Constitution, or to make the ad interim ex-parte prohibitory order restraining the appellants from taking any steps to take possession of the land acquired. Under subsection 5 of section 52 of the Act, the appellants were entitled to require the respondents to surrender or deliver possession of the lands acquired forthwith, and upon their failure to do so, take immediate step to secure the possession under subsection 6 thereof. The expression cause of action is tersely defined in Muller's Code of Civil Procedure. In other words, the cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to give them, the plaintiff, a right to relief against the defendant. The mere service of notice under section 52 of the Act on the respondents at their registered office at 18B Brabant Road, Calcutta, that is within the territorial limits of the state of West Bengal, could not give rise to a cause of action within the territory unless the service of such notice was an integral part of the cause of action. The entire cause of action culminating in the acquisition of the land under section 52(1) of the Act arose within the state of Rajasthan, that is within the territorial jurisdiction of Rajasthan High Court at Jaipur bench. The answer to the question whether service of notice is an integral part of the cause of action within the meaning of Article 226(2) of the Constitution must depend upon the nature of the impugned order giving rise to a cause of action. The notification dated February 8, 1984, issued by the state government under section 52(1) of the Act became effective the moment it was published in the official gazette. As therefore the notified land became vested in the state government, free from all encumbrances. It was not necessary for the respondent to plead the service of notice on them by the special officer, Town Planning Department, Jaipur, under section 52 for the grant of an appropriate writ, direction or order under Article 226 of the Constitution for quashing the notification issued by the state government under section 52(1) of the Act. If the respondents felt aggrieved by the acquisition of their lands situated at Jaipur and wanted to challenge the validity of the notification issued by the state government of Rajasthan under section 52(1) of the Act by a petition under Article 226, the remedy of the respondent for the grant of such relief had to be sought by filing such a petition before Rajasthan High Court Jaipur bench, where the cause of action wholly or in part arose. So here also the person is claiming that I am a resident of Calcutta, not even a company having its registered office, and I have received the notice in Calcutta, but all actions pertaining to this investigation regarding fraud, regarding the accounting question, everything, all exercises have taken place in Jaipur. So no integral part of action, cause of action has arose in Calcutta, my lord.
Okay.
My lord.
Next,
my lord. My lord, Utpal Kumar Bose, yes, my lord. উৎপল কুমার বসু সম্রাট বাবু আছে যেখানে সেখানে উৎপল কুমার বসু সাইটেশন বলতে হবে আমাকে my lord, paragraph 5678, my lord. Here it was a rejection of a tender and the communication was made to a person, an individual person sitting in Calcutta.
Yes. Yes.
My lord, I'm just reading just paragraph 8, my lord. I'm not troubling, my lord, with the entire things, my lord. Though I am also placing reliance on paragraph 5, 6, 7, but I'm only reading the penultimate paragraph 8, my lord. From the facts pleaded in the writ petition is clear that NICO invoked the jurisdiction of Calcutta High Court on the plea that a part cause of action had arisen within its territorial jurisdiction. According to NICO, it became aware of the contract proposed to be given by ONGC on the reading of the advertisement which appeared in the Times of India at Calcutta. In response thereto, it submitted its bid or tender from its Calcutta office and revised the rates subsequently. When it learned that it was considered ineligible, it sent representations including fax messages to EIL, ONGC, etc. at New Delhi demanding justice. As such, as stated earlier, the steering committee finally rejected the offer of NICO and awarded the contract to SIMCO at New Delhi on such and such date. Therefore, broadly speaking, NICO claims that a part of the cause of action arose within the jurisdiction of Calcutta High Court because it became aware of the advertisement in Calcutta. It submitted its bid or tender from Calcutta and made representation demanding justice from Calcutta on learning about the rejection of its offer. The advertisement itself mentioned that the tender should be submitted to EIL at New Delhi, that those would be scrutinized at New Delhi, and that a final decision whether or not to award the contract to the tenderer would be taken at New Delhi. Of course, the execution of the contract work was to be carried out at Hazira in Gujarat. Therefore, merely because it read the advertisement at Calcutta and submitted the offer from Calcutta and made representation from Calcutta would not, in our opinion, constitute facts forming an integral part of the cause of action. So also the mere fact that it sent fax messages from Calcutta and received a reply thereto at Calcutta would not constitute an integral part of the cause of action. Besides, the fax message of such and such date cannot be constituted as conveying rejection of the offer as that fact occurred on such and such date. We are therefore of the opinion that even if the averment of the writ petitions are taken as true, it cannot be said that the part of the cause of action arose within the jurisdiction of the Calcutta High Court.
No matter further.
My lord.
Yes, yes, continue. You continue. Other matter release.
No, my lord, if I am traveling, my lord, I should stop.
No, other matter release. Only 10 minutes is.
Oh, my lord.
And that is another unending list of judgments.
No, my lord, I am trying just on behalf of my client.
Better to show the last one, which considers all.
My lord, I have one. Minus just paragraph 37 and 36. I'm just placing it in a very short manner. Alchemist. Alchemist.
Alchemist.
Alchemist. Paragraph 37 and 38, madam.
$37?
37 and 38, madam.
Yes.
From the aforesaid discussion and keeping in view the ratio laid down in catena of decisions of this court, it is clear that for the purpose of deciding whether the facts averred by the appellant petitioner would or would not constitute a part of cause of action, one has to consider whether such fact constitute a material, essential, or integral part of the cause of action. It is no doubt that even if a small fraction of the cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain a suit or petition. Nevertheless, it must be a part cause of action, nothing less than that. My lord, in this case, my lord has also, my lord has the occasion to go through this judgment on several occasions, my lord, rather. My lord is well aware of this, of the facts of this case, my lord. Here the case is, my lord, the company was registered in Sikkim. Secretariat of the second respondent, the state is situated at Gangtok in Sikkim. Offers were called from various parties at Gangtok. All offers were scrutinized and decision to accept the offer of the appellant was taken by the first respondent at Gangtok. The state government's decision not to approve the proposal of the appellant bank was taken at Gangtok. The meeting of the board of directors of the first respondent bank was conveyed at Gangtok and a resolution was passed to withdraw the letter at Gangtok. The communication was dispatched by the first respondent bank to the company at Gangtok. So many things happened in the place of in Gangtok, my lord. And thereafter, my lord, at paragraph 38, the Honorable Supreme Court in this judgment held that in the present case, the facts have been pleaded by the appellant company in our judgment cannot be said to be essential or integral or material so as to constitute a part of cause of action within the meaning of Article 226(2). So all these things, although happened in Gangtok, in the state of Gangtok, in the state of Sikkim, in Gangtok, Still, it was not considered to be the part cause of action or integral part of cause of action. Well, lastly, my lord, I need to point out one judgment, my lord, of passed by this honorable court single bench, my lord. The copinator comes good. In this matter, I also had the occasion to appear, my lord. It a citation 2021 SCC online, Calcutta. 3004. My lord, in this judgment, my lord, what happened? An order was passed by the recovery officer DRT at Karnataka. But the company, it is in a, this company, Comsco Industries, had its office in Calcutta. They received that order of recovery officer of the DRT Karnataka in Calcutta. And their shares were supposed to be recovered. Their shares of the company registered in Calcutta were supposed to be recovered by the DRT officer of Karnataka. This, our honorable court, my lord, after considering all the judgments, Kusum ignored, Nawal Kishore, which even I did not place before you, my lord, Hong Kong Shanghai case, and even Swaika Properties, Ombika Industries, Alchemist, all these judgments, upon considering all these judgments, my lord, this honorable single judge was pleased to hold that even after this, although the shares were there of the company were there here, still.
Which paragraph?
My lord, at the ultimate, my lord, paragraph 25, my lord. Hence, no part of the cause of action of the petitioner, much less any integral part, has arisen within the jurisdiction of Calcutta High Court.
That's all. Any further?
No, my lord.
Yes.
First on the why my cause of action is here, the integral part. I have shown you the first day.
Nawal Kishore.
Notice. Page 77. Notice has been addressed to me as guarantor. Number one. That is within jurisdiction. AGST Post Road, Kolkata. Now, my relationship as a guarantor arises on account of the security interest which I have created in the property.
Yes.
Which I have offered as mortgage, equitable mortgage.
Yes.
That is a property at Kolkata.
Yes.
Now, if your lordship comes to page 32. Page 31, the document starts with sanction of credit facilities. And we come to page 32, the collateral security. Here number 2. Part of the table collateral.
Yes.
But she will get the address of the details of the security. In Shakespeare Shirley Police Station. Type of charge, equitable mortgage, owned by Aditya Balasari. So, my status,
yes,
in connection with this credit facility,
yes,
arises on account of the mortgage of this immovable property situated in Kolkata. It is not merely by fact of receipt of the notice, that is one cause of action, definitely.
Yes.
But the effect of this action, which is impugned, will be on this property which I have given as security, which is situated within the jurisdiction. This is an essential part of the cause. And I had already cited Kusum ingots. I don't know.
You have cited Nawal Kishore.
Yes,
Kusum ingot, you are not Nawal.
I'll keep Kusum ingots also. Because Kusum ingots has considered that ONGC, Swaika, everything is considered there. And this Kusum ingots and Nawal Kishore both say a small part of the cause of action,
integral part of the cause of
action will constitute jurisdiction. Your lordship will kindly come to paragraph 10. After discussing the cause of action from paragraph 6.
Yes.
Paragraph 10 says, even if a small fraction of the cause of action accrues within the jurisdiction of the court will have jurisdiction in the matter.
Yes.
Then, my lord, all these, my learned friends' judgments are all here, my lord, paragraph 12, 13, 14. I am not saying that just because this notice has been served, I am getting a cause of action. My cause of action is fact that you are practically invoking the guarantee
Of the
and the mortgage of the immovable property.
Of the Calcutta property.
Of the Calcutta property. That constitutes the essential part of the cause of action. This is my learned friend, and kindly also note paragraph 18 and 21 of Kusum Gots also. Facts pleaded in the writ petition must have a nexus on the basis whereof a prayer can be granted.
Yes.
Those facts which have nothing to do with the cannot be said to have given cause of action. So therefore, this is the fact which I have pleaded, this challenge to the notice. Then, my lord, your lordship, kindly come to my learned friend's first judgment, that division bench judgment of the Calcutta High Court, the Everest one. This also, in my most respectful submission, will be helping my case. 1985.
Yes.
Kindly see, my lord, first the first paragraph. The challenge was with Bihar legislation. Bihar Trade Article Order 84, Bihar Essential Commodities, 1977, as no application was ultra-violence. This was played for. The lordship will straight away come to paragraph 5 of the judgment. Towards the middle of the paragraph, in page 4. Kindly take page 4. I'm not getting the entirety of it. Towards the middle, accordingly, when the act eight lines from the top.
Page is missing.
No, my lord, my lord.
I think, my lord, it will not tally with your lordship.
Yeah.
Okay, this is page number 443.
Now in
443, my lord.
Yes.
I have a different SCC copy. That is why.
443.
Yes, yes.
Page 443.
Yes.
443. The question whether or not.
My lord, in the middle, accordingly, my lord will find accordingly.
Yes. Accordingly, when the impugned act. Don't you have got it?
No.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 17th line from the top, my lord.
Yes, accordingly.
Accordingly, when the impugned act of the respondent takes effect within the territorial jurisdiction of a particular high court, it may entertain the writ petition of the person aggrieved, notwithstanding the respondents and officers or residents outside territorial jurisdiction. An order has been made by an authority or person at a place beyond territorial limits of a particular high court, but the same is given effect to against petitioner within the high court jurisdiction. This is what is happening here. In such a cause, at least a part of the cause of action arises where the impugned order is implemented. Thus, when an order becomes effective, only when it is communicated or served, the service of the order or receipt of a notice thereof would form part of cause of action for filing of writ petition by the person aggrieved thereby. So, well, this is what I am pleading here. This order,
yes,
if stands,
yes,
scrutiny of this court will have direct effect not only on me but on my property situate here. So therefore, it is an essential and integral part of the cause of action. This is what my lord it is said here. Then the lordship will further come to paragraph 7. Why in this case the court said the court does not have jurisdiction? I will take paragraph 7. Subject matters of challenge. Subject matter of challenge is petition filed by the appellant at Bihar Trade Articles Act 77, such and such, made with prior concurrence of the central government by the governor of Bihar in exercise of power conferred by Section 5. Then next slide. Except the coal controller, officers of all other respondents situated outside territorial jurisdiction. Appellant claims to be a private limited company and owners of a set of beehive hard ovens situated in the district of Dhanbad, Bihar. They were also in Bihar. In paragraph 82, so if the effect of this order is felt, it will be felt outside. In paragraph 82, appellants award that by reason of the fact set out therein a part of cause of action and reason within the territorial jurisdiction of court, firstly it has been claimed that coal is the central subject, and not all material times all matters concerning coal, war, and steel are being looked after by central government through coal controller at one council house. It has been averred that effect of Essential Commodities Act in relation to coal used to be given by central government from the office of coal board. In our view, appellant has not even prima facie established that any part of its alleged cause of action in respect to the aforesaid orders made by the governor of Bihar had arisen within the limits of this court. Assuming there is substance in the claim of the appellant that there was repugnancy between coal control order and the aforesaid orders made by government, same as arisen entirely in the state of Bihar where the two orders have been enforced and given effect. Here, but this is given effect here.
Yes.
Secondly, appellant neither pleaded in this petition nor placed before us any provision of law under which the coal controller could direct the state government of Bihar or the central government not to enforce the provisions of the two orders. Therefore, by making coal controller one of the respondents, appellants cannot claim that any part of its alleged cause of action in respect of two orders had arisen within the territory. Completely different. Appellant was in Bihar, effect of coal control order was felt outside. But therefore, my humble submission is that the order which they are seeking to enforce is going to have an effect on my property, which has been offered as security. And I have been roped in by the notice only in my status as a guarantor. And that guarantee arises out of the
Property of Calcutta.
So, this is my submission on the cause of action aspect, and I only say, if your lordship sees now this notice at page 77, it is clearly in violation of the master circular. Why I say this, kindly see clause. I have annexed the master circular also. Kindly come to the page 79, it's page 82. 2.1.1.1. This is the first clause. Relating to show cause notice.
Yes.
Issuance of detailed show cause notice to persons, entities, and its promoters, whole-time and executive directors against whom allegation of fraud is being examined. I am neither of them. Number one. Number two is show cause notice shall provide complete details of transactions, actions, events, cases, which declaration and reporting of fraud is being contemplated under this direction. Now, if your lordship comes back to the notice at page 77, kindly see in the table what is the reason that none of these relate to the guarantor. Fraud angle, cheating and forgery and diversion of funds, factors of fraud angle. Hypothecated stock created out of the bank's finance was disposed of by the borrower. Direct allegation against the borrower without liquidating the bank's dues. There is diversion of funds as borrower did not credit the sale proceeds. So there has to be a direct charge against the guarantor. Alienation of assets financed by the bank without prior approval of the bank. Borrowers have intentionally merged the collateral with other properties. But where is the allegation against the guarantor? Not a single piece of allegation is there against the guarantor. And this has been addressed to me as a guarantor.
Yes.
I am not roped in here as a director
Yes.
of the borrower company.
Yes.
kindly see, so my first point is 2.1.1.1. Show cause notice can be issued to persons, entities, promoters, directors. I am neither of them. Still, if you have to make out a case against the guarantors, there must be some allegation against the guarantor particularly.
Yes.
So far as the security which I have offered. Now, kindly see who are these persons under 2.1.1.
To the persons, 6.
Yes, 6 is one of your lordship will go to get
Including third-party service providers and the
professionals such as architects, valuers, chartered accountants, advocates. So under no stretch, 2.11.1 covers a guarantor.
Including third-party service provider, professionals such as architects, valuer, chartered accountants, and advocate. Yes.
Well, this is my principal case on this show cause notice. On the face of it, it is in violation of 2.1.1. And my lord, I have some other point also. My lord, the lordship will kindly see clause 3, page 84. There cannot be a direct fraud declaration without the account being marked as a red flagged account.
Correct.
So, my lord, there is no determination of this account as a red flagged account.
So this so-called notice is issued only against you.
Yes, this
Not
is only against me.
Not to the principal borrower.
Principal borrower, at least this.
Or director of the company.
No, my instruction is that it has been issued against all the.
This
separate.
This should also.
That is my instruction.
Still say that. I am my challenge is restricted to this show cause notice issued to the guarantor only. Well, this is my submission insofar as this show cause notice is concerned. And also, kindly see who has issued this at page 78. Assistant General Manager Fraud Monitoring Cell.
Yes.
This is in violation of 2.1.3.1, page 83. Bank shall constitute a committee of the board to be known as Special Committee of the Board for Monitoring and Follow-up with a minimum of 3 members of the board consisting of whole-time director, minimum of 2 independent directors, non-executive directors. Committee shall be headed by one of the independent directors, non-executive directors.
Yes.
So therefore, there has to be a committee.
Yes.
And the committee's composition is this. He has no authority to issue this. He does not say that by the order of the board or by the order of the committee. So on the face of it, this is absolutely unauthorized and illegal and contrary to the rules. It has to be done by that board.
So whether he was the convener?
But that I have been told, my lord. That I have been told. He has been authorized to issue. He has been authorized to issue.
Because in your if you have constituted a committee.
There is a committee. There is a committee. And he has been authorized to issue.
You have to mention with regard to is a convener. If it is a convener, then only.
Yes, my lord.
That has to be evident from this notice by the order of the board as a delegatee. This cannot be improved now.
No, what they are doing, but I find in other cases the same point was raised, and I called the report. Then it was found that yes, in the meeting also, in the constitution of the board also, he will be convener, and all the correspondence will be made by this.
I am also not arguing one matter on that.
That I have been told, my lord.
They have filed their minutes of the board. From there, it can be shown that this person is one of the members of the board and he has been authorized.
Yes, I have been also told that he has been authorized.
This is not that.
That has to see.
He is an assistant general manager. He has no place in that board. Because the board can only comprise of the whole-time directors. 3 members. 1 whole-time director and 2 independent directors or non-executive directors.
Correct. No, he cannot be. That's why, because whether he is the convener, they are appointing. And in one case, what they have done, a common man been appointed for the review committee.
Exactly, and for the second committee also. Fraud identification.
Identification. Ka.
At least his designation does not show that he can be a part of this committee.
Yes.
My lord, may I be permitted to give a short reply, my lord? A short reply.
They have to file an affidavit
Yes.
to justify this. Without
Because with regard to the your point of jurisdiction, okay, there is no problem. But with regard to this, you have to come with the document or you have to submit the report.
Yes.
My lord, my lord, whatever my lord directs, my lord.
No, with regard to the jurisdiction, it's okay.
Yes, my lord.
That is the point of law, and this can be
My
taken into consideration. But with regard to this, the point which he has raised, first of all, is the guarantor. But the allegation, kindly the last fraud angle and factor. How the fraud angle, the guarantor will come into that.
But if my lord is directing me to give a reply to this on the merit point, my lord, then I have to use an affidavit if subject to my lord's sanction. But if my lord is deciding that this court is honorable court is not having jurisdiction, my lord.
Okay. Hearing with regard to the point of maintainability is concluded. Chamber mein
my lord, may I make just a short reply with regard to
reply?
maintainability, my lord? I have to try.
What further reply? What reply?
Short reply, my lord. My learned friend was pointing out that he is a guarantor and the property is in Calcutta. My lord, this is not a recovery proceeding for recovering the asset under Securitization Act.
Yes.
It is a declaration of fraud of the account.
Okay.
That is my short reply, my lord. Regarding jurisdiction, my lord.
Because my notice has been issued as a guarantor.
Okay. Chamber mein.
But Lordship will
chamber mein bhej do manch kaaj.
kindly grant a short stay till the maintainability issue is decided by others.
No, I am deciding.